Good morning, everybody. Happy Wednesday. It's already Wednesday, Bev says in her bleary state. It is indeed. It's already Wednesday, and it's the tail end of the defense case, guys. We could be done today. Not entirely impossible that would happen. We'll be finishing with Crash Daddy II, Andrew Rentschler, the biomechanical engineer, concluding his testimony today. But guys, it's really, we got to talk about yesterday. It's yesterday we got to talk about because it was really delicious. And sometimes you have to savor. You just, you have like a really good meal. You got to slow down, take small bites, really savor that. You got all these layers, all this complexity in the dish, and need to take a minute to really appreciate, make sure you catch all the little fine subtleties, the way that the citrus interacts with the butter and all that kind of thing. We got to talk about yesterday. Oh, yeah. This defense has done such a brilliant setup of the end game here. I mean, talk about being able to jump on the gifts that you're given. Because this has worked out extremely well for the defense, that for whatever reason, Dr. Welcher decided to go out on this limb of asserting that there's no x-rays of John's arm or hands. No x-rays. So he could have fractures. And I remember when he testified to that at the time, because I'm pretty sure my comment was, oh, so maybe he did have a boxer's fracture. See those bruises on his hand, on John's hand? Classic boxer's fracture. You hit something a little bit wrong. Your wrist isn't quite at the right angle. You mess up all these soft bones in there. You get bruising, you get swelling. It's a lay thing. You don't actually have to have a break to call it a boxer's fracture. It's just a very, very common, like, soft tissue type of injury. But you mentioned like this really looks like a boxer's fracture on his hand, and then you're screaming, he has no fracture in his hand, no fracture. So that's what jumped out at me when he said that. No x-rays of the hand or arm. So possible there are breaks in there. And so it could be a boxer's fracture. But no, guys, that wasn't even what was good about it, because of course, as we saw yesterday through Dr. Laposata, there are in fact x-rays. They took x-rays in the autopsy. So there have been x-rays of John's right arm and hand for 2.5 years. 3.5 years. Oh my God. Off on my math again. The x-rays have always been there. And so we're at a little bit of a tipping point now. We have a choice that is facing Mr. Hank Brennan, because of course the entire universe of us watching the Karen Reed trial are now quite curious. How did Dr. Welcher not know that there are x-rays? How did he not know that there are x-rays? See, here's the thing. It's virtually certain that the x-rays themselves are not the only way that you would know that there were x-rays taken of John. It's very unlikely that the only mention of the x-rays in the entire ME file is the x-rays themselves. The x-rays are going to be, discussed as the results, the fact that they were taken. They're going to be mentioned. It's going to be referenced as like there's, an exhibit to the autopsy, maybe an autopsy report. It's going to be mentioned. They aren't just a thing that's there in the file with no other reference to it. So me looking at this situation, you know, looks at a lot of medical files. Had a summer internship once at a PI firm. Looked through a lot of medical files. Very hard for me to believe that somebody reviewed the ME's file. Maybe you didn't see the x-ray, but still had no idea the x-rays were taken. Just like missed when it would have been referenced. It would have been referenced, guys. I feel pretty confident about that. Would have been mentioned. So how did you miss that? So it puts us in a little bit of a sticky situation with Dr. Welcher, doesn't it? Because there isn't really a good explanation for why did you come to this jury and insist definitively no x-rays? Not just I didn't see any, wasn't aware of any, don't think they did. Very definitively there were no x-rays. When in fact here they are. It shows you're not very careful with your testimony, shows you're not very careful with your review, shows you're not very thorough in your analysis, shows that you aren't particularly troubled by missing information that's pretty critical to the issue of whether John O'Keefe was hit in the arm by an SUV like you posit. Pretty directly on point to be able to evaluate the feasibility of this mechanism that has come from Dr. Welcher. And we saw Dr. Welcher testify. We saw his demeanor and attitude and so forth. And I got to tell you, my impression of Dr. Welcher isn't going to be the kind of guy to admit fault. Admit he did something wrong. Admit, yeah, I was sloppy. My bad, made a mistake. The mea culpa, I don't think is going to flow from this man's lips. He's got way too much ego, way too much pomposity. And now it's on record. He's a professional expert witness. Okay, literally all you do, go into court. Your livelihood is your credibility. And now you're on record in a transcript in a court in Massachusetts in a murder trial, being like, oh, my bad, I overlooked this central evidence. That seems really unlikely to me. I don't know that paying him $400,000 enough is enough to get this guy to fall on his sword. Too much ego there. So then what do we have left? They weren't given to me. Brennan, throw it back on Brennan. Throw it back on him. It's a beautiful thing to see. I've been saying when we've been talking about Brennan, you know, you got to be careful who you choose as your allies. You want an attack dog, but you got to be careful because as soon as the leash is off, you're just taking it on faith that you're not going to be a target. As soon as it's convenient for somebody like that, you'll be a target. That's the problem with it's a problem with dealing with dishonest, shady, unethical types of people. Can't trust them. So I don't think these guys can trust each other. I don't think they can trust each other. Especially tricky for Hank Brennan because we've got the implicit Napue problem. Napue versus Illinois, guys. It keeps coming up. It's been a common theme, I guess. Last few cases we've been watching. Napue versus Illinois, U.S. Supreme Court case from back in 1959. Prosecutors have a duty to correct false testimony. They may not rely on false testimony to obtain a conviction. May not rely on false testimony. And it's very clear. Doesn't matter if you elicited it. Doesn't matter if, it came up on cross. You're a witness testifying falsely and you know it, you have a duty to correct it. And this arises out of general ethical rules. Pretty much every ethical rule that I know of in every state in the country has a requirement that because it's part of your duty of candor to the tribunal, that if you're responsible for something that causes a false statement to be elicited, you have a duty to correct that. You don't get to just go ahead and roll with it, let it work to your advantage. But when you're talking about a prosecutor prosecuting a case, it also has a due process element to it. And that's what Napue is based on. It's a due process violation to knowingly rely on false evidence. You have a duty to correct it. So we have 3 prosecutors sitting up at that table: Hank, Lally, McLaughlin. 2 of those, Lally, McLaughlin, they went all the way through the first trial. They've been part of this case for quite a long time. We to believe they also didn't know that there are in fact x-rays of the hand and arm. Hank, we know Hank. Hank would throw it off. Hank would brush it off. I just didn't know. Hank has no shame, so Hank doesn't mind the my bad, I was incompetent defense. What's Lally and McLaughlin's excuse? What's their excuse for not knowing, not correcting that information? When you get up on redirect with your witness, that's your job. Mr. Welcher, you testified on cross-examination that there are no x-rays of John O'Keefe's right hand and arm. Are you sure about that? Would you like to refresh your recollection? It's your duty to correct it. So that's looming regardless. That's looming regardless. But now take it to the next level. We've got Dr. Welcher back on the stand in rebuttal. Dr. Welcher is being confronted with, are you dishonest or are you incompetent? The Hobson's choice. But he sees there's a third path. There's an escape route. It's neither. I was lied to. I wasn't given them. They weren't provided to me. You can always just shift blame to the prosecutor. Now we got another level to the problem, don't we? Because now it makes it look a lot more deliberate. Did he get any x-rays? Did he not see any references in the autopsy report to x-rays? Didn't bother to correct that. Now it starts to look like this was a knowing effort to pull the wool over the jury's eyes about the scope and extent of John O'Keefe's injuries, mislead them in a way that would, at least conceptually, theoretically, make it more possible that Welcher's onto something here with his blue paint theory, and maybe John was just hitting the arm. If we can't rule out breaks, fractures, serious bruises, major injuries to the arm, because there weren't any x-rays, then maybe it's, maybe it happened. I suspect we're going to hear from Dr. Rentschler that it's still pretty unlikely. We saw that dummy move. Guys, we saw that dummy move. 24 miles an hour, hitting the arm. I don't know how your arm is staying on your body, but I'm waiting to hear. I mean, there's a reason, I think, why Dr. Russell in particular talked about with motor vehicle collisions. You see, like, we had that photo, the photo of the unrelated one in Los Angeles. What do you have? Lots of serious avulsions and stuff like that. Degloving. Severe things, rip tear, severe injury, massive force. So the defense has set this up so brilliantly because this dilemma is now evident. Welcher messed up. Welcher messed up big time. Big time with the x-rays. And a little bit risky, perhaps. A little bit risky to gamble on that guy coming in and being like, I was wrong, my bad. And then you're going to get confronted with all the implications of there being no bruising, no x-rays, etc. Amount of force, ARCCA calculated, had to be involved with these types of forces necessary to break the taillight. Oh, they've set it up for a really damaging cross of Dr. Welcher. And I don't know if we trust him to fall on his sword or just turn around and throw it back on the prosecutor. So Hank's in a real pickle, isn't he? Because path of least resistance here, possibly the easy way out of this dilemma. Let's just not call him. We just won't call him. See, if you don't call him, then we don't highlight the issue with the x-rays. Defense kind of slid it in yesterday. So defense got the foundation in for this to happen yesterday. The x-rays are in, but Welcher's not fresh in the jury's mind. They're not necessarily sitting there thinking. They might be thinking, didn't he say there's no x-ray? Maybe he said he didn't see, Hasn't been brought front and center into their attention to consider the implications of what it means. Okay, all of that has gone unsaid at this point. It's just it's a little thundercloud on the horizon, but it's not actually, pouring down rain on our heads as we stand here. So you can maybe avoid the explosion, the thunderclaps. You just don't put him on the stand. It's a lot easier that way. It's brilliant in game. It really is. You have kneecapped the rebuttal case. Dr. Welcher was his real Hail Mary. His real Hail Mary. Because it was once again the gifts he's gotten from this judge and his ability to piss them away. It really is remarkable. Absolute gift he got from this judge that you get to have a free rebuttal case, no answer by the defense. He's going to have the last word. You're going to be able to ambush them. It's going to be completely by surprise because you don't even have to tell them what he's going to say till the very, very last minute. Now you just went and put yourself in a position where the smart thing might be to have to not use that at all. Just give up that advantage. It really is incredible. It's remarkable. It's so self-inflicted. That's the beauty of it. The defense hasn't had to do this. They've just had to wait for the opportunity and recognize it and seize it. That's all they had to do. They didn't make him testify. There's no x-rays. They didn't make Hank not correct it. But they sure did see the opportunity and they sure have jumped on it. And boy, is it smart. And boy, is it well done. Well crafted. I saw a lot of questions on the internet last night Why didn't they cross-examine Judge Welcher about it when he said it back when he was on the stand? This is why. This is why. This is why you don't cross-examine Judge Welcher about it when he's on the stand. Why would you do that when you can just go ahead and booby trap his rebuttal? Make it so Hank sees. Hank sees real clearly. You can put this guy back on the stand. There's going to be a blow up if you do that, but you're entitled to do that. Is that how you want to end your case? Go right ahead. Go right ahead. We'd be happy to blast him on whether he's dishonest or incompetent. Which one? And you know, if he finds his way out of the trap by pointing the finger at you and your sleazy, unethical, dishonest prosecution of this case, you, by the way, the entire team, all of you sitting there at that table, all of you who knew there were x-rays and just went ahead and let that lie go to the jury. Hey, if he sees his way out of the trap and points a finger at you, that's not going to break my heart. I'll be perfectly fine with the jury hearing that as the last thing before they go into their deliberations. Honestly, I'd be just fine with that. So very good position they put themselves in to come to a strong conclusion at the end of this case. It's very well done, and it's just, you know, it's fun to see all the little pieces come together. Imagine Welcher gets on the stand. Okay, he gets on the stand for his rebuttal. He's confronted with the x-rays. Here they are. Here they are. You said there weren't any. Weren't very careful with your language, were you? Weren't very concerned about the accuracy of your representations to the jury, were you? Put the pressure on. Imagine Welcher's reason for all this. Prosecution didn't give me any x-rays. I wasn't aware of them because they didn't give them to me. Think maybe we have just, you know, cemented the Napue problem here. There's no way this entire prosecution team didn't know about the x-rays. Just no way. It's a it's a dispositive issue in the case. Whether John was hit by a car, autopsy is central to that. They're all going to know. They're all going to know. So if you deliberately didn't provide it to your expert, it's because you want false information to be presented to the jury. You don't put him on the stand and he doesn't say that, he doesn't say anything like that, then you still have possible little bit of wiggle room. We just didn't know it was oversight. It was real busy, you know. Tougher, I think, to make that case. You got the witness saying, yeah, the prosecution provided me all this stuff, the autopsy report, the this, the that. But just not that x-ray of the right arm. Just not that. Defense is going to be able to go through everything that he was provided. If those x-rays are mentioned in the autopsy report, defense is going to be able to go through and highlight, well, didn't it occur to you when you read the autopsy report and it referenced an exhibit consisting of x-rays of John's extremities, and you didn't have those, that maybe you should follow up on that? Maybe you should acquire those? You just missed all that too? No, it's going to start to look more deliberate. It's going to start to look more deliberate. Karma's a funny thing, isn't it? It's a funny thing. The bill always comes due, guys. It always comes due. You choose how you want to conduct your trial. You choose the integrity you want to bring to your undertaking. The bill is always going to come due. Maybe not today, maybe not tomorrow, maybe not in this lifetime. If we're going to be real Buddhist about it. But every choice has consequences. Every choice has consequences. That's really all karma means. I think people often think karma is this idea of like I think it's like it's a Judeo-Christian kind of attitude about karma. That like there's a plan, there's a design, there's a greater justice. Everything is going to tend in that direction. It's not what karma means. Not what karma means. It just means every action has a consequence. Every action going back to the beginning of time has had a consequence. You and I living here today, we are the product of all of the consequences that preceded us that we have no control over. It's our conditioned existence. We didn't choose to be born as humans. We didn't choose to be born in this time. We didn't choose to be born in this country to these parents. All these things that are not our choice. But we have a lot of choices downstream from us. The things that we do, the things that we set in motion, that affects the great web of causality all throughout the universe. You know, it's a single butterfly flapping its wings kind of idea. So, you know, you come to a task and you cheat, you lie. The bill always comes due. Not always in the form you think it might be. Not always the way you expect it. But there's going to be a consequence. And it's just fun to see it so obvious and direct and immediate like this. This was your choice, Hank. You chose to take on this shady prosecution that seemingly nobody in the DA's office in Norfolk County wanted to take on. You had to be the hand-selected prosecutor by Michael Morrissey. Let's not forget that, by the way. Let's not forget that. Whenever we get irritated with Hank, outraged by Hank, wondering why on earth is Hank allowed to misrepresent stuff, degrade people, etc. Why on earth is this okay? Let's not forget, he's handpicked by Michael Morrissey to do this, and there's a reason for that. There is a reason for that. Because they want this. At the end of the day, you acquiesce in your chosen representative behaving like this. It's because you want that. Why do they want it? Well, some of it's the attrition. Talked about that a lot. It's the overall strategy in this case. Just make it painful. Make it painful and maybe they'll quit. If we come in and abuse all of their witnesses, maybe they won't call so many witnesses. We come in and we cheat and we lie. Maybe they will see the wisdom of just taking that plea deal instead. And if not, yeah, we'll make her suffer. We'll just make it painful. Get our pound of flesh. He chose this guy for a reason. And the reason why Hank is still running the case is because that's how they want it. So it is nice to see things come full circle, see some karma kind of taking effect in the final days of this case. There is a little bit of activity going on in the courtroom, but it looks like they are not quite ready to go yet. So just the camera is moving and there's words coming up. So I'm kind of watching out of the corner of my eye. What's going on? What's going on? Don't want to miss it. So Andrew Rentschler, continuing today. Oh, looks like they are getting started now.
Good morning, jurors. I have to ask you those same three questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their heads. Thank you. Can we have Dr. Rentschler again, please?
Let's see the text-free PowerPoint.
Yes, thank you.
Good morning.
Good morning, Your Honor.
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Rentschler, good morning.
Good morning.
Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
Thank you. That'll be KK for ID.
Let me know whenever, pardon me, let me know whenever you're ready, Dr. Rentschler.
Sure, you want me to bring up the PowerPoint? Or?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here. There we go.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer, ask the question again.
Sure. Did you seek to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Sustained.
Ultimately, were you in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
Yes.
So I'm going to see you both at sidebar for just a minute, please.
We got to have a series of objections and sidebars because you see the defense is rebutting the Commonwealth's case, you see, and we can't have that. We can't have that Dr. Welcher's analysis, very critical to a Commonwealth victory here. So we can't have holes poked in the analysis. No idea what the problem is here. Did you evaluate what their expert did? The guy that's equivalent to you on the other side, did you evaluate what he did? Not only perfectly okay, expected even, it is the norm. It is what he's here for. Why do you think we paid him 50 grand, Bev? So that he can respond to Aperture, so that he can look at Aperture and point out what a crock of shit all that is. That's the purpose. We all know it. And there's nothing improper about that. But we got to start off the morning because we know, we all know how bad yesterday went for the Commonwealth. Could be even worse with Dr. Rentschler. I just expect he's going to have some real good information here. So, got to start off with the serial objections, the interference to make it difficult. Let's micromanage exactly how Mr. Jackson gets to conduct his cross-examination. It's fine, Hank. You can delay the inevitable, but his evidence is going to come out. You can try to delay it with all these objections and sidebars. We can start wasting the jury's time within the first, 2-3 minutes of the witness's testimony. Already at sidebar. Look at that. Already at sidebar. It's going to come in. You can run, but you can't hide. Anybody watching the jury this morning? I have to go see if, let's check on Sue. See if Sue O'Connell is there in the courtroom. Interested to see if she is watching the jurors today. First sidebar of the day, 2 jurors look at their notes. The rest just sit. They just sit. Get comfortable, jurors. It's going to be, what did this say? I wonder if they already know that. They already figured that out. We've got a critical defense witness here, jurors, so expect a lot of interference.
Yes. Did you undertake to review analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those 3 separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So the next question, and I'm going to strike that. Next question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that.
Oh, the fix is in.
Let me demonstrate.
All those other doubts.
There are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank you.
Correct. This is injury reconstruction biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
And describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely, yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method. Okay, and the scientific method, which you know, it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation. You have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle, we ran into it, to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case? So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis, and that's what's important. You know, I have 3 kids. I have a 9-year-old who's actually.
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real world example that you might want to use to explain some or part of the scientific method?
There is, yeah, and I would like to explain an example of what's important with that. So I was going to say I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right.
Happy birthday, Kai.
We're going to stop this. Another example.
Go ahead.
What?
Minus all the personal.
I'm sorry, Your Honor.
Minus all the personal.
Details matter, okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen. Okay, as an expert, I can't come in and just say.
Sustained. It needs to be more question and answer.
Why do details matter?
Because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Objection.
Next question.
What if you don't have all the details and facts?
If you don't have details, if you haven't performed a proper analysis, then you can't come to a conclusion that something happened.
Ooh,
You
Good.
can't depend just on your
Set up
experience. You
there.
have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you best get details to come to a conclusion in a case?
You need research, you need peer-reviewed articles, you need evidence, you perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
Actually, it's the end of that.
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Objection.
Sustained.
What do you see? By the way, where are these from, these two slides?
These two slides are from the PowerPoint presentation that Aperture provided.
All right, so you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis? The fact that the individual, the surrogate, as you use the name,
did the cosplay, is that scientific?
The same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter. So we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is, yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis and the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report. And the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX570.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
Strike.
So I strike the end of that.
Would you describe
Don't say
the
he's
injuries
wrong,
on
guys.
Mr. O'Keefe's arm as lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force. They're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step in the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken. Are
autopsy records, hospital records, medical records acceptable sources for biomechanists to rely on in determining or coming to opinions and conclusions?
They are. They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file, is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor.
X-rays.
I'll get the right nomenclature in just a second. This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or age records?
It was a series of the X-rays. Yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see? Have you looked at X-rays before?
I have, yes.
Have you interpreted x-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at x-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at x-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
So would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore x-rays, if they existed?
No, if x-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this x-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
You see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie, what are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you review this in furtherance of your analysis?
And his
I
shoulder.
did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint either.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint.
Very important to look at the x-rays if they exist. You need to look at them.
Can we go to the next slide, please?
Maybe. Let me see if I can start backing on it here. Okay, there we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's go to Sidebar for a minute and Mr. Jackson, bring your PowerPoint, please.
Interjecting, bring your PowerPoint. Oh, it's normal and expected and commonplace for biomechanical engineers to look at the clothing and the damage to the clothing and to see if they correspond to the injuries, to the object the foundation is in. But Bev has been really, I think she's going to change her mind that, you know, she already told him yesterday, be prepared to take out all these slides with the clothes, depending on the foundation. So we already knew she has it in her mind, no foundation for this guy to talk about clothes. Gone and now and established this is exactly what biomechanical engineers do. Is that going to change Bev's mind? No, of course not. She's still up there unhappy with foundation to such an extent that even though we didn't even get an objection from Mr. Brennan, here we go. She's going to do it of her own accord. Call them up to Sidebar. Let's see if she's going to let these photos be shown at all. Make him cut him out. She's going to make him cut him out during the middle of his testimony on the stand. Really, nothing would surprise us at this point, would it? Yeah. Has he even sewed a prom dress? I'm finding he lacks sufficient qualifications. It's funny too, because literally we're just looking at photos that are, if not already in evidence, very easily could be in evidence, you know? Like, is there an issue here? Because we've seen the one close-up photo with the measurement of the damage to the sweatshirt, but I guess maybe we didn't see a second one. Maybe the second one is not in evidence. Is that what she's getting all up in arms about? It's from the same report. It's also from Hartnett. Guess what? If Hartnett's going to come back on rebuttal, like we expect, then we can just get her in anyway. Anyway, the application of Rule 703, the basis for the expert's opinion, is so all over the place by now anyway. Well, while we have a moment, let's take this opportunity to wish a very happy 10th birthday to Kai. Happy birthday, Kai. Sorry, this nasty old twat on the stand isn't gonna let your dad give you a shout out. Not your fault, not his fault either. Nothing wrong with that. That's enough. Use a different example. Not all the personal details. Right in front of the jury. Right in front of the jury. The one guy can literally make himself a test dummy. Can personalize all of this to that extent. But heaven forbid we use an example involving his now 10-year-old son, as if kid examples aren't routine in court anyway. Talk about that. It's like one of the most common examples that people will use to talk about credibility. How do you decide what happened? Dealing with your kids. Your kids come and tattle, and one of them tells you this, and the other one says, no, that's not it. How do you sort out? Because it's common experience. Everybody deals with that with their kids. Super common example with circumstantial evidence. You come into the kitchen and the cookie jar the lid is off, and there's crumbs on the counter, and there's cookies missing from the jar, and then you look at your child, and your child has a ring of cookie crumbs around their mouth and cookie crumbs on their hands, and the child looks at you with their big, sweet, innocent eyes and says, "I don't know what happened to the cookies, Mommy." Are you able, you didn't see it with your own eyes, but are you able to conclude that the child ate the cookies? This type of stuff is like routine. This is, first trial kind of examples that get used, because a lot of people have kids, so they can relate to that. They can relate to those types of experiences and that type of problem solving. So it just makes it it's good fuel for examples, because so many people can relate to it. Oh, Tom, he must have missed yesterday when we did our massive review of I don't know, what did we get through? We got through like 5 or 6 pages in detail. We got all the way into page 65 of the 252 page 1983 outline produced by the staff attorneys of the Ninth Circuit Court of Appeals. Wonderful resource if you want to know everything about how you can and cannot sue the government for violating your rights, and government officials for violating your rights. Nice 1 paragraph statute that Congress adopted, saying any person acting under color of law, state or federal law, or the Constitution, deprives you of your rights, is liable for damages. But you see, we have to have 252 pages of explanations for why that doesn't actually say what it explicitly says in its language, and why, notwithstanding that statute, you actually can't sue Judge Bev civilly, because she has judicial immunity. Absolute judicial immunity. She can't be sued. She's appointed for life. Very limited mechanisms to remove her from court. What does that mean? It means she has no skin in the game, as far as no personal interest in seeing that there's a fair trial conducted in her courtroom. She will suffer no consequence if it doesn't happen. She can act with impunity. Almost like it's by design. Almost like it's by design. Well, with the length of this sidebar becoming increasingly likely, I would say that she's making Rentschler modify his PowerPoint presentation on the fly. We don't get to talk about clothes. Not an expert in clothes. If it was a straightforward, I had concerns about the foundation. Mr. Jackson says, I established the foundation. This is something they do all the time. Would have been a short sidebar. Not very short though, huh? Nope. Love for one another, 1999. Her appointment cannot be withdrawn. Once the governor appoints her, she is appointed for life. Now, there is some limited mechanism for the governor to be able to remove her. It's not clear if it requires, it's not clear to me just from looking at the way it's written, whether, because you don't always know these things, right? You have a clear 1 paragraph statute that says very clearly something, but then you have 250 pages of case law that tell you why it doesn't actually say that. That's the practice of law for you guys. So the process says the governor can remove her and I forget the exact language that it used, but he's got to bring it up to the legislature. It's not really clear if the legislature has to buy in or not. Is that going to happen? You think? You think? To our Norfolk County Woman of the Year? Of course, that's not going to happen. That's not the system. That's not the game. It's not the game. They're going to double down on Bev and what a good job she did. Wait and see. Wait and see. They're going to double down. Well, see what some of you guys are thinking. Might as well. Might as well take the time. I saw Rob was in the chat. Jump to Rob, Law and Lumber. This is a scenario where counsel who feels like they're losing starts taking more risks. I predict shenanigans and more mistrial motions. Be ready for Hank Brennan to come out swinging hard these last days. This is a good prediction, Rob. Very good prediction. We've reached the nothing to lose at this point. If he's going to lose the trial anyway, whether he's fair or not fair, then you might as well do everything you can to try to swing the odds back over into your favor. So I think that's it makes a lot of sense as a prediction. I do question this a little bit though, and the main reason why I question this is because we didn't see it yesterday with Laposata. We really didn't see him come out swinging yesterday with Laposata. Like he gave up. It really is kind of like he gave up. Didn't really land anything with his impeachment, you know. She's probably answered that question about the station fire 100 times. She's ready for that. She's ready for that. It's probably not even the first time she's called it bullshit in court. And Hank just really didn't have a lot of fire. Didn't have a lot of energy to him, did he? Almost like he gave up. He's not even the one running this interference this morning. Oh, I mean, he's thrown up some. But over here fiddling with the PowerPoint, which I'm quite sure we're doing while the jury is sitting there waiting. That didn't even come from Hank. I feel like he's maybe in the giving up. And I'll tell you, if he's feeling snookered, okay, he's feeling snookered. There's nowhere he can shoot his ball, where he can get a clean hit. Then that'll make a person feel pretty.
Jurors, I apologize that took so long, but it was necessary to do rather than sending you out. So, sure. Thank you. Tori, can you give me a couple of these?
How long was that sidebar?
1 moment.
Okay. 20 minutes, 15.
Dr. Rentschler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this? That's
Number 12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please?
It's going to be okay.
Did you also look at and consider these
All that for nothing.
photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yep. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
So that means things had to move.
Can you scroll
through the
to
hole,
slide
right? Like the
22
teeth?
quickly, please? What is this?
This is a slide, again, from Aperture, from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the taillight, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from Aperture?
These are all from Aperture. I did not put any of those on there.
You see the small, it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the Aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to.
Can we count the ways?
First of all, the abrasions, the numbers don't correspond to the number of holes or.
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yeah, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Objection.
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time,
With the 9 holes in the right sleeve?
with the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please.
Sure.
What is this?
These are the top two and bottom right slide are from the Aperture PowerPoint.
How did you interpret the the 2 photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured tail light, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keefe's upper arm, and there's a red arrow pointing to part of the fractured tail light.
Can we go to the next slide, please? What are we looking at
Like
in
to
this slide?
see the slide, kind of guy.
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
That's very important,
Why?
because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same, but that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher, as it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear tail light of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the taillight, and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm
Nice.
fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in, as demonstrated by the paint
Perfect.
test, with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle's actually traveling.
When
Yep,
you say
we remember
horizontal,
that.
do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please? This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the
Yep.
arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. O'Keefe's arm if in fact it contacted the taillight and if in fact it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please?
Can't
This
have him
is on the
saying
left, the same video
Welcher
that we've
is
seen
wrong.
several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down. And so as you can see, as it starts out, and you'll see
got his
the vehicle
left
starts to
leg
slowly
in front
back.
of the car.
So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car
Good catch.
from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the
Look at his
surrogate?
terrible
What did you note?
posture.
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please?
Oh my gosh, he does. It's so visible.
Did you see what you were describing in that video?
I did, and I can slow it down. So you can see even at this
Yes.
point, as the
Slow
car
down even
approaches, it
more.
would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide, please. What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Can opine on science, the expert. Can opine
Thank you.
on the propriety of
Can we
the
move to the next slide,
Commonwealth
please?
method.
This is slide 30. And let's go to 31.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate area, of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of your arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The
For those
basis is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33. I may have just a moment, Your Honor.
Yes.
Did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt with 9 holes in it?
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint test, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint test in which the arm was leaned into the car?
In which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies, they use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often. So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar to if your hand was hit by the back of the arm was hit by the back of the car and propelled forward. That's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm, and here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we go to the next slide, please? And what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, its acceleration here is almost 300 Gs.
What does that mean just to us?
So 300 Gs. If you look at weight, if you say the weight of the arm is 10 pounds, 300 Gs means there's 3,000 pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to tear ligaments?
Absolutely, yes.
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulnar radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide, please? What is this showing?
So this is a slow-mo of the overhead from the real time. There was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm
Look at
as
that.
it's being contacted
Right
in
there.
those milliseconds where it's being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24-mile-an-hour impact?
G-force, let me see
Could
exactly.
you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
Do you need to refer to something
Yes, my report.
with the court's permission?
Yes.
Thank you.
I mean, look at it. You can see it.
So
Of
at
course.
24 miles an hour for the arm, the acceleration is 302 Gs. And for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back.
Let's watch the elbow like be all
Right there.
mangled.
What's happening physically to the arm, to the right arm at the point of impact?
So there is a force on the hand, on the forearm where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm is actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence, based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
Correct, nothing.
Can we go forward another frame? And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay, it's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics, yes.
Is there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the vehicle?
It is not. I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. We thought there was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, it shatters, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Let's go to the next slide, please. What is this slide showing?
So this is just frames taken from that actual video showing the interaction from the top left, then you go down to the bottom left, and then the top right and the bottom right. Just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation of his right arm?
Mm-hmm.
That's correct, yes.
Thank you. Next slide, please.
Again,
And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hoodie?
There is no defect in that right sleeve of the dummy. No,
Was
sir.
the dummy's sleeve examined following this test? Closely examined up close rather than just a photograph?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please. What are we seeing here?
This shows some of the photographs taken of the sleeve and the arm to show that there's no defects whatsoever, and it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there, but you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3-arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by Aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the lift gate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
Yeah, at this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hands, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide, please. What are we looking at in this slide, these two photos?
This was the final test that was conducted and using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it important, Dr. Rentschler, why was it important to do a center of mass test?
Because if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest? You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
From a physics standpoint, is it reasonable to believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. O'Keefe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense. If the claim is that the fractured taillight's the only thing.
So I'm sustaining the objection to that. I'm going to strike that portion, Mr. Jackson.
Let's go to the next slide. What are we looking at in this video?
So here's the video showing that strike at 29 miles an hour with the center of mass impact to the dummy.
What's the import of this particular test? Why was this important, and what did you conclude following this impact test?
That doesn't make sense as
There's
objectionable.
a couple of reasons. It shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. You would have substantially more damage than what we had in this case. And secondly, which I believe is just as important, it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustained is twofold.
Sure. What about the body? What directionality would you expect on a center mass hit?
The body's going to move in the direction that the vehicle is moving. That main direction, that main force moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And I could have just a moment, Your Honor.
Sure.
On what do you base your opinion that you just told the jurors?
That looking at the kinematics of the arm, it's inconsistent with the evidence we have with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius and the forearm, if your hand or arm was struck by the rear of the SUV.
Can we move to slide 48, please? What are we looking at in this slide?
This was a study where they used an impactor and they contacted the dorsal or top part of cadaver hands. And they looked at the force that was exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the Aperture paint test. You can see the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Mm-hmm.
Next slide, please. What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. O'Keefe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Next slide, please. What are we looking at in this slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly the paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that. So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please. What are we looking at in terms of this slide?
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800 pounds of force.
Did you see any trauma on John O'Keefe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma, there were no fractures, there wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage. There was no bruising, there was no lacerations, there was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit further. We've talked a lot about bone fractures and ligament damage, et cetera. What about bruising? In any of these tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keefe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
Next slide, please.
Not even bruising.
And let's go to the next slide. I think we want to jump to slide 50. What slide are we on? Is that 53?
This is 55.
Let's go to the next slide. There we go. That's what I'm looking for. What are you looking at here?
So this again is from the paint test, and it shows, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. And this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keefe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records medical records of John O'Keefe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keefe was struck center of mass?
None whatsoever. No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the thigh. You're getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keefe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle?
I do.
What is that?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a side swipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it's possible that Mr. O'Keefe was hit on his lower extremities?
I did, yes.
Why did you do that? Why was that important?
Well, because with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during auto-ped impacts. So if he's going to be impacted at that speed, especially center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, as the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Did John O'Keefe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a 0.5 centimeter abrasion on the outside of the right knee.
Could Mr. O'Keefe have suffered a 0.5 centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
I don't believe so. I don't see how those kinematics would work.
Sustained.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately 24 miles an hour.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
There you go, Alan. Just have to use the magic words.
Did Mr. O'Keefe suffer any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
0.5 centimeter abrasion.
That small 0.5 centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no.
Okay. Let's go to the next slide. Taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer or suggest any kind of damage anywhere close to this?
No, the only real damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this. This is the video that was the center mass impact.
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please? What are we looking at in this series of diagrams?
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and show it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts were actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. O'Keefe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there. The last 3 columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all three of the cadaver subjects that were struck at 24 miles an hour with an SUV.
Did Mr. O'Keefe show any signs of any of these injuries?
He did not, no.
Next slide, please. Is this, what are these photographs and diagrams on the right?
So this was taken from the PowerPoint from Aperture. And so it shows that the medical diagram shows the 1.5 centimeter abrasion. And if you look at the picture on the left of the surrogate, you can see, so the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a 0.5 centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of the, or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please? What are these diagrams?
Again, these are just reports, peer-reviewed articles demonstrating that auto pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about, these academic articles, in furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the Aperture report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test?
No.
Or cited?
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go. What does that slide depict?
So this is the opinions that were offered in the Aperture report. And
What's that?
if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner of the Reed Lexus, again, impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. And when you look below that, it basically has the references or the support for that one conclusion.
I'll see you both at sidebar for a minute.
Go ahead and leave this on the screen while you have the sidebar so we can take it all in. The range of occipital bone fracture force has been reported to be between 1150 and 2150, mean of 1634, drop distance is lowest 40. Oh, come on, camera guy. Bunch of stuff about the drop test. So yeah, just corroborating, just confirming that what he actually relied on has nothing to do with physics or science. He's saying, well, the cell phone and there was taillight around the yard. We definitely want to see this torn apart. Somebody will have screenshotted that, I'm sure. It'll be out there. It'll be out there. I don't like this. He can't criticize Rentschler or his method or his conclusions.
Dr. Rentschler, can we move to slide?
Yep, we knew.
Yeah, just a moment, Your Honor.
70, Mr. Jackson.
That's what was, I was just looking at. 7, thank you. I wish my eyes were better.
Can't
Slide
say it's
70.
unscientific.
Oh. Let me restart it here.
Thank you. Okay, what are we looking at in slide? This is slide 70. Yes. What are we looking at in slide 70, Dr. Rentschler?
So this was the one article that was referenced in the Aperture report with respect to automobile pedestrian impacts. And there was a chart from there that was referenced in the PowerPoint that indicates the head's the most commonly injured body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire Aperture report.
Can we move to slide 71? Do you recognize what's depicted in this slide?
I do,
Oh my
yes.
God, look at him
What is depicted here?
hugging.
So this was hybrid. This is the 50th percentile hybrid 3, the same dummy that we utilize. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device, was not a 95th percentile test device?
It was not, no.
Is it 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCCA utilized in all of its testing?
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
So this test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Concrete.
Next slide, please.
Not on frozen grass.
By the
You
way,
didn't test it on
Dr.
frozen
Richard,
grass.
did the last slide include a video?
I
Please tell
believe
me
it did,
ARCCA
yes.
tested
Can we go
on
back?
frozen
Okay,
grass.
I'm not sure it's on this slide, but that's just a screenshot.
I see. I
Yeah.
see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is
You
that
do
correct?
see him
That's
holding
correct.
it
Did you
lovingly.
review a video of what happened next? This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court's permission?
Is the video in evidence?
It's in Dr. Welcher's PowerPoint.
Is it before the jury? Is it in?
It is.
Okay.
Okay. Do you recognize this?
I do, yes.
Is this just look like the same screen, basically the same thing that you just took a screenshot of?
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video and pause it. As that video began to play, did you recognize this as being the same video that you reviewed earlier?
It is, yes, sir.
And did you utilize this in coming to your opinions
I did, yes.
and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission. Can we play the video? Thank you. What did you see? Describe what you saw in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto a concrete surface.
Can we see it one more time, please? I want to ask you one other question. I'm going to ask you to take note, Doctor, of the impact location. Did you see that?
I did, yes.
What kind of surface is that floor, if you can tell?
That, I believe it indicates it's a concrete surface, concrete floor.
Did you notice if the falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint. And if you could pull up slide, I think it's 72.
Let me, every time we do that, I have to restart the PowerPoint. Okay.
Why did you include this video one more time in your PowerPoint here?
Because again, this is the pain test, which indicates the position, at least that Dr. Welcher had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. O'Keefe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustain is to the end of that. I'll strike the end.
Do the kinematics support?
No
what you just
explanation?
suggested?
Objection.
Sustained is to form.
What do the kinematics support?
Objection.
I'm going to see you at sidebar for just a minute. Jurors will be taking our break.
Not the form, so then he makes it as open as possible. And it's still not good enough. We still got to go back to sidebar. Oh, this is so nonsense. So nonsense. So Judd Welcher thoroughly tested what would happen if you lean into the SUV with your elbow and like thrust it forward and roll and then get rotated 270 degrees and then stop and then fall forward straight backwards onto concrete. None of which is what happened in this case. No explanation of the kinematics. Apparently problematic. We don't get to criticize in any way what Dr. Welcher didn't do with his analysis or with his testing. No explanation. Is this dehumanizing? Is this just tearing this expert apart? Personal attacks? Of course not. Criticizing his methods, criticizing his conclusions. Is this appealable stuff? Potentially, yes. Yes, it is. This is classic right to defend. This is the key issue in the case. Okay, whether there was an accident or not, and you're not going to let this guy criticize the methods used by the Commonwealth's expert to claim that there was an accident. We don't get to challenge that at all. Yes, that's a problem with your right to defend, and it goes to a material issue in the case. Pretty good chance that this interference is grounds for error on appeal. Add it to the list, guys. I mean, I don't even know what the list is up to now. What's our list up to? We got the juror being kicked off without cause in the first trial. Without any sort of a hearing and so forth. We got that issue. We got the Betero pro hac vice issue. My God, it's hard to even keep track. It really is hard to even keep track. Not calling Easter, but not sure we got the record, to make a good argument for harmfulness of that error. We've got Dr. Laposata can't say a dog bite for no apparent reason. Animal is okay, but dog is not, for some reason that is not clear at all in the record. And now we don't get to question what Dr. Welcher did. We don't get to critique it. We don't get to evaluate it. We don't get to challenge it. We don't get to test it. Just add it to the list. I mean, this goes to Rob's point at the beginning of the case. We might very well be at the point now where everybody knows, even if they manage to skew this so badly that they get a conviction, it's not going to stick. It's gone too far just to get to this point. So why not just go all in? Why not just go all in? Sit on the scale. Okay, go ahead and put our full center of mass on that scale of justice and get our pound of flesh to get the conviction. We already know it's not going to stand. Seeing, honestly, seems like Bev is a little more enthusiastic about interfering with the defense today than Hank is. Doesn't it seem like Hank is barely bringing up the objections. Bev has had to sua sponte raise a lot of this stuff. Wonder if our jurors are rolling their eyes or anything yet. No comment like that. No comment like that from Sue. Just says different points. They're attentive. They're not attentive.
May I continue?
Yes.
Thank you. Dr. Welcher, based on your review of everything.
Rentschler.
Did I do that again? My goodness. This is Dr. Welcher in the video, correct?
Correct.
All right. I was staring at that. I apologize. Dr. Rentschler, based on your review of the video in which Dr. Welcher is positioned, as well as the drop test that you saw, as well as the discussion of the body placement, where you discussed the body placement, do you have an opinion as to whether or not the testing that you reviewed from Aperture is consistent or inconsistent with John O'Keefe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
Didn't use the magic words. That's what that whole sidebar was about. So ridiculous.
Finally, Dr. Rentschler, do you have an opinion, or did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay, so now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury. Jury break this way.
You are muted.
I was really hoping that Aperture would have done, or that ARCCA would have done a drop test with the dummy on some frozen ground. You know, you could do that. You could get some, couldn't you? You could get some sod. You could put it in like a, I don't know. We have these things that we use in bonsai sometimes for digging up trees and creating the root structure that you want, a spreading root structure. You use this thing called an Anderson flat, and it's like about 18 inches by 18 inches square, maybe 6 inches deep. And yeah, so it's kind of just a, you know, a small little tray. You could fill that with soil, put some grass on top, throw it all into a freezer, you know, get it all good and frozen. You could build a little platform for your dummy to stand on so that frozen grass is at the same level as the dummy's feet, and then drop him back onto that frozen ground in your Anderson flat. Just be interesting to know, wouldn't it? The difference between that contact and the concrete, using the concrete that very specifically is not present anywhere in or near the front yard of 34 Fairview. Well, that sure was a struggle, wasn't it? We knew that it would be. We knew that the final defense witness, who pointing out not just that all of this evidence is inconsistent with the mechanism that the Commonwealth is proposing, but most importantly, explaining why it's inconsistent, so the jury can think about it and evaluate it. Does that make sense? Is that consistent with our common experience? Is that similar to what we already know about how the world works? Compare that type of explanation that we got to the one that we got from Welcher. Well, you just can't know anything. We can't know anything, but there's definitely an accident here, a collision here because of all the non-impact related stuff that they don't get to challenge. Okay, we don't get to challenge and point out. None of that stuff has anything to do with science. None of that is a biomechanical type of opinion. None of it is an accident reconstruction opinion. You haven't actually done those things to reach that conclusion, but we're not allowed to say that. Jury's going to have to come to that conclusion on their own. Is that an error? Yeah, it is. Of course it is. If he gets to get up on the stand and say it, they get to answer it. They get to address that that's what he said. They get to point out what the implications of that are. And they get to, you know, bring it back around to what his expertise is, the reason why he's considered to be helpful to the jury in the first place, his specialized knowledge and expertise, and how none of that bears on the conclusion that he reached. They get to critique that. So her not letting them critique that on the ultimate issue in the case was their car accident. Yeah, that's error. That's, I mean, pretty much as clear a deprivation of the right to a defense as you might expect to see in a case. I mean, just think about this. They get to go on the stand, say that to a reasonable degree of scientific certainty, there was a collision here between Karen and the vehicle. And here's what that's based on. And the defense gets to say nothing about that. Yeah. That's not allowing them to defend. So I do. I'm getting a sense, guys. Bev is more gung ho at this point about impeding the defense than Hank is. Hank is kind of given up here. I mean, he's throwing out some objections to like the leading questions and stuff like that. But Bev is driving a lot of this show. Kind of getting the sense that Hank may not have a lot left, but we'll see. This cross is going to be very, very telling. What's he got? How aggressive is he going to be with it? Where is he going to go? If he goes straight to signal, Rentschler wasn't the guy having the signal chats anyway, was he? I mean, that's the problem with a lot of the, smear attack sort of thing that he had with the ARCCA witnesses. Dr. Wolf was like the main point of contact. Rentschler wasn't. So he's not really affected. If Wolf is texting with Alan Jackson by signal, it doesn't have anything to do with Rentschler. So it's just that's not going to be there. So you're going to have to try to get him on the substance. And what are you going to have? Are you going to have some words, some semantics that we're going to nitpick? That's been pretty classic. Pretty classic Hank Cross. What else you got? I think this is going to be telling. This is going to give us a sense of Hank's energy going into the final moments of the case. Well, where are you guys at? We got Bino hoping for a favorable ruling or two. Hi from, is that Ireland? I can't quite tell, but he got to talk about the clothes, guys. Took a long time, needed like a 15-20 minute sidebar. Initiated by Bev to not have to take all that out of his presentation. You get to actually consider the clothes. Here's why that matters, because yeah, I think you can get dog bite wounds, 36 separate wounds with 9 holes in the sweatshirt. That's because the jaw is interacting with the sweatshirt and the arm, but the sweatshirt and the arm are independent. And so you can have like, okay, so the dog's tooth, I don't have a sweatshirt I can go through. Let me find like I'll just tear out a piece of paper. Here's my dog tooth coming through. Okay, comes through the paper, hits my arm. Okay, hits my arm, and it's chewing me. But see, the tooth can get stuck in the fabric and move around, and then it comes out, and then it makes another one, and then we go and make some, because the sleeve moves independently of the arm. You can get that because you got multiple strikes from the dog. You don't get that from a taillight. You don't have a taillight coming in and like resetting its jaw and trying to get a different grip, and getting snagged in the fabric while it's doing that. Taillight's not going to do that. Taillight is one and done. It has no agency. Why did that have to be like pulling teeth to allow him to point that out? I swear, you need an expert to be able to count the holes and count the abrasions. The jury could be back there in the jury room, and they could do that themselves. Like this is not even the type of thing there should be an issue about the foundation. But we're at the tail end, and it's getting harder and harder to skew the case in the right direction. Jack Spears, will Mr. Jackson be allowed to impeach, ask why Dr. Rentschler lied, said about there not being x-rays, or will Bev deny the defense going into it? Well, that's the $1 million question, isn't it? That's going to be the $1 million question, because at least in theory, right, the redirect, the rebuttal was going to be limited in scope to ARCCA's new testing, and he's going to be able to respond to that. And then theoretically, the cross-examination is limited to what was brought up on rebuttal. So if he doesn't address, weird how ARCCA had the arm and elbow and hand x-rays and you didn't. If he doesn't address that on direct in his rebuttal testimony, technically it's beyond the scope to ask him about that on cross, isn't it? Now, this has been a flexible rule throughout this whole process already, but don't know how flexible we're gonna be, because the whole point is that advantage that we're giving to the Commonwealth by letting this guy get up and, you know, not be rebutted. He gets to say whatever he wants, and the defense doesn't have any ability to call anyone back to challenge it, including himself, right? Defense, at least in theory, doesn't have an opportunity to recall him. Okay, if it's beyond the scope of cross-examination, I'll just call him myself and we'll put him on in direct and we'll deal with it that way. But that's not how this is structurally been set up for them to be able to do it. This is the final little advantage that they got. Judd Welcher gets to go last, and he doesn't get responded to by the defense. So is she going to allow it? Now, of course, a normal judge who has grave concerns about candor to the tribunal is going to allow it, because the jury has heard false information. Jury has heard something untrue. No x-rays. It's now been corrected now that they know that there are in fact x-rays. But it goes to his credibility, doesn't it? Credibility is always central in the case. Why didn't you see those x-rays? Goes to the reliability of what he did. If you were this sloppy, what else were you sloppy about? If you were this uncareful with your description of the evidence in the case, your review of the evidence in the case, the statements that you made to the jury about what the evidence of the case is, what else were you not careful about? Of course it should be. Of course it should be. Is she going to? $1 million question, guys. Why am I thinking she's not? Why am I thinking she's not going to allow them to confront him on this, even though his credibility is still at issue? That hasn't changed. He gets back up on redirect. His credibility is still at issue. The reliability of his methods are still at issue. The accuracy of his communication is still at issue. So it should be allowed, but is she going to? Well, we're going to have to wait and see, aren't we, Jack? Joe Flipperhead, hashtag stop the thrust, please. Hashtag free Karen Reed. Thanks for the coverage and laughs. Thanks for being here with us, Joe. Thanks for being here with us. It's been you know, we've needed a few extra laughs, I think, in the final days here, because they are getting more and more desperate. It's becoming clear. Getting more and more desperate. The case has not taken the turn that perhaps they hoped it would. The defense actually has a defense, and the defense is actually a good defense. Okay, she wasn't hit by a car. Dr. Laposata drove a stake through the vampire heart of that argument yesterday. All this other stuff, all these little distractions that you're bringing up, the car data, the cell, it doesn't matter, because he wasn't hit by a car. And that really is the bottom line, isn't it? I said at the close yesterday, and this has been simmering with me. I mean, all week for sure, but this whole question about the defense strategy, and oh god, they're not calling the Higgins, and they're not calling Brian Albert, and and it makes us very nervous. And I've let this simmer, and I've sat with it, and the more I have, I'm very much leaning towards the side of this is a very smart and very disciplined approach. It really is. It really is. You're keeping it focused on the strongest argument you have for why she's not guilty. And it's not that Brian Albert and Brian Higgins and so forth can't help you make that case, can't help you put it in context, understand why all of this has happened the way that it is and so forth. But it's not zero risk, of course, to do that. You're going to get some downside along with the upside. And at the end of the day, you run the risk that if there's some dispute, some dispute because we put Higgins on the stand and Higgins denies that he has, that he caught feels for Karen and there's dispute about this type of thing. Then you run the risk that that's what the jury gets focused on in deliberation, trying to resolve that instead of focusing on just the very basic point they need to focus on. John wasn't hit by a car. We're done. We're going home. We're going home. So I know how you guys, a lot of you feel nervous. We know too much about the case, right? We know too much about what came out in the first trial, know too much about what came out in the interim. But it really is the bottom line. And smart, disciplined, not an easy thing to do. Guys, they're not blind at all to the public reaction, the public commentary. I think we've seen many indications over time that they pay attention to how things are landing and what the reaction is and the ideas that get generated by the internet. So they know how much public wants them to put Brian Albert, Brian Higgins, so forth on the stand. It's hard to resist that. It's hard. It takes discipline. That's why it's such a smart strategy. But we have needed a few laughs the last couple of days because this has been Sisyphean getting this defense to the jury. Rock keeps, it's not rolling down the hill just because, of course, you got Bev standing up there at the top pushing it. No, you can't critique Welcher. You can't critique his method. No, you can't point out that it's unscientific. So we need a few laughs to be able to get us through it. Casey Cat, what are the odds given this unusual situation Brennan faces sanctions or bar complaints when it's over? Low. It's always low. It's always low. The not correcting the false information about the lack of x-rays. Again, if we just leave it and we don't dig ourselves a deeper hole potentially, then there's always that deniability. I didn't know. I wasn't aware. Lally and McLaughlin. It's not my witness. I don't have the right to get up and correct them. Didn't hear, wasn't paying attention. So it's unlikely. Rarely happens anyway. Rarely happens anyway. Taylor Fulmer, Andrea, love your coverage. You look gorgeous today. Must know where you get your eyeshadow from. Well, thank you for that. It's very kind of you. This is Milani today. I've been using a lot of Milani. Got some new palettes like a couple weekends ago. I don't even remember what they're called. There's one that's like a brown. I wear a lot of neutrals, but then also this one that's kind of a like jewel tones, like almost like purple. Today's version of the purple eyeshadow, not the 80s version, but today's version. I do like a little bit of like a pinky purple sometimes. I think it works with brown eyes. Just works with brown eyes. So that's what I got today. Thank you so much for that nice compliment. You make me feel wonderful, even though it's still an early morning. It's not that early over here anymore, but been a few hours since I put this eyeshadow on. The rural juror. Which judge was it that was always great about always telling the jury that any delays, sidebars, etc., were her fault, and the jury should only blame her? Was it the judge in Daryl Brooks? I don't remember if she did that. Wouldn't surprise me. I didn't watch the Daryl Brooks case that closely. That was a point where I had other stuff going on, so I was only able to watch bits and pieces of that one. That particular judge, I didn't love how she handled him. I really didn't. I know a lot of people did. They're like, oh, she's great. She's the boss of the courtroom. And she certainly had authority. She's better in a lot of ways than what we're seeing in this courtroom in terms of, having actual boundaries and stuff. But I just felt like she engaged with him far too much. You gave him far more attention than you should, because that's reinforcing. It's reinforcing what he's doing. You can tell Daryl Brooks is the kind of guy where, good attention, bad attention, it doesn't matter. Attention is attention. And so when you give him a 5-minute lecture about how bad he's doing, you really are reinforcing what he's doing. That was just my read on it. Dealt with a lot of difficult clients. A lot of difficult personalities. Just not sure that that's the way that I would have handled it, but by and large, he was very difficult. She did maintain order of the courtroom, so that's an accomplishment. That is not an easy thing to be able to pull off. I don't remember if she said anything like this, that it's her fault, only blame her, but that's the appropriate and classy thing to do. One of the things too, I'll talk about this a little bit more when we get to lunch, and I'll do the recap. I'll do a full recap. But she's got this habit, because she's such a micromanager, exactly how things come out and exactly what comes out and the words used and so forth. She's got this habit of, I'll strike that last bit. The jury doesn't have any idea what that last bit is. It's like it's never crossed her mind that we already know you expect the attorneys to be mind readers with your objections, with the objections and your rulings on them. They're supposed to read your mind and know what's going on. And so they should be able to then, adjust accordingly. They're like in on the secret that you can't just make explicit and put on the record. But the jury is not, and nobody would expect the jury to be in on all of that or understand the reasoning or be able to make sense of, since I don't know why I can't hear this, I don't know what's being stricken. That last bit? Is that last bit the period at the end of the sentence? Is it the last 20 minutes of your testimony? I mean, it's probably somewhere in the middle, but exactly what? They don't have any idea. It's like it's never crossed her mind that the jury isn't in on your joke, Bev. Need to be a little bit more explicit with them. A geezer, wouldn't the concept of differential diagnosis also apply to police investigations, Hank? I mean, in a broad sense, surely it would. right? We need to consider all the possibilities. It really should apply to a prosecution for a crime beyond a reasonable doubt, because we really should have considered plausible alternative explanations. It was always my kind of catchphrase talking to a jury. How do you know if there's reasonable doubt? You know there's reasonable doubt because there's a plausible alternative explanation that hasn't been ruled out. And that's exactly the type of thing that differential diagnosis is supposed to do. You've considered all of the plausible alternative explanations for this set of circumstances that's been presented, and we've been able to rule out all of the ones that are inconsistent with Karen Read being guilty of the crimes she's charged with. That's literally what a prosecution is supposed to do, because if you don't do that, you better believe I'm going to be getting up, pointing out the plausible alternative explanations and making the point to the jury. Those are reasonable. That's a reasonable doubt. Yeah, it definitely should apply. At least the same principles should apply to, oh, nice. I just saw it didn't have the screen on, but the captions come up in the courtroom sometimes, even when there's no sound. What's the caption? And how long? And how long? I'm not going to put that on my list. I don't know who that was directed at. Anyway, yeah, A Geezer, good observation here. It's the same principle. It's the same principle. You don't just pick your theory and then cling to it, even if there are other possibilities. You really should be ruling out the ones that are plausible alternatives to yours, because that's what reasonable doubt is. KH, Dr. Welcher and his carefully crafted from the records I've seen BS. He's as slimy as they come, a hack worth the 400K. When do we start the online investigation of Michael Morrissey? Michael Morrissey is paying for all of this. He has hand-selected this prosecutor. He knows perfectly well now that this is not the first time Lally has sat there silently or affirmatively misrepresented what the facts of the situation are. That's been out since before the first trial, right? When Lally was claiming that he was in regular contact with the crime lab over the DNA testing, weekly contact, I think he said, and they just were behind, not getting it done. And then, as it turns out, Ms. Little has like the phone records or something. He hasn't contacted the lab in months. They already know. We already know Lally certified to his diligent search for discoverable evidence. Didn't come up with the sallyport videos. Nevertheless, no issue with any of that. Michael Morrissey knows all this stuff. It's like this for a reason, guys. Almost like it's by design. Almost like this is how they want it to run. Hey, if there's no consequence, for being dishonest and shady and in framing people for crimes they didn't commit, then if it's to your advantage to do that, why not? Why not? B555, Sue OC and others on 10 don't understand significance of dog marks. Do you think defense not explaining can't be MVA if arm marks are from a dog? Well, I mean, Laposata, Dr. Laposata said that explicitly yesterday, didn't she? How can you say these abrasions aren't from the tail light? Well, because they're from an animal, because they're animal bites. She made that pretty clear. So, a lot of this stuff, whether the defense is having success, doesn't necessarily depend on the jury is thinking about this right now. A lot of what you're doing in defense is you're just setting the stage to be able to make your argument. So as long as you have the pieces that you need to make the argument, you can get it in front of the jury. You don't have to have a witness say an argument. And so the argument is Nothing in the Commonwealth's theory accounts for John being bitten by a dog. There's no room in any of it for John to have been bitten by a dog on his arm while he was still alive. It doesn't work. It doesn't work. Where's the dog? When did it happen? How did it happen? And yet, you know, Karen still hit him like what, moments later? He didn't have those bites at the waterfall. So somehow he got bit by a dog between leaving the waterfall and ending up on the grass at 34 Fairview. It's just an argument based on the fact that, you know, these are dog bites is an evidence. And nothing that the Commonwealth has presented, their fact science data, you know, none of their argument for even how this might have happened. None of it accounts for a dog. So you don't have to have a witness say that. We just got extra lucky yesterday that, in fact, Dr. Laposata did, in fact, say exactly that. That's why it's important, because if it was a dog, it wasn't a tail.
All right, Mr. Brennan?
Thank you.
Let's see what kind of energy this cross has.
Dr. Rentschler, facts matter, don't they?
They
Facts
do, yes, sir.
You've said it many, many times. Facts matter. Isn't that correct?
I think it was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the question.
Dr. Rentschler, before this jury, have no idea where the point of impact
There was no
in this
collision,
do you?
that's correct. There's no evidence.
Play exhibit 2, please. When you were giving your estimate 10 to 20 feet, Dr. Rentschler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you look at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rentschler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today before you testify about Dr. Welcher's testimony?
Knew this was coming.
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welcher's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight from Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the Hybrid 3, and I use a Hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the Hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the Hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration. The acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio of force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Objection, Your Honor. Every question.
Maybe we can approach briefly.
Briefly now, briefly when the defense has concerns. Who was that? His employer? Because it sounds like his employer is ARCCA. And it wasn't ARCCA that was telling him. Shouldn't be saying employer. It was actually his client, not his employer. Clarify who that is. Why are they in contact? Do you have some reason why you might defer to them? Do they maybe have some superior knowledge about court processes and orders and rules and what's allowed and what's not and so forth than you do, that you might defer to their superior knowledge on that? So Hank is trying here. He's sure trying here, isn't he? Facts matter. Yes, they do. And we've already explained the dummy a few times. Welcher used the same dummy. Hank, Welcher used the same dummy. You're just impeaching your own expert while you're impeaching this guy. Perfectly normal to do the calculations. What adjustments would Wolf make? He's perplexed. What would he make? He's just trying to get the acceleration, and that's not going to change. And yes, it can change the force equation. But we already heard from Dr. Wolf it's nominal. The reason why it's nominal is because the driving factor in this equation is the is the acceleration, because the acceleration is squared. It's a quadratic equation. So the acceleration affects the result exponentially, whereas the weight, the difference in the weight is is nominal. So I don't know, Hank. I don't know why you think trying to go here for like the third time is gonna get you somewhere. It's just not effective. It's not good information. The sting has already been taken out of dummy. Gonna move on now, Hank?
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Got to be careful because you don't want him to be able to explain what. Why this unusual scenario, Dr. Rentschler? Well, because it was the FBI and there was a protective order, yada, yada.
Voir dire 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific
Objection,
answer.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Go ahead and deny it.
Honestly, I can't remember. It didn't change my opinion.
No, just go ahead and deny it.
I don't see how it
You
would
can
help me
just deny
prepare.
it.
I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter. So let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? Are you denying it?
objection.
Yeah, go ahead and just deny it.
Yeah,
You
I
can.
don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question.
Asked and answered. He's answered it
Receiving that information
multiple times.
from your employer, are you denying it helped you understand what was going on during the trial?
Objection.
I'm going to allow that.
Allow it.
I don't even think that it did. I don't understand it. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yeah, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
Yeah, there was no need to.
That's not the question. Details matter. Was there any attempt?
So the objection sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
And did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No,
What?
because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
You have a conversation about that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
Had a ham sandwich. Did you testify at some
Ham
point
sandwich.
that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change. Remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes. How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCCA. I have no idea how much ARCCA's been paid.
How much has ARCCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case? You have no idea.
It's not my concern. It's not my department, so I don't.
Is that that's a no?
That's the no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with whatever I had.
Did you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
Objection.
I'm going to allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use Signal to have conversations with their clients?
Objection.
I'm going to allow that.
These
that you're aware.
foundations, Bev.
I have no
What's
idea
his
what
basis of
my
knowing?
fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah. You worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like
Habits?
Signal?
Objection.
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf were in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you
Philly?
first began your testimony
Crash
yesterday,
Daddy?
you said that you were
Philly?
restrained
Go
in what you
Phils.
would do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that?
Objection.
Sustained.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Objection.
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
Objection, Your Honor.
So without that preamp, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Since your memory is difficult,
Objection.
Sustained. Okay.
Ask for the admonishment. It's not going to matter at all. When did we first do this? Like 3 weeks ago, and it's made no difference. We already know this is same circus, same monkeys we've been watching. Going on 8 weeks now. It won't matter, but go ahead and ask. You've made your record. Made your record of just the repeated impropriety. I like how he answers the question with a question when it's just ridiculous. It's such a natural thing to do. What adjustments would Dr. Wolf made? What would we have talked? How would it help me prepare? How would it change my testimony? It's it communicates that incredulity of why on earth would we be talking about this at all? Oh, did my radar go off when Hank is asking about, you know, there was a camera crew there and all this stuff? Do I have faith at this point that anything whatsoever Hank is implying was caught on camera is in fact caught on camera? No, I don't. No, I don't. No faith at all. That there's a good faith basis for any of this, that any of these questions are potentially impeachable with camera evidence. I sincerely doubt that. I do very much hope Dr. Rentschler was prepared when he was prepped for the possibility. Hey, this guy is going to lie to you about things that you said before and things that you did and what's in evidence and so forth. So don't necessarily take anything he says at face value.
to remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Killer blow there, Hank. Depends what it is.
You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty.
Correct.
And then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school, correct?
Have you had any peer review articles since 2003?
Probably not, no.
And your peer review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Really hitting hard on that fact, science, and data,
Displacement
aren't you,
between the
Hank?
seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging,
Yes, sir.
and again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Looking at your CV, you can note any area of specialty you'd like, correct?
You can put down whatever you like, I suppose, sure.
Sure. Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact, biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, Doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at the time, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I'd talk to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welcher.
Objection.
Sustained in that.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Objection.
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion, or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray is diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report, or were you doing a certain kind of,
Sustained.
were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what
Objection
you
asked
read
and
in the
answered.
report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
Objection, Your Honor.
Sustained in that form.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In
no.
x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
Sometimes x-rays are the best for looking at bony fractures. MRIs looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
Objection.
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Objection,
Multiple
irrelevant.
pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people,
Objection,
there can be multiple different
relevant.
injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience. Have you
I'm going to allow that.
ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? That ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen in any of your cases a pedestrian hit at a certain speed and have injuries, and another case where you look at where there is a similar type collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cards? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having
Details
experienced
matter,
pedestrian collisions, you
Hank.
can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
Objection.
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
Objection. Speak.
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit
All
with
those
the
things
same
are
car at the
identical.
same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence. If you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases
explained
that
it
when
anyway, didn't
plastic
he?
breaks, it breaks differently.
Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
No, it's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not matter if there's a need, did you?
I did not, no, sir.
Well, it does matter if there's a need, doesn't
You
it?
had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact
Oh, now we get to
the
ask about
actual
what Dr.
collision
Welcher
when
was
he did
trying
that
to
blue
do.
test?
Objection, Your Honor.
I'm going to allow it.
Couldn't ask about it
Well,
on direct.
that was the
Door's
only
open now,
test he
right?
performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Objection.
Sustained. So, Mr. Jackson, Mr. Brent, all right, I'm going to see counsel at sidebar.
Yeah, he's asking for the admonishment in front of the jury. It should have happened a long time ago. Should have happened a long time ago. Yeah, he should have been admonished in front of the jury. So now he gets to ask about what Mr. Welcher was trying to do. That's a door open. Okay, that's a door. We know it's not in Bev's courtroom. In any other courtroom in the country, that's a door open. Now we get to go back and clarify what is his understanding of what Dr. Welcher was trying to do, if any of that was necessary. I mean, you know, he's got the point out. If he wasn't intending to model this, then there's no reason to do it, and there's no support for his conclusion that these things are consistent. So pretty clearly, that's what he intended to do. But I guess according to Hank, if Welcher says, no, that's not it at all, that, you know, we defer to his words and not what he actually did. I guess that would be consistent with the Commonwealth's approach through all of this, wouldn't it? Pay attention to the words. I love this is some high-level witness stuff that Dr. Rentschler is doing with the, if you're claiming something happened, you have to do X, Y, Z. Okay, you're the one making the claim. He's reorienting all of this back towards who is making claims, who is saying what. Who has the burden of proof here? It's the Commonwealth that is making the assertion that there was a motor vehicle collision here. Therefore, You have to show that. You have to have the data. You have to have the studies. If it's not in the studies, then you have to go and do your own testing. You are the one that has to do that if you want to prove your theory. So they didn't do that. No more comments, Mr. Brennan. And within 5 minutes, of course, we have more comments. Is that funny? I would have loved for him to say, yeah, it kind of was actually. It kind of was funny, honestly. This whole thing you're doing is pretty ridiculous, if you want to know. Give him an opening like that. Dr. Rentschler, take it next time. Take the opening. No sound yet. What's going on?
So it will be the lunch and recess, and we'll take an hour.
All right, report, please.
Going straight to lunch, are we? We gonna have a little chit chat? Waiting to see. Just waiting to see if we're gonna have a little chit chat. I guess Sue, it looks like Sue O'Connell. I'll mute the stream. It looks like Sue O'Connell is reporting that one of the jurors looked sick. Says she looked like she was going to faint. And the early lunch is to accommodate that juror. That's Sue's report. It looks like they are just in fact going to lunch. So yeah, no admonishment, but definitely high time to have taken the stand. Admonish him in front of the jury, judge. Make it clear. Make it clear this isn't acceptable. Make it clear this is not normal. It's not allowed. He's violating the rules. They should know that. He's acting with impunity like they don't apply to him. They should know that. All right, well, let's back up for the day. We'll go ahead and do our recap. We got an hour for lunch, so we'll be coming back about 10:45 our time here on the old West Coast. Give us a minute to, we got a very windy day here, so I'm a little nervous about the trees. I don't want to miss it like I did yesterday, but we'll do our recap first. It's been all Dr. Rentschler all day. Got his PowerPoint in first thing, started going through it. Guys, let's just recap, right? Because now we're talking about what Aperture tried to do, tried not to do, his understanding of that. When he says right up front that the purpose of the investigation was to evaluate the evidence and how it pertained to the alleged theory of the case, the accident. Nope, stricken. You don't get to talk about the alleged theory. Okay, what is actually being presented by Aperture, right? Because they're trying to talk out of both sides of their mouth. They're trying to say, no, we're not simulating anything. We're just looking at possibilities, but then you're reaching conclusions based on it. So actually you are relying on it and developing a theory because you are, you're reaching conclusions based on this. If your conclusion was just that it's possible, as he keeps pointing out, it's not enough to satisfy your burden of proof, Commonwealth. So he reviewed Aperture's testing, analyzed what they did, analyzed their testing. So then we walk through the certain steps that you do for a biomechanical analysis. First, you identify the injuries. Second, you identify the kinematics. So what happened to the individual? If the individual was contacted by the Lexus, what force was involved? And then you have to look at each separate event of was he hit? How did he get into the yard? And then how did he fracture his skull? All of these pieces, because these are all parts of the evidence that have been presented. We have to be able to account for all of them. If our explanation is they're the product of a motor vehicle collision, we have to be able to account for each of those individually. And you have to eliminate all of the possibilities. And there's an objection, and that's stricken. That's stricken. If you're going to take a position that something happened, you have to eliminate the other possibilities. Stricken. We have a little lowering of the Commonwealth's burden of proof here. Bev is assisting. In the Commonwealth's case, if there's all other kinds of possibilities here, don't let that get in the way of convicting Karen. Just a little thing called reasonable doubt. Looks an awful lot like we're lessening the Commonwealth's burden of proof by preventing that kind of testimony. All of what he did is based on the scientific method that dates back to the 1620s. Indeed it was. When was Descartes? The Discourse on Method, 1637. So a little bit before Descartes put this all down in his seminal work. Yeah, it's probably circulating in the intelligentsia at the time. 1620s. We've known for a few hundred years how to do this, to do a proper scientific analysis. So if you are looking at, for example, we have superficial abrasions and we have a broken taillight, and we want to determine, are these things related? You would first go and look for studies to see if there is documentation about this type of thing happening. You form hypotheses based on the body of knowledge that already exists out there. And then you do testing if necessary to obtain additional data to reach that conclusion. So if you think you're related, you test to see if you can replicate it. See if you can get the right circumstances and loading to produce that result. But if the results don't add up to the injuries you see, you have to reevaluate your hypothesis. Yes, that's what experts do, he says. Yes. Yes, it is. We had the example going into that involved Kai, the 10-year-old son, Kai, who's having a birthday today. Happy birthday, Kai. Now that gets stricken and admonished in front of the jury. That's enough. Use a different example. Don't use all the personal stuff. That gets admonished in front of the jury. Remember that. Remember that when we're evaluating, should Hank be admonished in front of the jury? Happy birthday, Kai draws an admonishment. Do you think that's funny? Doesn't. I wish he'd have just answered that question. Yeah, actually, Mr. Brennan, I find whatever it is you're doing here extremely ridiculous, and it is kind of funny. Not going to lie about it. I'd love to just go ahead and answer it. He invited you to. So if you don't have enough of the details, then you don't have what you need to do an analysis that lets you reach any kinds of conclusions. If you don't have evidence, you get it from field testing. You try to fill in the gaps to the extent you can through field testing. So then we look at the Aperture video with the angle of the arm at approximately 90 degrees, which is where the arm would be at the tail light at the, if we're at the approximate height of John, standing erect, wearing the sweatshirt. And Looking at the condition of the sweatshirt is an important part of matching up the injuries and what may have happened with respect to the vehicle. That is a perfectly normal part of biomechanical analysis, helps you ID if and where and how there is contact. See if you can find the source. Very common to see that with pedestrian motor vehicle collisions. And it's one of the very first things you do. In fact, it would be very improper to just ignore the condition of the clothing. We turn to the paint transfer test. He's very generous with his characterization of it, isn't he? The paint transfer test. So that was an attempt to show that where the paint contacts the arm is the same place where John had abrasions. And the specific language from his report, from Welcher's report that we've seen, that the location and orientation of the lacerations are consistent with the geometry and orientation of the taillight. And he points out this test has absolutely nothing to do with the forces. It doesn't describe how the arm would move. It doesn't describe how the taillight would flat fracture. It doesn't describe how you'd get a laceration on the arm. By the way, John didn't have lacerations on his arm anyway. He had abrasions. So to say lacerations is incorrect, objection stricken. We don't get to say Welcher made a mistake in his report by calling these things lacerations. Don't get to point out he was wrong. He was wrong. Heaven forbid the jury might think that Dr. Welcher was wrong. We can't have that. Difference, the abrasion is the rubbing or the scraping of the top layer. The laceration is a ripping of a tearing or a tearing of the skin that gets down into the dermis layer. So it's a deeper type of wound. So after we've looked at the injuries, then we look at the physical evidence. So the sweatshirt and the arm, do they match up? So his review of all this is based on all the medical records from the autopsy and from the hospital. Confirmed no fractures from the ME file on the right arm or hand. We look at the x-rays. Very normal to look at them, important in this case, because you need to know not just what injuries do occur, but also what injuries did not occur. So no defects in the hand, no defects in the forearm, no defects to the right humerus on the x-rays. 9 punctures in the sleeve of the hoodie. We had to have a sidebar for this for some reason, counting, requiring special expertise. So he considered the photos of the damage to the sweatshirt and the photos of the abrasions, counted 36 abrasions on the right arm. So to get 36 abrasions, you have to have 36 points of contact with the skin through the sweatshirt, but there's only 9 defects in the sleeve. Never quite tied that together exactly. Why that works with a dog that is striking multiple times over time, but a taillight that has one explosion, you know, one chance. Okay. It doesn't get to reset its bite and then, you know, back up and then go back and strike the arm again. It is completely passive, solely being driven by the physics, the forces of physics, the momentum of the impact. Didn't quite tie that together, that it's not going to work, but he does say ultimately he believes it's inconsistent. Doesn't correspond with a number of holes. There's an objection to that that's sustained. But then he says you can't line up the 36 abrasions with the 9 holes. Objection to that, that's sustained. Then he says if those abrasions came from contact with the taillight, you would have to line them up with 36 points of contact. And we're working with the presumption that he's wearing a hoodie that has only 9 holes. That's as much as he gets to say in this courtroom about why the abrasions are inconsistent, why he has an expert opinion. Can't say. Maybe the problem here is we needed the why. Why does it not work to have the 9 holes and 36 abrasions if we're talking about a taillight? But could you imagine a hypothetical scenario where if it's a dog, oh, she'd never allow that. We definitely know that. The paint transfer was the only test Aperture did of the interaction with the taillight. They didn't take any measurements. That was a good point. I hadn't really thought about that. So we don't actually know where the paint extended to. It's just kind of on his arm and it's been eyeballed. And that's not scientific. The arm is in approximately 90 degrees in all the photos. If you're saying the orientation of the wounds corresponds, then you need the arm to be in the position that you claim it was in when it hit the taillight. The only photos we have of John's arm are straight. So then when you take that photo of John's arm and you rotate the forearm and you put it in 90 degrees, God, what a great visual. We talked this through when this came up. I don't even remember which witness it was now, where they talked about, I think it was Welcher. I think it was Welcher's cross, that the abrasions on the forearm would be perpendicular to the ones on the upper arm. If you bend John's arm, but if the dummy's arm was straight, they should, like John's are, they're all parallel, but you had to bend the dummy's arm. So then we get the visual that shows if you bend John's arm, you don't have parallel wounds. So you don't have the same directionality of the movement to cause the same abrasion. So you'd expect horizontal abrasions, everything going in the same direction along the length of the forearm, same direction, but that's not what you have when you actually go and bend John's arm. Calls into question, well, a lot of stuff, but definitely the position of John's arm. So they don't line up with the kinematics that were shown on the paint test. You would not expect this pattern of injuries. There's no measurements, just approximate. Objection, that's stricken. The jury already heard that we know they just eyeballed it and that that's not scientific. But I don't know. Pointing out that that's what Welcher did is a problem that has to be stricken. Then we got that beautiful side angle view of this paint transfer test where you can actually see where he starts. See, guys, and the reason why he had to do this, you can tell from where his feet are. In order to get his elbow in that position, he has to bring his weight forward. If he were going to start from that position, he would have more of his body behind the car, but he needed to have it be just his arm. So you see him, his foot, even his left foot in this, when he's in the starting position, he's not even all the way behind the car, but his left foot, it's right behind the rear wheel. So if he steps forward another, 8 inches, 6 inches to get his whole arm behind, he's going to be behind the back of the SUV. And that's not going to work with the forces, center of impact. You got to have a glancing blow. So he's standing, away, and he's got his arm and it's not lined up with the back. So when the car starts backing up, he has to push his elbow forward and lean into it and then roll off to get the movement that he's looking for. Can't ask if that's proper scientific testing. The objection to that is sustained. He's not allowed to have an opinion on whether that's a valid test. Not allowed to tell the jury, this isn't science. Understanding a little bit how junk science ends up in the courtroom. You don't even get to point out. When it's junk science. So all the paint test shows us is just how he leaned in. It tells us nothing about what happened, how the abrasions produced. It just shows that if you stand there and lean in like that, you'd get some paint on this general part of your arm. I love it. This is the same criticism we've had of so many of these tests, these demonstrations. Ian Whiffen demonstrated that he can write a program that makes the responds to actions being taken on the Apple phone in a particular way. Doesn't tell us anything about what the Apple phone is doing, but it tells us he can write a program that responds to the Apple phone activity in a certain way. Same critique here. It shows that you can like jerry rig this and do that thing. That's it. So, basis of his opinion, the number of abrasions, the orientation, and the direction, they don't correspond with how the arm would interact with the taillight at that angle. Now he finally gets to bring up the number of abrasions. Like, there's no rhyme or reason. He's got to be baffled. This guy's testified 150 times, all these different courts. He's got to be baffled at this circus that he's finding himself in the middle of. Why would you not be able to say it's not scientific? It's perfectly normal criticism for a scientist to make. So it showed nothing about how the taillight could shatter, how the arm could interact with it to produce those kinds of abrasions. So then we move on to the kinematics analysis and the motion of the arm if it were struck. And there's no research on that for this type of interaction, you know, being struck by a taillight, glancing blow, etc. So you'd have to do the testing. So that's why they use the 50th percentile male hybrid 3 arm, the gold standard for testing, just like they used with the NHL, just like, in fact, Dr. Welcher himself used. What they used to look at forces from airbag testing, that was a good example. You just use the 50th percentile to look at, you know, is the airbag design gonna break the driver's arm? And then you just scale it with the additional mass. So then we got the like restatement of the data to some extent, I guess, from Dr. Wolf's report. It was the hand and arm accelerated in 2 to 4 milliseconds compared to the 250 milliseconds it takes to blink an eye. That really puts things in perspective, doesn't it? It's probably took me longer to snap my fingers than it took for that hand and arm to be accelerated at just 15 miles an hour. At the 17 mile an hour lab test, we got the 300 Gs acceleration to the arm. With a 10-pound arm, that amounts to 3,000 pounds of force at 17 miles an hour on the arm, more than enough to break bone, tear ligaments. Hands are much weaker, doesn't take nearly as much force to fracture them. The 24 mile an hour impact, arm immediately reaches the speed of the vehicle. So in that particular case, the dummy was suspended, and this was the glancing type of hit where the dummy spun around because he wasn't hit center of mass. So Dr. Welcher, man, we're all having that problem today. Dr. Rentschler points out the center of mass. This is basic physics. Center of mass for the men is the belly button. Center of mass for the women is a little bit lower. It's like between the whitest part of your hips. So to force the whole body into movement, you have to be struck at that point of your body. For your entire body to be projected, you have to have the center of mass hit. If it's just hit on the arm, it's like a moment arm. It's just going to swing. It's just going to swivel and move on its pivot. The point of the arm that is contacting the SUV is pushed away from the body. A lot of force pressure on the joints. We saw that deformation. So the G-force here was 302 Gs on the arm, 435 Gs on the hand. That amounts to 3,000 pounds of force to the arm, 800 to 1,600 pounds of force to the hand. Part of the reason why this is so helpful is because, 3,000 pounds, that's a ton and a half. 1.5 tons. 1.5 tons. And so imagine dropping a 1.5 ton thing on your arm. Do you think that's going to break your arm? If the hand is holding a glass like Dr. Welcher's was, then The knuckles are going to be exposed to the contact. That's going to receive some force as well. But there was no indication of any sort of injury like that in John's medical records. So then we did the slow by slow, the frame by frame, slow down watch of that crash dummy test where we see the arm deforming. We see the tail light pieces. The arm is on a swivel, right? The shoulder. So the arm just moves out of the way. It moves to the side, but the tail light just continues to go straight back. So no real circumstance here where John and the tail light would end up in the same position with this type of glancing blow, which is what was hypothesized, or at least put out there as the very suggestive possibility that Dr. Welcher was evaluating. It is not possible for the taillight to be accelerated faster than the arm. There's no study. It was never seen in the testing. No demonstration of that being possible, and basic physics would indicate it's not. So then consider where John O'Keefe was found from the road. He estimated 15 to 20 feet. That's coming up on cross now, but that was his estimate. So John has to move diagonally. Okay. When I think he's saying 15 to 20 feet, he means 15 to 20 feet back, however many feet back, 10 feet back, 5 feet to the side, 5 feet back, 10 feet to the side, something like that. But so because John is moving diagonally. And so if he's hit center of mass diagonally, I mean, this was all just strange. Like the taillight's moving at the speed of the car and John is not. So there wouldn't be a situation there where you would find the taillight fragments on John. No defect in the sleeve at all, but there was lots of damage to the Lexus on this one. The lift gate light was also damaged. The fender was damaged. Then in the 29-mile-an-hour test where they moved the dummy in so they could get that full contact with the elbow and the upper arm, at that point there was extensive damage, 4,000 pounds of force on the forearm, 1,400 to 3,000 pounds of force on the hand, well above the levels where you would get fractures. And with a center of mass impact, now you start looking at propulsion. Now you start looking at where the pedestrian ends up. Depends on how they're contacted by the car. And so if they're going to be propelled in a certain direction, then there has to be contact at the center of mass. And we need to know that to figure out how did they get to that point of rest. How did John get to that point of rest 15 to 20 feet away from the car? And there's no way to correlate him ending up way over there from just an arm impact. If he ended up over there, it's for something that has nothing to do with a hypothesized impact between a glancing blow to his arm from the SUV backing up. Part of what we're dealing with here is that the arm only has the superficial abrasions. If the taillight didn't fracture, because there's not enough force, low force to get abrasions. It's a low force injury, but you also have to have enough to have the taillight fracture. It doesn't make any sense that you wouldn't have, more serious injuries if the taillight fractured, but that's objected to and stricken. Once again, and this is where I start to notice Bev is being, she's not telling the jury what is stricken. Just that bit stricken. What is that bit? What is that bit? They have no idea. They have no idea. And remember, guys, they're going to go back into that deliberation room. Some of them are going to have notes. Some of them are not going to have notes. They're not going to have a transcript. They don't get to go back and read the transcript. And they're going to be instructed, if I've stricken something from the evidence, that means you may not consider it as part of your deliberations. So really counting on them having that in their notes, what they're allowed to consider and what they aren't, if any of that is going to work, unless it's just kind of a big charade, you know, big charade. And we all recognize, can't unring the bell. Okay. They've heard it. They've heard it. But it's just, you know, making it additionally complicated. Even if you are one of the jurors taking notes, and even if you're taking painstaking notes and you're trying to catch all this stuff down, when all she says is that bit is stricken, we don't know what that is. How do you even know how to follow that jury instruction? The court's not giving them the information that they need to be able to follow that. And that is a direct downstream consequence of, we don't even get to state the basis for the objection in open court. Nobody knows what you're talking about. You're trying to do this mind meld thing with the lawyers, but now your instructions are implying that the jurors are in on that process as well, that they're going to understand why you had the objection, why the objection is sustained, and therefore what part should not be considered. But they're not in on it. So putting them in an impossible situation. There's no way they can follow that instruction based on what she's given them. So in the 29 mile an hour, of course, the direct impact, center of mass hit, we had extensive damage. We looked at the post-impact trajectory of the dummy. If it's a center mass hit, straight back behind the vehicle. No force involved that would send it to the side. Taillight goes in the same direction as the vehicle. So in that situation, John and the taillight end up in the same location. So his opinion, none of this is consistent with the arm contacting the taillight cover and breaking it. The kinematics of the arm are inconsistent with the evidence, the abrasions, the sweatshirt, and the expected fractures that would result from that type of contact. Looked into now what the tolerances are. A lot of this coming from the cadaver studies. So 377 pounds on average to break a knuckle. And they got 483 pounds at just 15 miles an hour. And that's just the hand separated from the wrist. The reality is there is a wrist right there that's with the hand as well. So in a real world situation, it would be closer to 900 because it would be more like doubled. So even at 15 miles an hour and even somewhat below that, you would expect to see a broken knuckle from the type of interaction that Welcher demoed in the paint transfer test. Force on the elbow, 10 miles an hour, we got 600 to 1,200 pounds of force acting on the elbow. That is more than enough to fracture an elbow. So if this impact took place, you would not expect the lack of injuries that appear on John. So 1,100 to 1,200 pounds of force on the forearm. We're already there at 10 miles an hour. By 24 miles an hour, we're up as high as 2,800 pounds of force. And yet we don't even have bruising on John's arm, not even bruising. Okay, half a ton. Drop it on John's arm, and he doesn't have a single bruise. So then we've looked at the arm. We've looked at those kinematics. We've tested all that. The next step is to look at, how does John end up in the yard? How does he end up in the yard? So that's the post-impact trajectory of the body. We don't have the indication that John was struck in the center of mass. Why not? Because if he was hit at the center of mass, it's his pelvis, thigh, knee, arm is going to be pushed into the ribs, into his torso. He's going to have very significant loading to the right side of the body. Don't have that type of damage. But if it's just a glancing blow to the arm, it wouldn't propel him off to the side. So the problem here with the Commonwealth theory is you can't have both of these things coexisting. You can't have a glancing blow, and you can't have projection of John's body. Those two things do not coexist in the world of physics that we live in. The lower extremities are most often injured in pedestrian impacts. So if there's a center mass hit, you would expect lower body fractures, but all John has is the 0.5 centimeter abrasion on the outside of his right knee. Also, significant SUV damage from a center of mass impact with the dummy. Remember, this is a lighter dummy than John. Okay, they had to make a big point of that. It's actually conservative then when you're looking at the damage to the body standpoint. There would be more damage with a larger body, more force involved. But Karen's SUV had no damage that was equivalent to what we saw in the dummy test. So Welcher's reliance on that study was not good. There's more recent testing that looks at compares injuries that result from a smaller sedan to an SUV, and that shows that the SUV generally causes more injuries to the lower extremities and to the pelvis. He describes the knee, the ACL, the MCL, fractures to all the bones, extensive damage to the legs. In this particular case, the bumper of Karen's car lines up from the knee to the pelvis on John. So it would not just produce a 0.5 centimeter abrasion. It's a much larger area of contact. The only article that he cited relating to this contact was that one that was from 1979. Then we go to the opinions that are offered in the Aperture report, and we get that screenshot of the report where he concludes the totality of the evidence is consistent with the collision, and he goes through and has the list of things that he relied on: the cell phone, the taillight, et cetera, all of the non-scientific things that have nothing to do with biomechanics. But then we had a sidebar and we came back and we weren't allowed to get into that because critiquing his ultimate conclusion and the basis for it, not going to be allowed in this courtroom. It's not going to be allowed. This is a Sixth Amendment free zone, guys. No defense. No defense. That gets in the way of the whole point of what we're doing here, which is to railroad Karen Reed. What are you even thinking? Thinking you can question his ultimate conclusion and the basis for it. What do you think this is? A fair trial? So the old article is from 1979. It's before an SUV was ever manufactured. First one, today I learned, 1984 Jeep Cherokee, the first modern SUV. The dummy, now we point out, it's the same one as ARCCA, as Welcher used. They both use the same 50 percentile dummy. And Welcher did, in fact, the same thing that Wolf did, which is you use the 50th percentile dummy, then you scale the acceleration to the weight, and that is both normal and expected. He let it fall back passively onto a hard concrete surface. So it simply demos what would happen if a rigid person fell backwards. It does not show if a person has force applied to them and falls backwards. Starting from a still standing position, falls back. And in that scenario, the dummy did not slide across the floor. So then the equivalent to this, the ultimate between this and the paint test, what he has ultimately demonstrated is that if you rotate to the left about 270 degrees and then you stop and then you fall directly backwards on the concrete, that's what would happen, to the head. We had to object and have a sidebar to all of this as well. And all we're allowed to say is that the testing that they did is inconsistent with the kinematics that would result from that scenario. So the evidence is inconsistent with John being struck on the arm into the yard and falling backwards. Took our morning recess and came back for cross. There was a final piece of his analysis that we didn't hear, right? He told us 3 steps. You got to first look at the injuries, then you got to evaluate, you got to look at, or not that, you got to look at each of the events in order, each of them separately. And how did that happen? So we have to look at the arm. How did the arm get the abrasion? How did John end up over there in the yard? And then how did his head end up with the fracture? Those are the 3 pieces. And they didn't really talk on the third. That's where I would have loved to have seen. Do the dummy drop test. Just freeze some grass, freeze some sod. Stick it in that Anderson flat. Freeze it, drop the head on it, tell us what kind of force you get. Would have loved to have seen that. But that piece of the analysis, we didn't get anything real specific with that. It's enough, I think. It's enough to show the arm isn't consistent. The final location isn't consistent. If you take those things out of the equation, then we already know we have to have a different explanation for the skull fractures. So we come out on cross, firing facts matter. Yes, indeed. Well, this was funny, wasn't it? He said, well, I said details matter, but facts matter too. The meta of this response, facts matter. Well, actually, details matter. Details like details versus facts. Those things do matter. Especially if you want to prove something happened in a certain way. I love this. I love this way of phrasing it. Keep the burden of proof on Hank. Hank is opening the door for you now. Hank is the one asking the questions, so you can get it out there. Love that particular way of framing his analysis and just what the scientific process looks like in this kind of context. So we don't know exactly where John came to rest because there's no measurements. We only know approximately, and 10 to 20 feet. He actually said 15 to 20. Hank, details do matter. But it's the total distance of travel that he explains, moving this way and moving that way. Nobody knows the point of contact because there's no evidence of it. I really wanted him to say, yeah, because there's no proof of any contact, just like Dr. Laposata did. Doesn't matter because there was no vehicle collision. That's okay. He just said there's no evidence of any what any point of contact is. So we look at the dash cam video. We see the street. He confirms, yes, 10 to 20 feet. Then we get into, did he talk to anybody about Welcher's testimony? Did you think there might be an issue with the hybrid 50 percentile hybrid 3 dummy because you brought it up in your NHL testing? Nope. Didn't even know it was an issue. Not representative of John's same size. But that's okay because the force on the limb would be less if you use a lighter limb. And so his calculations would be an underrepresentation of the force that would be produced. It's conservative. It would be conservative. Even if they use this dummy and didn't scale, like we've already heard multiple times is the way that it's done. And in fact, saw for ourselves, that's how Welcher did it. Wouldn't you have to make adjustments? Wouldn't Wolf have to make adjustments? What would he have to make? I like his answering the question with the question. It really isn't proper, but Hank's just gonna argue with him, and he doesn't know the answer. Hank doesn't know the answer to the question of what adjustments would Wolf make. And if Hank tries to get out the 26% offset, oh man, that's gonna get torn up. We know he's gonna be even more perplexed by that than Dr. Wolf was. We can't just willy-nilly add and delete 26%. But he acknowledges, yes, it could change the force equation. Dr. Wolf already talked about that. It's nominal because it's quadratic, because the acceleration increases in the acceleration increase the force, the resulting force exponentially. So it has a much more significant effect on the force that's produced than the weight of the object. He did not discuss the case with anyone before his testimony last time. The party that retained them told them certain things. That party was the one that was in contact with the court. I did not discuss anything with them. I did not violate the sequestration order. They were the ones that were in communication. We had no direct communication, so anything he got was from the organization. Doesn't remember if they told him the testimony, but it didn't make any difference to his analysis or conclusions anyway. Changed none of the facts he evaluated. Did it help him prepare? How would it help him prepare? It didn't change anything. So for example, that trace DNA, we didn't know about it. It was very significant to Dr. Welcher. We don't know about it, but it has nothing to do Nothing to do with his opinion. I want to see AJ come back. I would like to see AJ come back to this on redirect and just tie that up. Why not? Because it doesn't matter. This is not a biomechanical consideration. That's not scientific. Has nothing to do with the expertise. Just to make it, tie that link together with what Welcher actually did. Highlight his opinion, not scientific. It's based on stuff that doesn't matter. He did have 2 to 3 phone calls with the defense while he was traveling, possibly one with AJ about his qualifications right before the voir dire. Everything else was logistics. He doesn't need to go and represent himself to be independent because he was independent. So there was no need to talk about it. Then we get into the ride from the airport. You didn't ask to take an Uber. Yeah. And in fact, he points out, if I wanted to portray myself as being independent, I would have done that, wouldn't I? I would have called the Uber if that was what I wanted to do, to portray myself a certain way. Instead, he took the ride. And then after he was done with his testimony, there were going to be others they had to take to the airport. They were having a lunch. So I had a ham sandwich, sat and ate, then literally stood in the corner waiting for the ride. Didn't talk much. Yeah, if something funny was said, he probably did laugh. Like all of this, very dismissive of it because it doesn't matter. I like how he's handling it. Yeah, I probably did laugh if somebody told a joke. Probably did. He did see a camera crew there. Could care less if he was on footage. Maybe he was talking about the case. I don't think they have any way of substantiating any of this. I really don't. I think this is that head fake bluff we're used to seeing from Brennan, where he just makes up whatever he thinks will intimidate this witness or, get him uncertain about what happened. He's feinting receipts, and I don't think he has them. We never got a follow-up, did we? We never got a follow-up. Here you are laughing. Here you are having this conversation. Here it is on video. We never saw any receipts, did we? So I'm very skeptical that there is any of that on video. Remember laughing about the physics doesn't change answer? No, he doesn't. Doesn't really matter. Then he got the ride back to the airport. He has no idea who the company billed for the time that was traveling and testifying. He just enters his time code. He has no idea who pays it. In fact, he used the same code as he used for the original client. He assumed ARCCA has a contract, but that's not what he does. He gets paid regardless. He's just there to do his job. He's a salaried employee. ARCCA getting paid is not his concern, not his department. He doesn't know how much. The texts, logistics, he had like 2 texts about where to get the ride and what time, so he probably deleted them. He did not use Signal. No idea if the other employees use Signal. No idea. Doesn't know Dr. Wolf's habits. Then Klein comes into the picture. They sort of work together in the sense that they all contributed to the project, but he's in Pittsburgh. They're in Philly. Go Phils. Go Phils. I had no idea. That our crash daddy was part of Philly's nation. Just makes us like him more, doesn't it? Doesn't think he was given free rein to do whatever he wanted. There was budgets they could suggest. Has no idea if he suggested crash tests or not. Do you write things down to remember them, Dr. Rentschler? Well, it depends on what it is. What on earth was that? What on earth was that? This was after we're, continuing to have these comments from Hank about the answers. And so we had to have a sidebar about that. Now we go through his CV, number of peer-reviewed publications. He's written a lot of stuff about wheelchairs from back when he was in grad school. Apparently this sounds problematic to Hank. He relied on Wolf's data for the analysis. I didn't fully understand this explanation. The 863 Gs was from the right hand. That's from CFC 1000 hertz. He used a lower number. They're both accurate. It's just how you filter the data. He used a lower number in his calculations. There are some, it sounds like a unit or a conversion or something like that. I'm not sure. I'm not sure exactly what all that meant. But you know, Brennan thinks he's got a discrepancy between the reports. So that's what that's about. He already knows. He's got an explanation for it. He does not diagnose, so he's got no comment on whether there are punctures or other types of injuries. The X-rays, yes, he looked at him, but it was the ME's opinion. You can just look at them to verify. There's no fractures, no displacement of joints. The diagnosis is consistent with the X-ray itself. There's nothing that jumps out. Obviously, if the femur is like broken in two and sticking out through the leg, you'd be able to see that on the X-ray and you'd be able to question the diagnosis. Point out that's not consistent. No MRIs. He doesn't believe any were taken. The X-rays anyway are the best for bony fractures. MRIs are better for soft tissue injuries. And none of that matters because they cut his limbs open. They cut his limbs open to look for hemorrhages and saw none. So soft tissue injuries, not there. They just looked directly. They didn't need an intermediary like an MRI at all. What kind of injury you get from an accident depends on the force and all kinds of variables. Absence of a bruise necessarily mean no impact. You would have to look at all of the evidence. You'd have to look at the force. If there's 4,000 pounds of force applied and there's no bruise, you'd have to question if that collision did in fact occur. Indeed, you would. We got this multiple pedestrian crash example. Ever seen a case where two people were hit by the car and one was injured and one doesn't? He's like, you'd have to look at all the different variables. Where are they hit? They're not going to have identical hits. You'd have to look on the case details. No, I've never seen a case where two people, same size, same weight, hit by the same SUV at the same speed in the same location and evaluated the injuries. He's never done that. Hank is getting at resilience, but I don't think he knows how to ask those questions. He just doesn't know how to ask about resilience. Directionality of glass. What are you talking about? The directionality would depend on the shatter pattern. There would have a whole bunch of different variables. And it would depend on the testing that you do. Once again, if you're claiming it shattered in a certain way, you have to do the testing to show that's what happened. That's right. You're making the claim. You have the burden of proof. So yes, you saw the taillight break, but it did not cause any abrasions. And we had the, is that funny? No more comments, Mr. Brennan. No more comments, Mr. Brennan. I wish you'd say, yeah, it kind of is, honestly, because you're being, what you're doing here is so ridiculous. I do find it a little bit amusing. He didn't count the pieces of tail light. They didn't need to. They were looking at the damage on the sweatshirt and there was none. So then we get into if Welcher's test was intended to model the position of John's arm. And he points out his opinion is based on just this paint test that he performed. That's the only basis that he had for his opinion. So that the taillight orientation and configuration, was consistent. And so if you don't have the test that's apparently intended to model that, you don't have a basis to have an opinion about whether it's the orientation and configuration are consistent. Hank is, continuing to argue. So now Alan is asking for him to be admonished in the presence of the jury. We went to sidebar, didn't happen. Then we had our early lunch. So that's where we're at the conclusion of this morning's session. It's been kind of fun, hasn't it? It's been kind of fun. Guys, that took me longer than I meant. I am going to have to pause real quick now. I do have to check on the trees. Hopefully they don't get started with court, but this is Bev, so probably got an extra 5-10 minutes. We'll see. Hang tight for me. I will be right back. All right, guys, thank you for hanging tight. Looks like I am about 5 minutes late, but so's Bev. So kind of saw that coming. No problem. You know, guys, I just had a thought during my little time away that I wanted to just bring out, because there was actually, oh no, I think they might be coming back into session already. Just remind me if we don't get a chance to get to it. There was a reason. There were lots of reasons why we talked about all that 1983 stuff yesterday. Remember the whole outline, all of the various rules and restrictions and limitations on being able to sue your betters in the government for violating your rights. You know, all the different ways that can't happen. And there were a lot of reasons for talking about that and what some of those standards are, but we didn't actually get to one that is kind of important, because it might put in context a little bit better what we're seeing unfold here. If you're wondering about the scrambling and why are they doubling down and why are they putting their thumb on the scale and so on and so forth. Remember, when we looked through all those rules, we saw it's very, very difficult, even under the best of circumstances, for a claimant to pursue an action against the law enforcement, the prosecutor, the judge. You know, some of them much harder than others, but there's just a lot of variables involved. State person versus local person, all of those types of details. It's difficult, but it's not impossible. But there is a requirement in Section 1983 that is a really, really potentially dispositive one, that if the claimant can't establish it, you don't get to bring a case against anybody no matter what. That's what's called the favorable termination rule. The favorable termination rule. And what that means is that if you are criminally convicted in relation to this conduct that you're complaining about, for you to be able to sue on the basis of this conduct, you have to show the underlying case was terminated in your favor. You have to show it was terminated in your favor to be able to go sue under 1983. That doesn't necessarily mean you have to be acquitted, although that certainly counts. You can get a dismissal. You could potentially get, mistrial and not pursuing it further. But what takes it off the table is a conviction. You get convicted at trial, it's not a favorable termination, therefore you can't sue. So it's a long shot. It's a long shot to pursue a 1983 case if you get convicted, if you get acquitted, even if you get acquitted. But it's not impossible. And there's like we talked about, all that we looked at yesterday. There's a lot of variation. The prosecutor, for example, what role are they in? Are they doing investigative work? Are they advising the police? Are they participating in that part of the case? Or are we talking about their advocacy in court? Different standards that can apply under different situations. But guess what? You take it all off the table if she gets convicted.
While the jury is on their way in, I need to see counsel at sidebar.
Well, we'll go straight to sidebar then. We will go straight to sidebar. So I wanted to make sure that I didn't forget to actually bring that all around full circle. The design, the context, what we're seeing. Okay, how it all makes sense and how it all fits together. We have a massive aversion to accountability on the part of our government betters. Okay, we're gonna create this system that makes it nearly impossible to hold them accountable civilly for violating your rights, for just ignoring the rules, ignoring the Constitution, trampling all over you as a citizen. You're going to make it extremely difficult to achieve that. But then if they do it well enough, so that you get convicted, now it's completely off the table. That's our context, guys. If you're going to go with the frame job to avoid your accountability, you got to go all in. That's why we're seeing what we're seeing. It isn't just sunk cost. It isn't just psychological. It's self-protection. You take it off the table if you can get her convicted.
Be seated, this court is in session.
All right, Mr. Brennan. Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Must have gotten too hot, and that's why the juror was faint. No admonishment of Hank.
Dr. Rentschler, you wrote a report back in February 2024,
Yeah, that's correct. Yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did. Yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct. Yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and from, you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
You don't lean
Well,
into
it
the
does to a
car, that's
certain
for
extent,
sure.
Yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there's only one reference, you were referring to the pink test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
We're going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report and PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
So I think there were.
Now we're into the number of studies battle. Only a lawyer would think that that's persuasive.
26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this.
The reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 cites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest in this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its Relation to Lacerations Severity Indices. You know that, you cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napue goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct. And that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test
correct.
dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure. I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything
Come on,
where
AJ, wake
Dr.
up.
Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that?
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm
represented.
asking you, you've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alessi?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
Objection.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You
You're correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Yeah, you have
Well, you're
reasonable
right. You
doubt
can't
about it,
prove
wouldn't
that
you?
actually occurred. That's the basis. Yeah.
So,
If you don't have the
You can-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It
Yeah.
scientifically makes no sense.
So if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
Could be perfectly reliable.
Very briefly.
Test could be perfectly reliable. It's just that it may or may not be relevant to what the jury needs to decide. But of course, your test could be reliable even if you can't replicate the actual collision, because it would be doing something else. But notice the circular reasoning, right? It's not replicating anything unless that thing exists. Okay, unless that thing happened, there's no replication. That's not what we're trying to do here. We don't have a known that we're trying to replicate. What we're trying to do is we're trying to reverse engineer this outcome. That's what we're trying to do. We're not trying to replicate something that's known. We're trying to reverse engineer something that isn't based on the pieces that we do know. Oh man, Hank is really, really flailing on the shores of reasonable doubt here, isn't he? If you don't know how something occurred, how can you know it did? That makes no sense scientifically. And that's the bottom line of the case, isn't it? That's the takeaway from Judd Welcher. No idea, too complicated. He doesn't know. Therefore, you can't say it did. Doesn't make any sense scientifically. If you don't have the evidence, you can't prove it actually happened. You're absolutely right about that, Hank. If you don't have the evidence of how something happened, you can't prove it actually did. Really, our bottom line, that should be enough. That should be enough for us to go ahead and go home now. But no, he's gonna flail some more. A test that doesn't replicate something that may or may not have happened can still be a perfectly reliable test. None of these tests that we've seen are done to try to replicate. We're reverse engineering. And it's perfectly reliable for that purpose. But yes, we don't know John's position. We don't know the arm position. We don't know the point of contact. That's literally what we have to be here to find out, not to try to replicate. I am not clear if we are getting into the neighborhood of where this might be open to simulate, couldn't you? Possibilities. You could simulate possibilities. And that would be reliable. They just wouldn't be definitive because they still wouldn't prove what actually happened.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement on it that he was trying to reenact the actual collision?
When I did that, there was one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again.
Objection.
The detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that.
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
Mm-hmm.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course
Beginning
after
part
the
of it,
collision
it
to a
would.
resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift,
Almost like you're not testing the throw when you restrain the dummy. Almost like that's logic a kindergartner could figure out.
if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
You've seen crash test dummies where it is held in place electromagnetically, and when
Lovingly
the
at
collision
the hips.
happens,
In fact,
then
we
the
have.
dummy can move. Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash tests with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a Fender Vault, isn't there?
There is, yes.
A Fender Vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a Fender Vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentschler's PowerPoint, please?
It is. He's really struggling. He's
In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions,
trying so hard to give
Validated
him
Models
credit.
for Pedestrian Impact and Projection, correct?
Yes,
And you put snippets up on the board?
yes.
And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these
Frontal
situations are known
impact,
as Fender Vault.
not relevant.
The models presented here do not apply to Fender Vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions because that is the majority of pedestrian collisions in the front end, isn't
He
it?
The
cited
majority,
things,
it is, yes, sir.
but he
And so
hasn't
there is a difference
quoted
between
them
Fender Vault
in his
and the center
PowerPoint.
of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's the center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No,
Correct.
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
I don't know. There's an impact.
Nobody knows. I don't think his arm was even impacted by the car, so no.
You
I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle,
So ask the question again.
Okay.
There it was. Wasn't even hit by a car.
You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you
Yes.
talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
Well, that was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure if we're talking about force over area. And that's what I evaluated in this case.
When you gave your
He doesn't
demonstration about the
understand.
hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
Objection, Your Honor.
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
Objection.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
Objection.
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight breaks, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your video, yes or no, after the collision, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Grab
an
exhibit
individual.
73, please.
Don't interrupt him. Object. Come on, Alan. Fight for your witness.
Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right, is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight
Well,
cover.
when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard
No, it
area of
doesn't
34
matter.
Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of it?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate.
Could have
or
been
investigate
planted,
that.
as far as I know.
76A, please. Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none. So, no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 990.
Certainly different possibilities.
Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I
Sure,
suppose
and
that's a
another is
possibility, or
planted.
someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says
Oh,
I
is that why
reviewed
you thought you
medical
could get
records
away
and
with it?
reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had taillight shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't, well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that
Matching.
were recovered from Mr.
Consistent with.
O'Keefe's sweater or shirt?
Objection.
I'm going to allow that. Did you consider that?
Your Honor, it could be reformatted. Otherwise, I need to see the photos.
I'll try. I'd rather try to reformat than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's
Objection. Not
sweatshirt
an evidence.
and T-shirt was scraped?
Objection.
I'm going to allow that.
Your Honor, I need to see the photos.
Jurors, this will be brief.
Jurors, this will be brief. Just because Mr. Jackson wants it, it will be brief. It's not an evidence. That's not what the testimony is. The testimony is it's plastic that's consistent with the tail light or another source. Could have originated from that tail light or from another source. They share material properties. That's the testimony, not that these are tail light shards. It's similar plastic. That's what we know. So good objection by Alan on this one. I'd be objecting a lot more at this point. You know, why not? Why not? Let him have some of that back. He's going to badger, if he's going to be cumulative. Make my record. Make my record. And just you're showing the jury that you see what's going on. And you're calling it out. If it's not proper, the jury should see that it's not proper. You calling it out highlights it as being improper. Oh, we finally got there, didn't we? We got to the Dr. Laposata moment. Don't even know he was hit. So of course we don't know the angle. We don't even know there was a collision. I don't think it was. Don't even think there was. By the way, that hat, of course I have no idea how that hat there. We can think of a lot of different possibilities. Could it be there by an accident? Yeah, well, it's there.
Thank you, Your Honor.
Okay.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Your Honor, based on the last question, I wonder if Dr. finished his question. The judge will need to try based on the question that was asked. For the same reason I just indicated at sidebar. Could you just be reformatted and straight?
I'll try again.
Okay.
When you looked at these taillight shards that were
Objection.
Go ahead, Mr. Brennan.
when you looked at these taillight shards that were consistent
Objection.
with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection. Word it differently. Start with the different one.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in scrapings of Mr. O'Keefe's clothes.
Objection asked and
I do.
answered.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
You want to ask it again for like the 30th time?
Please.
Bringing you back to my question.
Do you understand this is
Go ahead, ask it
broken
again.
pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're
I don't,
telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to have considered in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
If you disagree, do you think they're not sharp?
I don't have an
I
opinion.
just said they
as to
look
that,
sharp.
We'll take a look.
Objection.
Sustained.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp?
Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back
Been
to
looking at the normal eye.
20E. Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter. through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
Lawrence, you got it in
In
anyway.
your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass? No.
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
Okay. And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the breaks in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you move the arm angle, do you expect that the break would look different?
That the break would look different?
Yes.
It could look a little different. I mean, certainly the breaks looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
Objection.
Don't know that he was standing.
No, I'm going to allow that.
You do not know how John O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Objection.
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or
Is it
different?
all going in the same direction or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Okay. Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the taillight at what you say is 24 miles per hour can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Zach's
Well,
answered.
knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
And because he's suspended.
Yeah, that's the rotation of Randy. And again, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
Objection.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, and sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor. No.
Snort.
I'm going to allow that.
Now it.
Objections.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
Do you think John O'Keefe did somersaults in the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking you. I've heard that. I'm asking you
Yeah.
if he did somersaults in the front yard.
No, there's no evidence of what he did.
Your Honor, come sidebar quickly before I start.
Okay.
No, I don't think he was even hit by a car. How many times can you say that in one cross? Oh, a couple somersaults into the yard as not impossible is way less impossible than the car blasting off into outer space. The range of possibility that Welcher wanted us to have and to hang on to seems far more possible that somebody does a couple somersaults into the yard after getting hit by a car than that the car blew up into outer space. Maybe that's just me, not a scientist here. You engineers, I trust that you could calculate the specific difference in likelihood between those things happening, and you could give me the error rate, and you could give me within how many standard deviations is that difference accurate to? Oh man. Flailing. He's flailing. No, Hank, none of that stuff matters. Doesn't matter how many times you want to answer the question. He's running into the same problem now with Laposata as he did with Laposata, which is that Rentschler's getting warmed up and he's on to him, and now he's starting to feel himself and get comfortable. Now he's getting to stunt on him a little bit. Little bolo punches. No, I don't think he was even hit by a car. Wasn't allowed on direct to say anything about the number of holes compared to the number of wounds in the arm. But we got it out on cross, didn't we? Got it out on cross. Hank invited it. He's getting the feel for explaining all these things. And so if Hank wants to keep asking the question, I'm going to bring you back to my question. Great. Then I'll just go ahead and explain it again. And we can do that as many times as you like, all day if you want. I'm not in a hurry. I'm getting paid for being here, just my normal salary. You want to keep going down that road. I'll just keep explaining how there's no collision here. So none of this other stuff matters. Oh, what a conclusion. What a conclusion to the defense case. On the one hand, the dummy doesn't move right because it's suspended. But on the other hand, we want to really focus on how the dummy moved, even though it was suspended, to try to point out how try to say that like lines up with the shoe, all that stuff. I don't know. Where's the measurement of the shoe? Where exactly was the shoe found relative to the car, the point of impact, et cetera, et cetera? Can you identify any of that, Hank? No, you can't. So then it's all supposition. Got to start with the first parts first. Then you can evaluate where the rest of this comes in. But otherwise, there's just a number of possibilities for the way those things can get there, Hank. Somebody could even put it there. Someone could even put it there. That's right. That is a possibility. Hasn't been ruled out, has it? Hasn't been ruled out. Somebody put the hat there. Somebody put the shoe there. Somebody put the cup there. Somebody put the plastic there. Hasn't been ruled out that the vast majority of this plastic was never there in the first place. No photograph of it at the scene. No documentation, no measurement, not even a chain of custody, not even putting it into evidence when you say you found it. That's true. You're right. I don't think Freckles, she did do it to Karen in season 1. Something funny, Miss Reed, but I don't think she did it in front of the jury. I could be wrong, but I'm pretty sure she did not do that in front of the jury. It was during one of the arguments that they were having at the end of court. So it is a minor difference, but it is an important one. In front of the jury, oh, I wish she would have just answered. That is kind of funny because you're pretty ridiculous and you don't know anything about what you're asking here, do you?
Please.
So I find it amusing.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that.
Question.
I'm going to allow that.
Your Honor.
So hold on.
Sure.
Let's get an answer, Dr. Rentschler. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
Your Honor, that's not an evidence.
No good faith.
So
Glass? No.
hold on, Mr. Jackson. Mr. Brennan.
I can reword it.
Okay.
Please.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have exhibit 195, please? You recognize that?
That is another photograph of the drinking glass. Yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
Okay. 98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that
My
does
God,
appear
the
to be
straw.
a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
Okay. And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body? The suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street. Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. May I approach?
Yes.
April 20th, 2021. Page 124, line 16. Yes, 124, line 16. May I approach?
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
That's it. That's
I have
it.
no further questions.
That's it.
Mr.
Oh,
Jackson? Okay.
oh. Yet another cross that it's not real clear why we bothered to do that. We came out of that one worse off than we started. Didn't land anything significant. Nothing significant landed here at all. Is there any point? Is there any point that he landed? Any at all? Let alone any point that he landed that overcomes the damage he did with inviting Dr. Rentschler to say how many times he doesn't think there was even a collision here. So, of course, he doesn't know the angle of the body at impact because he doesn't know there was an impact. Overcoming the damage of a lot of ways this stuff could have ended up out there in the yard. A lot of ways. Somebody, in fact, could have put it there. Possibility. I don't know what he accomplished here or thinks he did. The only method to the madness is trying to make him look bad, and he didn't pull that off. He lost that.
Yes.
Thank you. Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just answer the question.
Sorry,
And-
Your Honor.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCCA.
Okay, wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. You were asked about a Fender Vault collision, and you said, well, this wasn't a Fender Vault, right?
Correct.
What is a Fender Vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up. If it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the
Hank's mad now,
police
sitting there
reports
steaming.
that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the following question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that, to be honest.
In your view, was there evidence of a collision with John O'Keefe?
Objection.
Sustained.
And
In your opinion,
get to that ultimate issue.
were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Get into the planting. Brennan's sitting there steaming about that.
Doctor, you just said that you do not believe that there was a Fender Vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well,
Not
I
hit him,
don't
hit him?
believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that that glass was pulled from his nose? What
Objection
date?
beyond the scope.
I think it was the morning when his body was discovered.
January 29, 2022,
Yes, sir.
somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
This is beyond the scope. It should be objected to. None of this came up on redirect. Redirect limited to your employer. It's not a Fender Vault. It happens when you're hit at the center of mass. All these other things have nothing to do with the case because it doesn't matter who they got there, or it doesn't matter how they got there if you haven't proved that there was a collision at all. Guess she's treating the door open by the stuff about he would spin. And so if it came from like the tail light or something, it would pass him by. And even if there was some contact, it would be on the right side of his face, not his left hand side. So I don't know. You got a new theory you want to put out here, Hank, about the glass ending up in his nose. You want to give us yet another mechanism of how that might have happened. Did the Bush do it? You know, did the Bush throw the glass at John O'Keefe? Is that possible? Welcher might think so. I doubt that this guy does. But now Brennan clearly wants to get into the video of Karen saying that. He wants to like replay that for Dr. Welcher. Not sure how any of this is really responding. So got it that Judd Welcher gets to testify to his opinion as to there being a collision with John O'Keefe based on all the non-scientific stuff. But the science guy, he doesn't get to testify to his conclusion about whether there was a collision with John O'Keefe. Did we catch that? I definitely caught it. I definitely caught it. They're allowed to have an opinion, but Dr. Rentschler is not allowed to have an equivalent opinion on behalf of the defense or to explain why or anything like that. This might be fun because I see this comment that just came up. Witness said there was no evidence John had a glass. He said, "What do you mean by evidence?" He said, "Is there a video or a photo of him holding the glass? Otherwise, there's no evidence." Okay, what's the evidence of John holding a glass? Goes back to the statement by Karen. Right? Goes back to the statement Karen said. He got out of the car. He took my glass with the vodka soda. It was from her statement. So number one, if this is not the same clip as when, taking the glass out of the nose, we have no idea if he saw this. Okay. So there's a basis for the question problem here anyway. But number two, it's inviting him to talk about testimony and how it's not his role. I hope he gets there. Not his role
whether or
to
not
testimony.
any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
So when there was a snowblower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasions, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at the bigger picture if things make sense. If somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture that doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary. Is one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How'd it break that night?
I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right. You're all set, Dr. Rentschler.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson?
Yeah, sure.
Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
PowerPoint.
The documents, I think, subject to the documents. Outside of what Mr. Drew put in, I thought this was more than one.
They've been marked for identity. Jurors, I want to see counsel for a couple of minutes over here.
He wants the PowerPoint in evidence. It hasn't been offered. It's just been marked for identification purposes, which is pretty normal because it is a demonstrative. It's not evidence in and of itself. But, you know, we've got this mishmash of stuff, I think, coming into evidence. Some coming in, some not coming in. It's really not clear how the rules apply here. So I have no idea if it's supposed to come into regular evidence or not. I love him bringing up the smell test. I love the smell test. The smell test is what told me how this case is off in the first place. Actually, technically, it was the eye test. The eye test. You can just look at John. Like, huh, that's no car accident I've ever seen. It's a guy with a guy that's been in a fight. Guy's been in a fight. Would love an MRI on his nose. I tell you what, if we want to complain about the lack of MRIs, I would like one on his nose. Okay, because it's not hard to look at that photo and see how red and mangled looking his nose was. And then we heard from the description of when they found John and he had blood gushing from his nose and his mouth. That's how Karen ended up with the blood all over her face. Blood coming out of his nose. I don't think you get blood coming out of your nose from the basal skull fracture or the orbital roof fracture. That sounds a little bit more like, you know, kind of thing that happens when somebody gets punched in the nose and then they bleed all down the front of their shirt and their pants and even onto the top of their shoe. Happens like that. Guess this is going to take a minute because you know, we're at the tail end of stuff here. I think we're about to hear the defense rests, and the jury will get the rest of the day off. We'll have tomorrow for Hank's rebuttal, and then Friday the instructions conference. Has he had a sense of the futility yet, do you think? Or do you think he's walking out of this courtroom going, man, I really killed that cross. I should absolutely get Dr. Welcher back on the stand because I can't lose right now, man. I should run out and buy a lottery ticket. Everything is going my way. How do you think he's feeling about that? I selfishly, very selfishly, I want Dr. Welcher back because I want to hear his response to the testing. What do you got, dude? What's your criticism? Guy who did some finger paints, what exactly is going to be your criticism of this testing? Selfishly, I would like to know that. But not totally confident at this point. I'm actually going to get that, but we'll see. I mean, boy, Hank can't end it on this, can he? He does still have to bring in Terry Kuhn, the DNA, the dog DNA, the not dog DNA, the pig DNA. That lady, we got to get her in. Not sure what we need Maureen Hartnett to rebut. But he said he wanted to, so I guess maybe there's something there for Maureen Hartnett. Those are small witnesses. Those would go very fast. Not a big deal. Welcher, though. Welcher's gonna take some time, and boy, he's risky, isn't he? Isn't he? Didn't see those X-rays. So were you just sloppy, or were you being dishonest? Oh, you mean the prosecutor just didn't give those to you? Very risky situation. See, the unknown that we have that Hank doesn't is what the story is there. If Hank knows the answer to this question. Hank knows whether he just didn't give those to Dr. Welcher, or if Dr. Welcher lied on the stand that they don't exist, or Dr. Welcher was super sloppy and somehow managed to never see them or be aware that they existed at all. Hank knows the answer to that, and so that gives him some better basis than we have to make the decision, do I call Welcher or not? But even that is not 100%. Reality is not a bad predictor for what people are going to say on the stand, but it's not 100% correlation. Just because you know the answer doesn't mean that's going to be the answer you get from the witness. I'd be very, very concerned, having seen this witness, Dr. Welcher.
Jurors, we're going to issue for the day. We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, so jury.
Sound is still on, so I think they're going to come back and we're going to have an argument. Yeah. Looking that way.
May be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
All right, to the court, please.
So this sounds like we are negotiating the conditions to admit the PowerPoint into evidence or not. Full evidence, not just a demonstrative. I don't know. None of it makes a lot of sense at this point. Normally, the PowerPoint is not coming into evidence. It's getting marked. That's it. But it's, we're in this courtroom, so who knows? All right, guys, let's recap what happened when we came back after lunch. So we're still on cross with Dr. Rentschler. Hank brings up his February 2024 report. There were several opinions way back before the defense ever hired them that John's injuries would not result from the undamaged taillight cover, and the force required to break the taillight would result in I wrote significant, but I don't think that's the actual word that he used. I think he said extreme or something like that. Soft tissue and likely bony injuries. So force acts on both of them. If it's enough to break the taillight, it's also going to be enough to cause significant injuries to whatever part of John's body came into contact with the taillight. It's just X-rays. There's X-rays. There are no MRIs. We already heard this before. Getting a little lally style with the repetition. So the X-ray itself doesn't necessarily show soft tissue damage, but it could show laxity of the joint. The dummy, of course, is not the same as a person, and that's why you look at the acceleration, the rate of acceleration and the force. That's what the ATD is for, not to treat it as, a equivalent person for all purposes. And of course, looking at what happens to the dummy is not the same thing as looking at an MRI. That's why he's explained his process is you get the measurements, the acceleration. From that, you can calculate the force, and then you go from there. Then you just compare it to tolerances. References in Welcher's report. We got into the count, the site count, like that matters. They both had 26. It must be a really close case. They both had 26 citations in their report. Well, Welcher included some other paper with a big bibliography of a bunch of different things with some 1960s and 70s studies cited. The most recent one was from 2004. He didn't read any of those extra references because Welcher didn't cite to them as the basis of any of his opinion. So not clear why they're relevant at all, what they have to do with anything. In his own May 7th report, this very recent report, just the response to Aperture, he cited 26 studies, textbooks, etc. Several sites for using crash test dummies and relationship to soft tissue injuries. Shouldn't do that. No, and that's why that's not what he did. We all know that the dummy is different from how the real skin would respond, and that's why he didn't use the dummy to evaluate skin injuries. And the study doesn't say it's appropriate. That's correct. But ironically, the study doesn't say it's inappropriate either. And yes, there's lots of literature about the Hybrid 3. Some guy, Harold Merckx, I couldn't catch quite what his name was, says, don't use dummies to evaluate lacerations. And he said, yes, that's exactly why I didn't use it for that purpose. And to imply so is a misrepresentation of my testing and analysis. Oh, way to get aggressive after lunch, Dr. Rentschler. Start thinking about how to hit back. Yeah, let's call it out. It is a misrepresentation. I like that. It is a misrepresentation of what he did. So call it what it is. Just like it is funny how ridiculous he's being. You could just say that. It's okay. You can just say it. Really wish he had. Yes, the absurdity of sitting here in this courtroom watching this woman be tried for murder when you can't even prove there was a car accident. You can't even prove that there's a collision. Yeah, that does seem, in a black humor kind of way, Mr. Brennan, sort of funny. Just lean into it. Sometimes it's okay to just lean in. That's okay. He didn't, but misrepresentation, he gave us that. So then getting into Welcher's intentions, right? Oh, I just had Hamlet going through my mind. Words. He didn't say specifically in his report that he was intending to model the exact position and configuration of the arm. But the problem is, he says the orientation and position are consistent, and his only reference to that is the test. So if he didn't intend to test that position, then I guess we're acknowledging, number one, Welcher has no idea what the position of John's arm was. And number two, we have no idea what the value of this test is. What is this test even for if it's not to propose a position of the arm? What's it even for? All we can do is evaluate what he did and the use he made of it. So if he didn't assume that, then not only does test not represent that, then he in fact has no basis for his conclusion that there's consistency here. That's right. That's right. You feeling like you really got somewhere there, Hank? You really feeling like you got somewhere with that? He never said. That was their deniability the whole time. Well, he didn't actually say that's what he was doing. It doesn't matter. Talk is cheap. Remember, talk is cheap. Look at what people do. What people do tells you so much more than what they say. Look at what he did. You understand the significance of it based on what he did. But I guess we have to conclude he has no idea how John O'Keefe was positioned. Nope, he doesn't state what he thinks the speed was. He doesn't state how he thinks John O'Keefe was thrown. And That's because you can't actually prove any of this occurred if you don't have the evidence. If you don't know how something occurred, how can you know it did? That makes no sense scientifically. Indeed, it doesn't, or even just from a common sense standpoint. Makes no sense scientifically. So no statement from Welcher that he was actually trying to attempt a reenactment here, but there is no other explanation of what happened or how. Welcher said he had conducted a biomechanical and accident reconstruction analysis, but if the testing wasn't to do that, wasn't to propose a mechanism, then he didn't actually do any of those things that he said that he did. So if that wasn't the intent of his test, I'd be curious to know what the intent was. Yeah. Maybe we'll ask him if he gets called up for rebuttal. Maybe we'll ask him. I don't know. Maybe we won't. We'll see. Yes, sometimes in real life there are variables that you can't predict, but is it possible? I don't know. Is it? It depends. It depends. It depends on what you're looking at. If you want to conclude that something happened, you have to look at all the variables. And if you don't know or you can't control for those variables, then the result is you may not be able to prove what happened. How many times can we bring this back around to no collusion, you haven't proved it? How many times? A lot, as it turns out. We can bring that back around a lot of times. He's evaluated hundreds of pedestrian cases. He relied on Dr. Wolf. Wasn't even there for the crash test. Oh no. Oh no. So if Dr. Wolf made a mistake, then the effect of that would just depend on what the mistake was. How about we start with establishing Dr. Wolf made a mistake, because we haven't seen that. The dummy on the forklift would move like a pendulum. He wouldn't be thrown. Had a big argument about this. There wouldn't be thrown because he's tied. He's suspended to the forklift, but it would still show backward movement. And so in the video, though, we don't get any of that. We get the dummy turning and the spinning, but it wouldn't fall. Yes, there's other ways they could have done it, but they didn't because that's not what they were testing. Center of mass versus a Fender Vault hit we got into. He cut out the part of the article in his PowerPoint that talks about some frontal collisions being deflected to the side. I don't know what kind of a gotcha that is, because all you did is invite Dr. Rentschler to say yes, because this isn't a frontal impact with the front of a sedan. It's in fact totally different. What kind of dumbass would put that in their PowerPoint when it doesn't apply? The frontal impact, you don't usually get a center of mass hit, so it doesn't pertain to any of the allegations of what supposedly occurred here. We had the F and the E test. F is the center of mass hit at 29 miles an hour. E was not a center of mass hit. It was just on the arm. Where was he hit? Well, nobody knows. Nobody knows. In fact, I don't think his arm even was impacted. I don't think it was hit by a car. No, we don't have any info on the angle of his body because we don't have any info that he was even hit. How many times can we say that? A lot, as it turns out. A lot of times that can come out in your cross-examination. The force equations, Hank tries to suggest he only cited concentrated forces. He only used concentrated forces. And he provides an explanation that Hank so clearly does not understand what it means or what he did that he couldn't even argue with it. He explained I don't know. I couldn't write down that explanation, but you can do it on the center of mass. You can do it another way. You could do it both ways and it would be fine. Hank didn't understand it. The center of mass is actually the most distributed impact if you're calculating the force. Slapping you in the head with a book versus a high heel. This isn't time for your fantasies Mr. Brennan. Nobody's hitting you with a high heel anywhere. But you would have to look at the force to evaluate the injuries. Phone data has nothing to do with biomechanical. Go through the long laundry list. Alan keeps objecting because none of it has to do with biomechanical evidence. It's repetitive. It's unnecessary. It's not helpful to the jury. None of those things have anything to do with biomechanics, the health data, the phone temp, etc. He knows what a debris field is. In this particular case, we just know there's debris from a yard, but where it came from, those details are all supposition. There's no actual facts. And how much he relies on that or considers it would depend on the evidence, how it's collected, whether it's accurate and reliable. But for biomechanics, generally, it doesn't matter. That's an after effect. That would be just, something that I guess you could evaluate if you wanted to get more detail about what an impact looked like. But you have to start with establishing an impact. So that's what matters, because guess what? There's lots of ways stuff can end up in a yard. It doesn't have anything to do with the biomechanical analysis, because if there was no impact, none of that matters. So no evidence as far as the distance of the taillight from John. Nothing like that. He has no idea how the taillight got there. He could conceive of several different possibilities. Same with the hat. Someone could even put it there. No evidence of how it got there, so it's not relevant to the biomechanics. He saw the x-rays when he was on the case initially. This was not, oh, Hank, you're trying to find out how you got caught, aren't you? You're trying to find out how you got caught. Trying to find out if he just got these x-rays recently. No, Hank, he's had them since he was on the case initially. And guess who provided him with all that information initially? That would be the FBI. That would be the FBI. So, don't know what your people did with the x-rays. Rentschler just went ahead and got him from the FBI. He was trying to feel out if there was going to be like room there to wiggle, excuse. When did you see those x-rays? Back when the FBI gave them to me, sir. All the various pieces of plastic, the shards, the stuff from the shirt. We had numerous objections about that because he kept wanting to call it taillight pieces. He kept wanting to, equate it to pieces of taillight. That's not the testimony. It's not in evidence. Just that it is, it's got similar material qualities, consistent material qualities could be sourced to the taillight or something similar. But all of this stuff doesn't matter. Other ways stuff can end up there. You need the contact with the arm, I guess, apparently. I loved that. For any of this occur, I guess it's the arm. We don't even know because none of it makes sense anyway. But even their theory, non-theory that they deny is a theory but assert as a theory, you need contact with the arm for any of that stuff to happen. Any conclusion based on that other evidence without proof of contact, it's supposition. It's you're working backwards. You're working backwards. You're assuming the contact to get to, the manner of deposition, but you don't actually know that. So if you can't prove an accident even occurred, you can't look at this tertiary evidence to form an opinion about whether an impact occurred. You don't know anything about it. You're being conclusory. Some parts of that plastic do look sharp. And sure, it probably could cause lacerations, but not abrasions. You wouldn't get the same pattern, and the force of the superficial wound would be highly unlikely. But even if it was possible, you would have to have enough punctures or holes in the sweater to account for all the abrasions. And in that case, maybe it would be possible that those pieces caused it. Then we turn back to the testing. They positioned the dummy to be in the same position as Welcher's apparently irrelevant demonstration. I love how he leans into it. I really do. I really do. If they're going to insist that what Welcher did is irrelevant and it doesn't matter, lean into it then. We positioned the dummy to correspond to the position of Welcher's apparently irrelevant demo. But no, they did not put a glass in his hand. No, they did not count taillight pieces. They counted the holes and punctures in his sweatshirt instead, which was 0. He's getting spicy. Dr. Rentschler was starting to get spicy. So then we look at the taillight, the impact. It has some spread. Majority of the pieces didn't land on Randy. If the dummy fell right where he stood, there would be no taillight on him at all. I guess if John fell in the street, there wouldn't be any taillight on him, but he didn't, did he? Did see from their testing that the taillight could be broken without the dummy's knee being contacted. Yeah, when you hit it at 24 miles an hour. Hit it at 24 miles an hour, you were able to break the taillight with the non-center of mass hit. Then we got into how the dummy isn't loaded. So the problems with the test, it doesn't show the flight path after because you tied him up. But then because you tied him up, his feet aren't loaded on the ground. There's minimal contact with the ground. But now we want to rely on the foot position of the dummy when he's spinning without any weight on his feet. A normal person wouldn't spin like that because it wouldn't behave like a dummy that is suspended. So no having it both ways for you, Hank. There's no evidence of staggering backwards. Spinning would not cause you to stagger backwards. Is it possible? Now we get into the is it possible? You can hypothesize almost anything. You could hypothesize that somebody could do a couple somersaults into the yard. Do you think John did somersaults into the yard? No, in fact, I don't think he was even hit by a car. How many times can you tee that one up, Hank? You want to tee that up some more times? Bet you can tee that up some more times. So then we got to the cut to the nostril. He's aware, he believes it was glass that was allegedly pulled from John O'Keefe's nose. He did actually evaluate that because it was inconsistent with coming from an impact to the vehicle. Go through all the photos. The drinking glass, yes, he's aware of it. The straw, yes, he's aware of that too. The straw, remember, that was found like weeks later in the street, at least a week later in the street. This was on the February 10th, I'm pretty sure. Maybe it was the 3rd. Now I can't remember. Plow has gone by how many times? And somehow that long black straw still sitting there in the street. We don't even have DNA connecting it to anybody or anything. No proof at all that this is has got any connection. But we're going to look at that straw photo. He doesn't remember exactly how he found out about the glass in the nose. It might have been in an interview that he saw. Then we go back to his testimony at the voir dire when he was asked about being informed by the FBI what was going on with respect to the trace DNA. Yes, he remembers those questions. That's right. They told him about the trace DNA and it doesn't matter because it doesn't affect his conclusions. Nothing to do with the biomechanical analysis. And at that time, he said it helped him understand what was going on during the trial. Yes. That's the hard blow that Brennan is going to conclude that cross-examination on. Guys, he got nothing out of that. He got nothing out of that except about 5 times the witness got to say there wasn't a collision here. There wasn't even a collision. Yeah, but you haven't proven that, see? And if you don't have the info, then I guess you can't prove that. And that's just how it is. Ugh. Redirect by Mr. Jackson established that the they who provided information about the prior trial was not anybody associated with the defense. It was also not his employer. It was not ARCCA. It was the client, somebody completely separate. Client who's the only one that's having the communication with the court and the parties and so forth. We went back to the Fender Vault. The Fender Vault is when you have a pedestrian that's in a crosswalk. They're walking across the street, and so they're crossing the front of the car. They have this movement. The car has the movement, flips them over the driver's side. No applicability here. The demonstration of where the center of mass is. What happens if you're hit below the center of mass? It will flip you up and over. Has nothing whatsoever to do with this case because the profile of the back of the SUV is completely different. The debris field. Oh, I thought Hank was going to jump on this because, you know, he's sitting there steaming in his seat after he tried to, are you saying this stuff was planted? I'm saying there's possibilities for how stuff ended up there. But boy, that debris field, he doesn't know how or when that plastic got there. He doesn't know who put it there. And he is aware none of it was found at the time that John was found. The cut on the nose is inconsistent with the glass coming from the vehicle because he explains the mechanics. He's spinning. If you're in this position, the debris, you know, it's not a center mass hit, then the debris passes right by you. If there was even any contact, it would be on the right side of your face, not the left side. All these other details, hat, straw, glass, doesn't matter if it's not. And if there's no collision, then those things aren't where they are as a result of an impact. Got to start with the impact. So you don't have any idea how it got there. Therefore, you can't use that to prove what happened. If you had it on video and you knew exactly how it got there, then maybe you could. Maybe you could reverse engineer from that, but you don't. It's unknown. So you can't use that to work backwards. Not allowed to say his conclusion as to whether there was a collision with John or whether there's even evidence of a collision with John. He's not allowed to say that. Welcher is, but he's not. But he is allowed to say that the injuries are not consistent with John being stricken by an SUV. Restate that. We go into Recross. A clip. Clip is not consistent with the evidence or what occurred. Clip is just another way of saying the side swipe, the not direct hit, non-center of mass hit. He would spin. Not consistent with what happened. The glass in the nose, he's aware that that was found the morning the body was found. Wants to know about the evidence relating to the John holding the glass. He's like, what do you mean by evidence? Is there a video or a photo of him holding the glass? Otherwise, there is no evidence he had the glass. We had a long sidebar, came back, don't get to continue with that conversation. We talked a little bit about why. Not clear that he even knows about Karen's. This just comes from Karen's statement, from Karen's interview. She's the one who said he was holding the glass. But we don't know he saw that interview. This really does open up a lot of doors that the Commonwealth would probably prefer not to open about how it's not his job to evaluate the credibility of the witnesses. That's for this jury here to do. So testimony, you don't get to decide whether things happened or not just because somebody said it. The taillight pieces, yes, he watched the leaf blower video and he saw where those pieces were found. But do you have any evidence of where they were found? No, Hank, because your witnesses didn't preserve any of that. Your guys didn't prove where the taillight pieces were. We don't even know. We don't even know. They were in the yard on the grass. We don't know any of that. Your guys didn't do that. Can you use common sense? Do you have common sense that you can use along with your physics? Well, indeed, yes, you can. You can look back and you can consider if an explanation makes sense, if it passes the smell test.
Court is back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
It's exactly the substance of Dr. Welcher's.
Which was not objected to, right?
No, the court keeps saying that, yes, there were things that Mr. Alessi, like evidence, yes, there were things that.
But did he object to the PowerPoint coming in?
It's been well under pressure. I don't know what Mr. Alessi did to do, but PowerPoint, that's not the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it, we take out all hearsay, a discussion of the opinions or thoughts, thought processes. These are all the tests that were completed and done, exactly as Dr. Wolf's PowerPoint was done. This PowerPoint should be evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welcher's PowerPoint. There are, most of the videos are included. Oh, no, I'm wrong. Things have slowed down. So there are, the videos are the same, but the videos that Dr. Rentschler used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm.
Remember that.
What he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the court suggesting that it's not going to let just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes,
Very briefly.
yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welcher's. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have posed that objection before it was displayed for the jury.
Well,
We've now seen the entire PowerPoint. I mean, it's tactical. It's not strategic. It's tactical. They still like to use it to the case. If they didn't want to get certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed in, not in part, in whole, as it now assists for the jury, assists for the court, for quadruple K for identification, it should be admitted.
okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess' PowerPoint is in evidence.
So,
No, I'm pretty sure it's
Mr.
not.
Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else?
Mr. Alessi needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Yep, there it is.
All right.
Your Honor, it's late in the day. We would like to review which required finding of not guilty at the disclosure of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if what we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would,
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So,
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they did mark for identification.
no, they were marked as evidence, right?
They're private markers exhibits.
Yeah, they're exhibits.
But no, they're coming into evidence, Your Honor. I mean, ruling this.
So are they,
I thought they were marked as identification, not evidence. If they're an evidence, they're in. If it's identification.
so I need to find that. It would be my intention that they get put into evidence.
We
I'm
know,
not going to
Bev.
display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, there are exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's
We know,
identification.
Judge.
I have a different part on
That's
how
the
this works.
point.
Yes.
You
It's
keep saying we'll do it, and you haven't done it.
B.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them?
Yes, let's do that right now.
Where are
So
they?
it's
Oh,
done.
Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
Yes. You just said, Bev, I've ruled they're in evidence, but I need to know if they're in evidence. How do you not see that's the problem?
Reporter.
So the 230?
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have.
230 A through D. Oh my Lord. This is why he's had to keep bringing it up to you, Bev. We said that the other day when he brought it up, because you said you're going to do it. You didn't. You brought it up. You said you were going to do it.
We will make,
It's
so
still not
as of
done.
now, they're in evidence. Tomorrow, we need to physically put the sticker on those.
Why don't you do that right now?
Yes.
230A,
I'm sorry, say that one more time.
230A through C, 230C.
We got to wait till tomorrow to put a sticker on.
All right.
Council, there are 4, A through D.
Just so the record, this is limited to saying different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the focal points marking. So as we do that, I'm good and I'll get out of here.
This is not rocket
We will
science.
do that first thing tomorrow morning.
That's fine.
All right.
Not
We
rocket
will-
science.
So everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay, so I'll see everybody tomorrow morning at 10
Don't you
for
care
the
if it
charge
works for
con. Do
me,
you have them
Bev?
now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order, so you know what they are, Mr. Jackson, in order, okay?
223.
223.
Thank you. My only other question, Your Honor, was
223 before we said it was 230.
last year we were relegated to 1 hour. I would ask, an hour and a half.
Now I got to go back through and see if we already have a 223.
No, I got it.
That's going to conflict.
Yeah, I can go.
I would ask for. I would ask for an hour and a half for a final summation, given the gravity of the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally would allow us only an hour.
You might get an hour and 15 minutes out of me. Let me see about an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the
I
same?
don't have a position, I'll take whatever the defense is.
Let me think about it.
Yes,
All right,
Your Honor.
so we will see.
Thank you.
All right, so I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to
Lord.
discuss?
No, thank you, Your
All
Honor.
right, we'll see you tomorrow morning.
All rise for the court, please.
You didn't ask me if that works for me, Bev. You didn't ask me if it works for me. Yeah, it does. It does. I'll take an extra. I'll take an extra day. Okay, Exhibit 223. Looks like they had already marked those. What a mess. You know, the basic thing of getting materials into evidence, making your actual record, it shouldn't take half an hour at the end of the court day. You shouldn't have to bring it up over and over again. It's one of those basic things. Oh, let's take this in order. We were like 30 seconds from the end of the recap with the recross, asking Dr. Rentschler if you can use common sense. And he's explaining, yes, you can consider if a potential explanation even makes sense. But the biomechanical analysis itself, it is the physics. And if you don't like that and it doesn't fit, too bad. It's the science. It is what it is. Doesn't preclude you from taking account of the smell test or the bigger picture. But the physics are just the physics. And as far as how the glass broke, there's no evidence. That's how Hank concluded his case, guys. Had a little bit of recess to talk about the PowerPoint. Defense wants Dr. Rentschler's PowerPoint in evidence. Hank is objecting. It is hearsay. It shouldn't come in. It's also demonstrative. It's not, but AJ's arguing in and of itself, it's substantive. And I think he does have a point with some of this stuff, like the slowed down video. It's not already in evidence. That is substantive. So Bev appears to be going in the direction of tell me if there are slides that have information or evidence that wasn't already admitted. And she'll let those ones in. AJ saying, well, if they objected, it should have come before you displayed it to the jury. Now the jury has seen the whole thing. It's not really recognizing the difference between a demonstrative exhibit, which the jury does get to see, and a regular exhibit, which goes back into the jury room with them. Those are different things. So I don't think Bev is going to change her mind on that, but it is what it is. And then we heard from Hank. Boy, they really successfully snookered him, didn't they? You can't call Welcher back after that. You can't call Welcher back after that little shenanigan with the x-rays. You can't do that. It's going to blow up in your face. You know the answer, Hank, to why he didn't see those x-rays. You know the answer, and you're not calling him back. Tells me everything. Tells me everything. You know that explanation, it ain't going to be good for you. You know it's not. No further witnesses after the defense rests. So defense is going to have to renew their motion for judgment, notwithstanding the evidence, or notwithstanding, I forget what they call it here, but the mandatory judgment. Commonwealth hasn't met its burden of proof. It's going to be denied again. They'll just do that in a kind of summary sort of way. Mr. Alessi had an issue, but if there are no more witnesses, then that means he doesn't, because it was going to go to, where's Welcher's response? Where's the information? Am I going to get to see this before he gets on the stand for rebuttal? Don't matter. We're not doing rebuttal. We're not doing rebuttal. We have successfully, I don't want to call him a queen, okay? Welcher, the queen, coming off the board, because it's just he's not that important. But in relevant to their case, he kind of is. He really is. He's the queen. He's supposed to be the fact, science, and data. But boy, just throw his hands up. We can't know. Can't know what happened. So then we, had the long go around with the documents that we've already had to revisit twice. She says they're in evidence, but they don't seem to be in evidence. Why should we have to be spending all this time verifying if they're in evidence? They should be in evidence. They should have a sticker on them. Bev says, I've ruled they're in evidence, but I need to know if they're in evidence. Yeah, exactly, Bev. That's exactly the issue. I'm glad you get it. So tomorrow we will do the jury instruction conference starting at 10. We get to sleep in an hour. Yay. We knew it. You guys, was this really going to be a full week? Of course not. It's not going to be a full day tomorrow either. It won't take them the entire time to get through the jury instructions. Those have been out, the defense and the Commonwealth's proposed. We've looked at some of those. So Bev will have her own script as well that will get incorporated into all of it. This was the same thing as we saw happen last year. Some of them she differs from the form instructions. So just a thing to bear in mind. Maybe she'll call it out. She did last year. Maybe she won't. Then on Friday, we will do closings starting at 9:00, arguments, and then the jury charge. Then the jury gets the case, guys. Maybe she'll think about maybe giving them a little bit more time for closing. No way they're getting 90 minutes. Okay. Beyond the pale, 90 whole minutes, but maybe an hour 15. The micromanaging, it just really is. It really is off the hook, isn't it? It's nuts. What a way to end the case. There was no collision. Last evidence the jury heard. Hey guys, according to the physics, no collision. That's where we're going to leave it. Well, how do you guys think that went? How do you guys think that went? Let's get back to your comments here. Dawn Huffman, why was it important that the paper copies of paper x-ray be put into evidence? It's not critical that the paper x-rays be put into evidence. I think the issue is that it's preferable because, at least from the defense standpoint, because you can look at them. They're readily available. They will literally just be physically transported back into the jury room. If you do it digitally, okay, they get a thumb drive, but they don't necessarily have a way to look at it. So they have to typically go back to court and ask for permission to be able to watch it. They have to ask for access to like a laptop or something that they can plug the thumb drive into to be able to watch it. So if they're going to look at it and consider it, everyone's going to know. They can't just do it. They have to ask for special permission. It's a hassle. You're, imposing on the court and all that. It's not a ton of friction necessarily, a ton of resistance to getting that done, but there is some. It's non-zero. So I think from the defense standpoint, it's preferable to have it in as paper so they can just look at it. Don't have to go through that that intermediary to be able to get to it. But it ultimately doesn't necessarily matter that much. It's just kind of getting to logistics of deliberations. Teddy 617. Can the defense file a motion regarding alternate and jury foreman selection processes? We need every juror number in McDermott's tumbler and keep an eye on juror 1. I am right with you on this one. I'm right with you on this one. We've just seen, I didn't watch it, but I know plenty of other people did watch the Dr. Turk. I'm not even sure how to pronounce his name. Watch that trial right here in this courthouse and watch the alternate selection process. And it's just like pretty much every other court I've ever been to. You don't always have a fancy like bingo wheel type of turner. Sometimes you just have like more of like a Yahtzee cup, you know. But you have something like that and it's a draw. You just draw them randomly out. You do that in open court. It's public. It's transparent. Everybody sees. So we are on the same page that should happen. Can they file a motion? Yes, they can. Absolutely, they can. They haven't, though. But I guess they got tomorrow. Will she suddenly be too busy? It won't be timely, you know, who knows? But yes, they absolutely can. They can file a motion. They can cite the law that establishes the process, how it's to be done. And then, you know, consistent with that, propose what other mechanism they want. Might be smart to do that. I'm with you. It's a very, very high priority for that process to be transparent. Casey Cat, Andrea, why would Hartnett from the crime lab be coming back in the rebuttal case? I wasn't able to figure this out either. And apparently it doesn't matter because she's not. I had no idea what they're going to try to bring Hartnett back to rebut. No idea. I thought maybe it would have something to do with, like, did they have additional foundation that they would need to get in the dog DNA? You know, dog DNA testing. It's about all I could think of. But now apparently we're not getting the dog DNA either. So now we're back in the confrontation clause problem, where they never got an opportunity to cross-examine that whole testing process, results, analyst, credibility, none of it. Interference, the issues they had in the first trial, they talked about possible interference with being able to develop results. That was the problem with asking Dr. Russell about it, from my perspective. That's the primary problem. Not that it's hearsay, that it's testimonial hearsay. It is hearsay prepared by a Commonwealth witness for the purpose of prosecuting somebody. Very crystal clear, you have a right to confront on that. You don't get to elicit it through other witnesses and avoid cross-examination. But that's what they did. That's what Bev allowed. That problem is now back sort of out there because it hasn't been cured. Maybe we're at full-on fuck it point now. They don't even care. Maybe they just don't even care. I gotta say, if Hank is willing to leave it at that, leave it at Dr. Rentschler owning you got nothing from him and he told you and your jury at least 5 separate times. John wasn't even hit by a car. There wasn't even a collision here. You're satisfied to leave it with that? I think maybe you've quit. I think maybe you've just given up now. So who cares about a confrontation clause issue? Add it to the list. Just go ahead and add it to the list. Why not? We've given up anyway. Sandra M. I wonder if Hank told Scorty Bello to not mention the x-rays. Well, I just don't think it came up. It wasn't disputed. It wasn't disputed until Welcher said, well, he maybe has injuries. You know, I was thinking about that all the way through the first trial. There was no dispute. Nobody argued. Maybe he did have a boxer's fracture. She testified, no fractures below the neck. And everybody just went with that. So there's no need to Bolster that. It's fine. It's not in dispute. But now Mr. Welcher comes along and he puts it in dispute. Well, there could have been because there weren't any x-rays done. Well, no, actually there were. There were x-rays done. So you can actually be confident that there weren't any fractures. I don't know, man. I don't know. But it was going to come out if you put Dr. Welcher back on the stand. Why he wasn't familiar with those x-rays. And I just have to suspect that wouldn't look good for Hank. Great positioning by the defense. Ipsy Dixit Land. That sounds like a fun game like Candyland, except maybe a little more frustrating. Ipsy Dixit Land. Now I want to think up a board game. Ipsy Dixit Land. Hanky tanking his career. Does Lally care? Karma. Yeah, look at Lally. Look at Lally. Lally's gotten paid to just show up and sit here and be a potted plant for the most part. Got to handle a few witnesses and, otherwise just sit and watch Hank flail harder than he did. It's not like this has affected Lally's career, not like it's affected McLaughlin's career. That whole misrepresentation about what's in the TUI disclosure from the feds. Doesn't matter at all. We'll see if Hank tanks his career. If he does, I don't think it will be. We've talked about it many times. I don't think it will be for the reasons that you might think. Because he's an asshole, because he's dishonest, because he breaks the rules. That'll be desirable to a certain clientele. That actually makes him more valuable. But the problem is really going to be that he's destroyed his referral network. Nobody is going to be referring cases to him. And he's not trustworthy. Just because some people might like that, other people are going to look at that and be like, that's a vicious dog. You can't control who's the target. You get too near a vicious dog, you run the risk you're going to be the one that gets bit. Jason McClellan, if the defense asked for a mistrial or the jury is hung again, would the Commonwealth go for a third try? Do you think Reed will take the stand? She has done interviews and she has sat through 2 trials. If there's another hung jury, would they try again? We have a major sunk cost issue. And then we also have what we were just talking about when we came back from lunch. Tie that 1983 piece back into it. If we've got to contemplate the possibility that Karen Reed might sue over this. Remember, you got a lower burden of proof in a civil case than there are in criminal cases. All you have to prove is preponderance of the evidence. There was violation of her rights going on here. All you got to prove is by a preponderance of the evidence. And where did those bumper sprinkles come from? In and of itself, getting close. Where did they come from? Because they didn't come from that glass. If they want to take that off the table, they have to convict her. They have to convict her. If she wants to sue, she has to show favorable termination. Favorable termination of the case, of the prosecution. So if they just get a mistrial and give up, she can argue that's favorable termination because they didn't get a conviction of her. So it worked to her benefit. They have to convict her to take a lawsuit off the table. So might be a big part of it. Oh, and very different discovery in the civil suit than in this criminal one. In the criminal one where you have to ask for permission from the court to do like anything. Generally not going to be the case with civil. That said, I haven't gone over the civil discovery rules in Massachusetts with a fine-tooth comb, but yeah, suspect that would look a little bit different. So my guess would be yes, they would. After how today is concluded, I might be leaning more in favor of acquittal. I might be off the mistrial. Ugh, I can't though. I can't. There's just too many variables, too many opportunities for shenanigans. Very first question we looked at here about the jury selection, right? That just brings it all front and center. We can't count on this process. We can't count on the process to have integrity. So would love to be able to rule out shenanigans, dirty business, but we can't trust it because Hank does shady shit and has no consequences for it. No transparency for a lot of the stuff the court's doing. Can't take it on faith. So yeah, I think if they did, I think Commonwealth would go for a third try. They have to. Would Karen take the stand? I don't know. I mean, she didn't this time and she's already done the interviews. So maybe that would be like the Hail Mary. Seems like, if you've tried it twice and you haven't gotten on the stand, you're probably not going to get on the stand. My prediction would be no, they don't put her on. My recommendation? Well, I've been a fan of putting Karen on the stand from day one, and I know I am not the majority on that. So I know I'm not. It's not the majority view, but I always want my client on the stand if I can. If it's possible, I want them on the stand. Humanizes them. The jury is so curious. The jury wants to know. And even though the jury is instructed, can't hold it against them if they don't. Study after study after study of jurors show that, in fact, they do. They do hold it against your client for not testifying. So I think that's the best answer I can give you on that one. Texas Sister 2. So Hank should have corrected no x-ray on redirect to be ethical. Yes, he should have. But Hank gets first on rebuttal, so should clear up. But how? Witness will blame prosecution and prosecution will blame the witness. Well, it turns out we're not going to correct it at all. So along with the confrontation problem that hasn't been cured, we also now have the Napue issue. We have the Napue issue with the, incorrect information being elicited and the prosecutor not correcting it from his witness. We don't have a record of what he knew, and that's potentially part of why we're not getting a rebuttal case, because it's possible that Mr. Welcher knows just a little bit too much about whether Hank was aware of these x-rays or not. But yeah, it means it's going uncorrected. I mean, other than just the fact the x-rays are out there, the jury knows now that there are x-rays. The jury has the x-rays in evidence. So, I mean, in that sense, it's been corrected, but the testimony hasn't. And he hasn't been confronted with why he didn't know that. North wings, northwest ings. Always see this username, and I'm curious about this. In wings. I'm a little behind, but didn't Dr. Laposata say she didn't see x-rays until 2 weeks ago as well? Where were they? Thanks, Andrea. She did. She said it was about 2 weeks ago that she saw them. Don't know. It's very interesting, isn't it? That Dr. Rentschler had them from day one, from his prior engagement. I mean, the FBI, we already know the FBI got a lot of what the FBI got because they subpoenaed David Yannetti and his file, and he turned over the entire client file. And so to me, the most logical explanation for where did the x-rays come from, they came from the autopsy report and the autopsy records, and everybody has had them this whole time. So the FBI got them because David Yannetti gave them to the FBI with all the other material in the client file and in the autopsy report. That to me seems logical. Why did we only just give it to Dr. Laposata 2 weeks ago? 2 weeks ago was when Welcher testified denying that there were x-rays. So it hadn't been in dispute until then. And Dr. Laposata, she's the forensic pathologist. She's the one with the expertise, right? Specific medical expertise to look at it, do the diagnosis. Perfectly normal. These things are all perfectly normal. So if you didn't know you needed to dispute it, you didn't know you needed to address that issue because you didn't know it was in dispute, wouldn't have necessarily provided it to her. But boy, you sure would have provided all of those autopsy materials too, huh? So why wouldn't you have given it to him the first time? It is a mystery. It is a mystery, isn't it? It makes it seem like maybe it wasn't in the autopsy report that the defense had because they didn't have it to give it to her. Or she would have already had it. And it wouldn't have been, I needed to give it to you 2 weeks ago. It would just be, oh, I'm going to draw your attention to it. We didn't know we were going to have to talk about it. And now we do. We'd love to know, wouldn't we? Does the FBI have a backdoor source for these x-rays? Oh, I hope we get more information from Karen or from the defense team after this trial is over. I want to know the story about the x-rays. Occiput boner. Can AJ say in closing that they didn't call XYZ as they didn't want to keep the jurors longer and chose just to present evidence there was no collision? They cannot. You can't talk about stuff that's not in evidence. Your defense strategy is not in evidence, and it's not relevant anyway. It's none of this tends to prove whether or not John was hit by a car, whether or not Karen murdered him, etc. So no, you don't get to talk about yourself and your own processes and things like that because it's not in evidence. So nope, they can point out what is in evidence and what it shows and why it matters, and then kind of hope to get an implication for what they didn't put in, why it doesn't matter. But that's going to be, I think, about the best they can do. Nicola Maxwell, happy birthday, Kai, from a sunny Scotland. Indeed, happy birthday, Kai. It's a sunny, windy day up here in Washington as well, and we hope you're having a great day there in Pittsburgh. Pittsburgh is a lovely city. I gotta say, all those beautiful, beautiful bridges. There's the funicular on the hill there. It's not Heinz Field anymore. What is it now? I want to say Petco, but that's the one that's in Petco's in San Diego. It's not Petco. It's not Heinz Field anymore. Anyway, PNC Park. PNC Park, my opinion, one of the most beautiful baseball parks that there is. It really is lovely. It looks over. I don't remember if that is the Allegheny or the Monongahela, but it's one of those rivers, and it's got the beautiful bridges and stuff. Really, really nice ballpark. Hope Kai is having a wonderful day over there in Pittsburgh. Occiput boner. It occurred to me why ARCCA didn't do Meadows. Bev made them finish testing over a weekend when she punished them for not being available at her demand. That is true. That's true. They had limited time to be able to do the response to the Aperture testing. Now, having said that, yeah, I guess that would have been a response to Aperture. It would have been rebuttal to Aperture. So I was thinking like they could have done that anyway. They could have done that like before, but we only hired them to rebut Aperture, and so just the timing wise, it didn't work and so forth. So no, I think you're right. I think you're right on this. Maybe it's also why they didn't drop test the head on some frozen ground. You have limited time. Got to do what you can do. So I got to say, I'm pretty impressed with what they were able to put together on a rush job over like the 10 days or whatever they had to do it. Was it even that much? Wags, I just wish Kai a happy birthday on X because Bev is a Grinch. He's 10 today for Pete's sake, and his dad is busy freeing Karen Reed. What's your problem, Bev? What's your problem? We got to hear all about Jen McCabe coaching the kids and Oh, it's just such an important thing that she does with those kids. No problem with the personalizing all of that. Suddenly we can't acknowledge the fact that our expert witnesses are also humans, have some of the same experiences as the rest of us do for purposes of considering examples. Good for you. That was a very grinchy attitude towards a wishing a happy birthday to a 10-year-old kid. Sonia Woods. Hank and Bev are panicking and talking over each other, objecting. The science is an inconvenient truth for them. It's almost like someone lit a smudge stick in there and the demons are in death throes. It's like the shades had, there's a crack in the shades and the vampires are over at the wall. No. Let the light in. Let the light in. It's a great disinfectant, isn't it? That sunshine of science and truth and facts and data. Let it all into the case. SL, defense not presenting any evidence that the videos of Karen Reed were misrepresented. Some jurors are going to hold that and lead to a mistrial. Maybe we don't know what the jury's going to make of the videos of Karen. It's going to be the responsibility of the defense in their closing to either argue why they don't matter. And along the lines of what Dr. Rentschler was just saying, if there was no collision, that doesn't matter. Karen could absolutely, firmly, unequivocally, vividly remember that there was a collision. And if scientifically it didn't happen, her belief is irrelevant. People are wrong all the time. So some jurors might hang to it. I don't know. It's the only case that the Commonwealth has. Was enough to get him a hung jury the first time, right? I hit him. But we've got such a better targeted, cleaner focus by the defense this time around. No collision. Their job to prove it, and they haven't done that. That's good. That's good. It's a good position to be in. So if they buy that, doesn't matter what Karen Reed said. So I think that's likely how the defense is going to handle that. Dino Tink. Andrea, what's your opinion as to why the defense has not brought in x-rays before yesterday? Were they not allowed? They didn't matter. They didn't matter. It wasn't in dispute. Nobody ever said, you're wrong, Scorty Bello. He did have a broken bone, or maybe he could have had a broken bone. It was never in dispute, so you never had to. We could just go with her testimony. No fractures. But Welcher decided to get on the stand and say she could have been wrong. She could have been mistaken. Maybe there were. We don't really know. So then we get all this testimony. We had also never heard that they opened up his arms and his legs. They dissected them and didn't find as much as a bruise. We didn't know that before either. It was never in dispute. So that I think is the reason why. A cool breeze. What is the defense allowed to say about Brennan's behavior throughout the case? Bev's instructions didn't elucidate the problem with the hoodie. They'll be coming back to that tomorrow, right? I'm not even going to deal with this until the charge conference. Well, that's tomorrow. So we'll be dealing with it tomorrow and whether your curative instruction was sufficient. Maybe they'll just let it go now because it's like so far in the past. We'll see. We'll see how that comes up. Generally speaking, though, they can't comment on his behavior. They can't. His behavior doesn't tend to prove whether Karen hit John with a car. It's not relevant. It's not proper. They can't. They have to kind of trust that the jury sees some of that for themselves. Now, there might be ways they can obliquely highlight the distinction between the case, the presentation, the attitude. You can mention things like the defense witnesses withstood a lot of indignity and insult and nevertheless remained firm and confident, and none of their None of their facts, their substantive facts that they established were undermined at all. Contrast that with Dr. Welcher, who was arrogant, who is pompous, and as it turns out, is at least best case scenario, overlooked a really critical piece of evidence in the case. Worst case scenario, ignored it and lied about it. It's for the jury to decide what happened. You get to point out that possibility. So you can kind of obliquely get to it by just focusing on what actually happened during the presentation of the evidence. But to personalize it to Hank, no, that wouldn't work. You got to do that indirectly. 45 state PE. Brennan argued yesterday that John lived a long time after being hit and could have been saved. He is pushing for Karen's malice of leaving and therefore only working for the murder charge. Well, he definitely was trying to suggest this as a possibility. What if John was alive for a while and then he was cooled and they have trauma centers and all of that type of thing? I mean, it could be. You know, if you're not going to go for the murder, then why even charge it? Why even prosecute it? You know, it definitely, I agree with you. That's definitely where he's going with that. Would he take a manslaughter if the jury wouldn't give him murder? Bet he would, and he'd be extremely grateful for it. Well, he actually probably wouldn't. He'd probably feel slighted by that, but he should feel grateful if he got a manslaughter conviction out of all of this. But that's because, you know, he can't prove there was a collision. So if you can't prove there was a collision, you shouldn't get any of it. You might as well focus on malice if you can't focus on proving that there was a collision. Kathy, your realtor living in New Jersey. I missed yesterday. Oh, you missed a great day, Kathy. About what time did the X-ray cat jump out of the bag? Oh, sounds amazing. Wish I could have seen it with you all. It was in the afternoon, so I don't remember the exact time, but it was I think after the afternoon recess. Maybe it was right after lunch with Dr. Laposata. It was good. It was fun. We enjoyed it a lot. Great day. Nicole Kelly. So Wolf, thank you. Yes, Wolf can talk about his wife's cappuccino, but God forbid he wishes his son a happy birthday. Yeah, another great example. Little personalized stories. Everybody else gets to talk about their kids, but not Rentschler. Not the kid who's actually still a kid and having a birthday. 45 state PE. State versus Charles Smith, as well as Texas v. Joe Bryan, as well as People v. Mario Casciaro, Illinois 2013. So I don't know these cases. Joe Bryan, I believe, is that an innocence case? Is that an Innocence Project case? I feel like it is. I just don't remember the details. I suspect these are innocence. These are exoneration cases. Joe Bryan's the only one that kind of rings a bell for me. Don't know the others. Hey, screenshot. I'll check them out later. Thanks for the reading material. Tracy Elliott, love that you let us listen and then provide your feedback. I do get a little excited sometimes when there's crazy shit going on there and talk over the stream. But guys, I recognize can't hear two things at once. So I do my best not to interrupt and let us just take in what we get and then comment about it afterwards. And then we don't miss anything. Lawyer nurse. Oh, come now, Dr. R. My 3-year-old daughter does this test at childcare daily, but uses her hands, and it's beautiful. We support it with evidence. Every grandparent who received one for the past 50 plus years, does she put her hand in some blue paint and then put it on a piece of paper and then draw it into a Thanksgiving turkey? That's a good 3-year-old project doing that. You put the paint on your hand and then you put it on the paper and then you draw it into a turkey. It's really, it's so adorable. Just the cutest thing. Maybe Welcher's hoping to get some of that. Aw. Amanda, fun physics calculation. I love fun physics calculation. The percent difference of momentum of just the arm between the 9.34 and 11.8 arms is 23%. But factor in the real situation with the car, it's 0.04%. Pretty significant difference, right? Is this looking at, I'm just going to guess the math you did, and chat can tell me if I'm being an idiot. But the we had the percentage difference calculation that Dr. Wolf talked about, and that's this percentage difference of momentum that we got with the 23%. But if we do the full force calculation, and we do it one time with a 9.34 arm, and we do a second time with 11.8 arm, because our full force calculation is also taking into account the acceleration, weight of the car, et cetera, it's actually 0.04%. That's my guess of why it doesn't actually matter. Materially speaking, it's insignificant. That's my guess. Don't know though. Didn't take enough physics to be able to do that math myself. Wisconsinite Concept Season 3 of Karen Reed, The Immaculate Collision Chronicles, flashes ahead to her 23rd trial. Dr. Andrew Rentschler is played by Christopher McDonald, aka Shooter McGavin. Oh, who do we have playing Dr. Rentschler? We saw some good suggestions. For me, it's really Jeff Bridges or bust. I'm sorry, guys, but I can absolutely see this guy, his expressions, everything, the befuddlement. I could just put him right in a bathrobe and hand him a White Russian and not know which movie I'm watching. To me, it's clearly Jeff Bridges, but we've had some good suggestions for Dr. Rentschler. Matthew Dulea, when Welcher comes back, can AJ not ask any questions, but instead approach the witness, put a clown nose on him, and boop his nose? No more questions, Your Honor. Well, maybe Welcher anticipated this, or Brennan anticipated this. Decided that discretion is a better part of valor here. Just cut your losses. Cut your losses. Get to your argument. That's the only place you have a chance of making any progress at this point. The whole truth. Is Bev protecting Commonwealth and herself by implication from malicious prosecution charge? You know, the whole potential for criminal liability for this stuff is different. Very different from what we've all been talking about with the 1983. 1983 is just about, can you sue them in civil court and get damages? Can you make them pay you money for depriving you of your rights? Real different question than, do criminal investigators and prosecutors have the ability to charge criminal conduct? And it really just depends on what the evidence is, of course. I was actually looking this up a couple days ago because I was curious, and unusually for me, I still have the tab open. It's been a full week so far. But I'll just go ahead and share with you what I was looking at, because the most likely thing we'd be talking about in that type of a scenario, we'd be talking about some kind of obstruction of justice charge. So here generally is what they are. Here's the federal obstruction of justice charges: influencing officers, influencing jurors, obstructing proceedings, alteration of record or process, picketing, parading, nah, it's not going to apply. Recording, listening to, or observing proceedings of the juries while deliberating or voting. She's not going to obstruct her own court order, obstruct criminal investigation, obstruct state and local law enforcement, tampering with witnesses, retaliating, some civil actions for restraint, obstructing a federal audit. It's not that. It's financial institution, not that. Criminal investigation, not that. destruction, alteration, or falsification of records in federal investigations and bankruptcy, destruction of corporate audit records is not that. Retaliating against a federal judge is not that. So if there's anything criminal here, I think to really be concerned about, it's something here in obstruction, you know. But all depends on the evidence. You just really don't know. But yeah, they always have to be more concerned about a criminal prosecution than a civil one because of all that protection that they get from 1983. But by the opposite hand, the opposite token, you know, criminal prosecutions for this type of thing are much more rare, and they also have a much higher burden of proof. That's part of why they're more rare. It's easy to make a civil claim because it's relatively easy to prove a civil claim. It's harder to prove a criminal charge. I can't say, no, this isn't happening. Can't rule it out, can we? We can identify it as a possibility, but we can't say that's what's happening, but we can't rule it out. Marian Vitale, I'd pay to see Dr. Rentschler cross-examine Dr. Welcher. I don't know, man. It's not his game. It's not his game. And there's a lot of pitfalls. But it would be fun, wouldn't it? Is apparently irrelevant testing. If it's not to show the position of John's arm that they propose, and I'd be very curious what the actual intention was, because there's no other way that it's relevant. Nothing else it shows. They're just trying to disclaim themselves, you know, have it both ways where we're going to assert a position but deny that it's our position. I mean, it's silly. It's silly. So I liked him calling that out. It might be fun. It might be fun seeing that cross-examination. He would definitely know what the weak points are, wouldn't he? Just not sure that he could really tolerate the, you know, the gas coming out of that bag. Irish Gal, do you think there's a massive cover-up to frame Karen Reed because if found not guilty, maybe all Proctor's cases will be looked at and maybe more people are framed? Possibly, but the thing is that that's already happened. That's already happening. Proctor got fired for misconduct in a case. Like, that's already happening. They are already going back. They're already looking at Proctor's old cases. That's already going to be in effect. They're going to be looking at what was known, what was disclosed, when was it known, you know, should I have been able to impeach Proctor in my trial with this? The activity, was he texting with his friends about my case? Like, this guy's, the cat's out of the bag. You don't need an acquittal for that. Even if she were convicted, it's still out of the bag because he got fired based on his misconduct in the investigation. Leanne, it's my birthday and I get Crash Daddy too. Also, a happy birthday to Dr. Rentschler Jr. Well, happy birthday to you, Leanne. Happy birthday with Kai. What a treat for you. I didn't have anything like that on my birthday. In fact, I don't even really remember my birthday this year, the actual day. Oh, wait, yeah, I do, because we were on an airplane. We celebrated my birthday with Dead and Company in Las Vegas, but we actually flew there on my birthday. Not the most exciting day in the world, but it was fun. Alexandra Hall, why does the missing witness instruction have to be decided after the defense rests? It's just all the instructions are decided once the evidence is in, because you don't know, and you don't know what he's going to do on rebuttal. We only know that now. So until all of the final decisions are final, you don't know what instructions you actually need. Just like Karen could decide at the last minute, I'm going to testify, and now you don't need that instruction on the defendants not testifying. Brennan could decide at the last minute, going to call people in rebuttal, and now you don't need that missing witness instruction. So if the defense called them, you don't need it either. They're not missing. The jury didn't get to hear them. Defense can point out, you only heard from them because we called them. Party with the burden of proof, They didn't call him. You only heard from him because we did. So don't really need it if the defense calls them. Debbie W., I think my super chat is the one that got closed out yesterday. It's okay. It happens. It said, I was hoping Dr. Laposata would say to HB, I'm a doctor, not a physicist. It would have been fun. That would have been fun. We got a little bit of I'm a physicist, not a doctor today from Dr. Rentschler. So just get it from both sides. Sorry about that, Debbie. It does happen. I do try to just sometimes you hit the wrong button or things, get kind of mixed around in the queue. So very sorry if I did miss that yesterday. But yeah, doctor, not a physicist. Josh H., has the Commonwealth proven where the supposed collision occurred? No. Is there a police report stating the resting spot of John? No. Hank hasn't met his burden. None of it. None of it. And once again, he just wants it both ways. We don't have any information, so we can't know anything, but you should still conclude there was an accident. You can't have it both ways. You really can't. Nicole Kelly, if Hank is asking the questions, insisting something nefarious is going on, why can't they say the feds? This isn't a balance of justice. They should, I feel like that door has been opened a long time ago. But definitely if you're going to be misleading about who is providing you with the information and why and what is their basis for thinking that they could provide you the information, all that type of thing. I got to tell you, as far as the FBI is concerned, FBI is not going to give one single shit about there being a state court level sequestration order because it can't be enforced against the FBI. It's the whole issue they have in Koberger with the gag order violation. And the Judge Hippler is making a lot of noise about, we could appoint a special prosecutor and we're going to investigate that. And you guys have to preserve all of your communications and things like that. Doesn't matter. If it was the FBI that leaked to Dateline, then you have absolutely no way of enforcing that. You have, in fact, until July 1st, another 3 weeks, to get Dateline on the stand before Idaho has a reporter shield law that then comes into effect. As of right now, they don't. And reporters can be compelled to give up their sources or jailed as a consequence. But going to run out of time in about 3 weeks to do that. They're not going to do that. So they won't find out from Dateline. It's the FBI. There's no way to enforce that. This is the whole reason we have TUI and the supremacy problem. So anyway, feds don't care if there's a sequestration order anyway, but that's a little bit aside to your point. They should be able to. Who was it? It wasn't us. It wasn't ARCCA. Who was it? Oh, it was the FBI. Everage, how can Brennan rebut without mentioning the arm? If he mentions the arm, wouldn't that open the door to the x-rays? Love your coverage. Maybe. He would have to be very, very careful. If he was gonna try to call Welcher and try to limit the scope, that doesn't open the door to the x-rays. Try to play Bev that way. He'd have to be very, very careful. And like you're saying, I'm just not sure what he'd be able to get in that's useful that wouldn't open that door. Because the injury is the focus of Rentschler. And your whole purpose in rebuttal is to respond to Rentschler and Wolf and the work that they did. So yeah, I think it was quite a dilemma. The horns of which Mr. Brennan found himself upon and chose the less risky option. Less risky option, just don't call him. Less chance that you'll be outed as a lying, scheming, unethical hack that way. Law and Lumber, I wonder if Hank sought to indict that very ham sandwich. Lol. Good one, Rob. I don't know. Did the ham sandwich intimidate any witnesses? Could be very intimidating, that ham sandwich. Honey Kid Lists. Here's my dilemma. Do I use the phrase details matter to be a jerk, or do I promise to never use the phrase details matter because I will think of Brennan? Thanks, Andrea and Mods. Well, details matter. You can think of Rentschler, because it was facts matter that came from Brennan, and Rentschler had to correct him. Actually, I said details matter, thus illustrating my very point. Details matter. If you're going to try to confront me with something I said, do try to get it right in the details, Mr. Brennan, because they do matter. Maybe you can just think of that. Think of that little funny moment that we had. Nick Stero, the difference between client and employer is enormous. Yeah, very much. If someone tried to pull that stunt in my area of law, labor and employment, that wouldn't fly. No judge should allow this, but here we are. Yeah. Very big difference. Very big difference. Glad Alan chose to sort that out on redirect. Should, yes, in my opinion, go ahead and just open that door all the way. Okay, it's like 3/4 there. FBI has entered the chat a long time ago. Point out it was the FBI. They should be allowed to do that, but of course she's not going to allow that. The problem with the question and the employer being not in evidence, not correct, not a good faith basis for that characterization, that doesn't matter. Not in this courtroom. I'll allow it. I'll allow it. Ms. Jake, oh no, he's using his education to make life better for the elderly and disabled. What a monster. How could we be putting this guy on the stand? Can you even imagine? Oh, it's funny. Impeachment by his 20-year-old publications, making life better for old people. Didn't see that get him anywhere at all. Oh, we know what the implication is supposed to be. Well, you're not an expert in these. Well, but you're an accident reconstructionist. So yeah, you are. And you don't have to be a specialist to be able to do the work, especially when it's this fundamental. Let's just look at forces on an arm and see if that makes sense. Lo and behold, it doesn't. LTL Media, how long you'll think these bullying, how do you think these bullying tactics by Hank are playing to the jury? I don't know. I don't know. And that's been one of the big questions that I have, because I don't know the culture of this community. And I don't know if these are massholes that expect this type of interaction and this type of aggression and this type of buffoonery, or if they are, I don't know, not massholes and expect ordinary civility and respect and decorum in a courtroom. I don't know, because I don't know who the jurors are, and I don't know the culture. I can see this going both ways. Honestly, we've seen from Sue, when Sue talks about the jury, she's got one juror that she describes as really enjoying the cross-examination, smiles a lot, like leans forward, really enjoys the conflict of cross-examination. That sounds like a masshole. And so that person might be real impressed with what Hank is doing. They might love it. They might think this is great. It's exactly what a lawyer should be doing. I just don't think there's any way to know unless and until the jurors choose to tell us themselves. Teresa Kaufman, Sir Francis Bacon, 1620 book, Novum Organum, Scientific Method Steps, first published. High school AP Chem and AP Bio teacher here, and have given a Sir Bacon Award to students. Good job. Good job. Yeah. Pre-Descartes, a couple of years before Descartes. I'm sure Descartes relied on him. I guess Descartes is just the principle of skepticism, pretend you know nothing at all. And then what can you know if you know nothing at all? But Sir Francis Bacon being the origin. Thank you so much for sharing your expertise. Love these kinds of facts. Sir Bacon Award. Very clever. Nicole Kelly, Hank inserting yesterday, John O'Keefe could have hit his head on a rock. Has anyone looked into who placed a rock on the lawn during jury viewing of 34 Fairview? Inquiring minds want to know how much this potentially attempted tampering with the jury has been prioritized and investigated by law enforcement. Yeah, we'd all love to know that. Not sure there's any way for the defense to really investigate this themselves other than you can talk to the homeowner and see what the homeowner knows. But if they didn't see anything, you don't have a mechanism at this point to, like, I don't know, go subpoena the Ring camera video from across the street, see if it shows who put the rock there. Shouldn't be hard, should it? A lot of different ways you could get to that information. Is that a law enforcement priority? Why do I suspect it's probably not? AK, how much do you think Bev cares about how the jurors perceive her other than being on schedule? Well enough to do that, you know, very sugary fake thing that she does with them all the time. Good morning, jurors. We're so happy to have you. She wants their good opinion. She wants them to like her. And it's a low bar to clear for a judge. They're inherently predisposed to like and respect and look up to the judge, just structurally. So I do think it matters. Is it her highest priority? Probably not. But maybe. Hey, maybe if you know, we are in a universe where the jury is a bunch of assholes and they love people being rude and difficult and obnoxious, they would like that from Bev too. They would like her chastising the defense in their presence, chastising the witness. Don't talk about your kid. That's enough. They might like that kind of thing, you know? I don't know. Law and Lumber stepped away and came back to Hank Brennan going full asshole mode. Did you miss most of the day? What did I say at the beginning of the day? This is going to be an interesting afternoon. He sure did try, didn't he? He sure did try. As it turns out, that's all he had. Try to get Dr. Rentschler down in the mud with him, make Dr. Rentschler look bad, dirty him up. He didn't achieve that at all. Not even close. He had no substance to work with. So all he could try to do was, you know, get himself real dirty and grab Dr. Rentschler in a hole similar to that loving hold that we saw Dr. Welcher have with that dummy. Loving little slow dance pose. Grab him like that and hope some of your dirt gets stuck on him. It's the only strategy he had, and it didn't work. Byron Butterfield. Want to buy Clue? Karen Reed first. Karen Reed edition. Chloe in the garage with a pig ear chew. Higgins in the basement with a fist. That would be fun. That would be a fun Clue game, wouldn't it? That would be fun. Well, there's a lot of different ways you can go. Call in with the Advantage boys. Lucky with the plow. I mean, all of it. You can have all of it on the table. That would be a fun game. John Mike, ham sandwich in police slang refers to planting evidence. Wowza. Does it really? I didn't know that. That's really funny. We, of course, all know it. The lawyers, we all know it as, you know, even you know, incompetent prosecutor could get a grand jury to indict a ham sandwich. You could get a grand jury to indict a ham sandwich. Getting an indictment is not difficult at all. It's a very one-sided process. You have to really not have much evidence to get a no bill from a jury. So think about that when you think about the no bill on Karen and Turtle Boy for witness intimidation. Weaker than a ham sandwich, that case. I did not know that slang. That's a great piece of information. D, I'm playing catch up, so sorry if this has been asked. Do courts ever give glossaries, instructions on basic terms to the jurors? Bev just had to clarify stricken, and it seems like jurors should know that term by now. Sometimes they will define things. Sometimes they will give explanatory instructions. You know, here's what it means when I say this. She had to do that yesterday with Dr. Laposata, where she's like, when I said strike it, it's in evidence. It doesn't mean you can't consider it at all. You just can't consider it as to this witness. And even that is like really unclear. And then we had the problem today where she's just saying strike that. We don't know what that is. So I don't know how the jury is going to have any idea. Strike that bit, that last bit. What is the last bit? What's the last bit? The jury has no guidance on what they are allowed to consider and not allowed to consider when you're that vague with your rulings. So there is likely going to be, in fact, it's like in the form, pretty sure it's in some of the proposed, just don't remember off the top of my head, but in the instructions, they will be told evidence that has been sustained or evidence that has been stricken, testimony that's been stricken, you're not to consider it as part of your deliberations. So they don't necessarily define it, but they do explain what the significance is of the evidence being stricken. Doesn't solve the problem of you didn't do a very good job of identifying exactly what you were striking. So they don't know. They know they can't consider it, but they don't know what it is. You didn't tell them what it is. That last bit, they could all sit back there and have different opinions or beliefs about what it is. It's a mess. Bev sitting on the scales. Did Dr. Rentschler eat the grand jury ham sandwich? Maybe he did. Maybe that's why they couldn't get to Karen Reed and Turtle Boy for witness intimidation. No, wait, because he ate the sandwich after that. So Joss Girl. Andrea, can we officially declare trial watching a sport? This is more interesting to me than any show. I'm doing a lot of sitting for this to be a sport. It's definitely an activity, perhaps a game. I guess, not to get too semantic. Just depends on how you define a sport, right? Is chess a sport? Is billiards a sport? Those of you who are busy in the chat actually doing the physical activity of typing are probably closer to a sport than I am, although I am taking the notes, so maybe the notes are part of the sport. Yeah, why not? Why not? If chess can be a sport, then surely trial watching can be a sport. We should have like a league and divisions and a Super Bowl and stuff like that. Wouldn't that be fun? Amy McCammon, I had a ham sandwich. We talked about your mom, Hanky. Oh, poor Hanky's mom is regretting her life choices. Ms. Lady Leah RN, if jury equals not guilty, can Bev cancel and say guilty? No, absolutely not. The jury comes back and says not guilty. We're done. We're done. She goes home. No legal mechanism to overrule the jury. The jury is the final arbiter of the facts, the credibility of the witnesses, etc. If Bev says there's enough here to go to the jury at all, then the jury's decision on how we make sense of it is final. Not guilty is final. No way around that. Liz Hunter, as a witness outside of pleading the fifth, what other way can you say to a lawyer, you are done answering them, it's just circles, and you have answered? You can say, I've answered that, and he did. Pointed out several times, I have answered that. I'm going to come take you back to our question. Okay, because I answered it. You want me to answer it again? Okay, here's my same answer. You can do that. You can do that. You can just say it. You can just say what you think on the stand. It might be a little risky sometimes, but you really can. You can just say what you think. I've already answered that question. Perfectly permissible. KIU, aka Kirstine. Sorry if a stupid question. Is defense lack of objections a tactic to show the obvious bias in Commonwealth's favor? Hank objects every 2 minutes. I feel lost watching this game. Science versus grease paint taint. In general, the tactical reason to not object is to just, when you do object, it looks like you're interfering with the other side and it looks like you don't want the jury to hear stuff. And so if you object less, if that's the interpretation that the jury is putting on the objections, keeping stuff from us, then you're minimizing that. We're okay with you hearing everything. That's why we're not objecting. Not really my style. I'm gonna push back. I'm gonna make you do it right. Just me personally, but you know, it's all context dependent. It all depends. So yeah, some of it probably is tactical. They've made the decision. They're not going to be obstructionist. Hank can be obstructionist. It'll be a contrast between them. And then the jury can wonder, why does the prosecutor with the burden of proof want us not to see all this stuff? And the defense, who has nothing to prove, is just letting it all come in. They don't seem to have any problems. And Cat 100. So 2 questions. Wasn't it stated they turned John O'Keefe's body over? That was, I believe, something that Jen McCabe said in the 911 call. They're turning him over. It was a comment she made at one point. They're turning him over. Would account for accumulated blood on face if Karen Reed hit John O'Keefe at time at mile an hour, have hit white car. If John had been out there since 12:30 and he's found at 6 o'clock, any bleeding that he did back at 12:30, it is long dried, it is long frozen. He's already dead, so he's not actively bleeding. We don't know exactly when, but long ago enough to get him to 80 degrees. I don't think that's gonna get you to blood transfer, because there's still no explanation for why you have fresh blood in the first place. It's just a little bit of a messy situation. Now maybe if it's, you know, I don't know, mixed with saliva and phlegm and stuff like that, in his body temperature is still warm. Maybe it's not going to freeze, but you'd still think it would congeal. So I don't know. If Karen Reed hit John the way that the Commonwealth says, the white Jeep seems to be a problem. Definitely seems to be a problem. I don't know how you avoid it. That's why Welcher had to be like, oh, well, but majority of witnesses didn't say it was there. Well, but it's not your job. Not scientific to decide who is a credible witness and who isn't. That is subjective. That is not a scientific method to do that. You would assume both ways. You would, let's look at both ways and see what happens. If these people are right and the car was not there, then there's no issue. But if these other people were right and the car was there, might be a problem. That would be the scientific way to do it. So that would definitely be a problem, I think. 40 Doherty, if she's acquitted and it comes out afterwards the jury had been watching news, social media, could she be retried, or is that only if found guilty? That is only if found guilty. If she's acquitted, we're done. We're done. It would violate double jeopardy to go back and retry her after she has been acquitted. So it would not matter. Mark Lyon, if a crash test dummy was holding a ham sandwich while fender vaulting at 34 Fairview, would a forklift have damaged the curb? Have you cited a single study, Dr. Rentschler, where a suspended dummy eating a ham sandwich simultaneously spun around and also stepped backwards and ended up 10 to 20 feet away at a flagpole? Not even a single study? Don Huffman, thanks, Andrea, for all you do. My question is, are you sure the jurors get to take their notebooks back for deliberations? Yes, it'll be in the instructions that they get to have their notes with them during deliberations. But they are not to rely on their notes as a substitute for their memories. Their memory of the testimony and the evidence is what is supposed to control the deliberations. So do not assume that your notes are any more accurate than your memory. There's a lot of those things that are standard in the instructions. So yeah, I am confident they will be able to have their notes in the deliberation room. Michael O'Houlihan, if he wasn't trying to make any representations, then why did he dress up as John O'Keefe? Great question. Great question. I didn't even think of that one. Why are you trying to be John if you're not trying to mimic John? None of this matters. Oh, that's such a great observation. Hadn't even thought about that. Loqueria, question. So if Karen is found guilty, but it gets overturned on appeal, would she then be able to sue the Commonwealth? We would, if it's overturned on appeal, then we're still at a favorable outcome for her. So if it gets overturned on appeal, usually what happens is it gets sent back for retrial, and we're just right back where we are. There are very, very few resolutions on appeal that result in the case being thrown out altogether. Very, very uncommon. So most often the remedy is you just do it all over again, and here we are back in the same position. So we're still in the ground of in the realm of having a favorable outcome. So a reversal on appeal does not help them for that. Spidley, it seems like Mr. Mean Mug and the rest of the O'Keefe clan are realizing Chloe bit John and Albert or Higgins KO'd and ragdolled John. My imagination. Hate to say it, but probably, yeah. Hate to say it because, frankly, there's no reason why this realization should be dawning only just now. If it's dawning at all, there was plenty of cause for it to dawn on them at least a year ago during the first trial. So I hate to say it, but yeah, probably your imagination, probably wishful thinking to some extent. It's just nothing here that's so different from what we already knew about the case that it would be like revelatory. Not that I see. Adriana B, custom furniture and home decor. Hearing gold standard so many times brings back bad memories of Dr. Curry versus Hughes testing in depth. Yeah, that's MMPI, the gold standard for the psychological testing that she did. Curry did, Hughes did not. Hughes just did the self-report your PTSD symptoms. And as it turns out, Amber Heard has over-reported everything. She has, according to her, suffered more trauma than people returning from war zones. And not a single injury. Not a single injury on her. Any photograph when she's supposed to have busted up noses, black eyes, so forth. Photographed when she's supposed to have those injuries. Nothing. But that's because ice reduces swelling. All right. Enough of Deputy Heard. Kristen, by the way, defense tech guy is Evan Wolk, not another Wolf. Hey, another piece of great information we didn't know. Because I'm telling you, if there was a second Wolf in the room, Dr. Wolf would have known that. Right? He's the one who called him Wolf. He rode to court with him. Wolf would know if there's another Wolf in the house. Hello. You can find your pack. Good piece of information there. Rentschler really destroyed Brennan. Love it. Thanks for your coverage as always. He really did. He really did. I still have Dr. Laposata as the best of all the witnesses here. But Rentschler is a real close second. Really did hand it right to him. Sweet Lorraine, would FBI have reached out to ME to let her know it was an FBI investigation? Could they request a deeper examination of John O'Keefe's body from her? It would be too late at that point. As far as we know, by the time the FBI was involved in this, it was, well after the autopsy was done and, John was buried or cremated or whatever ultimately happened to John. I'm not sure. So I don't know that they would have had the body anymore, but certainly the FBI could have reached out to the ME and, for example, investigated her, interviewed her, subpoenaed her, gotten her file. They could have gotten the evidence directly from her. That's a possible pathway for the defense getting it, isn't it? If They didn't have it initially, so they couldn't have provided it to Dr. Laposata, but the FBI had it. Okay, the defense is getting it from the discovery, so the defense is only getting what the prosecution is giving them. So if the prosecution gets the autopsy report, yoinks out these x-rays of the arm, and then passes it on to the defense, and that's what the defense gives Dr. Laposata, that's a possible reason why Dr. Laposata hasn't seen all this, and yet Rentschler had, and Rentschler is able to bring it out, bring it to their attention. But it didn't come from Rentschler, right? Because they already knew. I don't know, man. It's a mystery. It's a mystery, the path of those x-rays. We would love to know. Bobby Dredd, thank you for another day of excellent insight, analysis, humor, and umbrage. Thanks for being here with us. Tomorrow is going to be a little drier. Not so much drama with the jury instructions, but from the legal standpoint, it's a very interesting part, because this is the rules of the road being defined, right? This is defining what you get to say to the jury, what you don't, what the jury gets to do with that. So they got the information, but if the instructions limit what they can do with it, just ends up being a very important part of how you end up with the outcome that you end up with. At least if we assume the juries even pay attention to the instructions and follow them. And I have criticized the Massachusetts form instructions many, many times for being far too verbose. They try to say too much. It takes forever. Nobody's going to pay attention to all that. So we'll see. Probably less fun tomorrow, but I'm still going to be here. I'm definitely not going to miss that. Desert Quill, Bev gave the lawyers in her recent bench trial case 1.5 hours without them even asking, and that was a simple case compared. Another piece of good information. Why should it be so restricted? There's really no good reason. We got to be concerned about the jurors' time. It's going to take the time it takes. We've just spent 31 days taking in the evidence. What's another hour? What's another 2 hours? What's another half a day? It's nothing, relatively speaking. Good thing to know. I wonder if the defense knows that. Edward Foster, doesn't Hank have to present the DNA? He's not going to cure the issue. So apparently not. Apparently not. Don't know if he's just given up and is like, who cares? She's not getting convicted anyway. And even if she does, there's already 5 ways from Sunday. It's getting reversed on appeal. So why bother getting the dog DNA in? I don't know. The not dog DNA, the pig DNA. He's not going to cure it. And we already saw the objection to the basis. Bev didn't care, got overruled, came in. So Edward Kirkpatrick. So now no cure for Brennan introducing and asking questions about DNA, not in evidence. Way to go, Judge Bev. Yep, just added to the list. It's one more issue that's not getting fixed. Mark Lyon, no DNA. Nope, not in evidence. Cow's Dad. In new movie Friendship, Paul Rudd and Tim Robinson's characters play box in a garage. Won't spoil it, but evidence gives play boxing gone wrong, in my opinion. Well, maybe. I don't know. A cut over the eye is not play boxing to me. Like it's. I mean, I guess it depends on are you geared up? Things can happen, you can, oh God, we had, I'm having like flashbacks because maybe a month or so ago we're doing mitt drills at the gym and I'm working out with Heidi and, love that girl to pieces, but I have like probably 60 pounds on her. Okay. She's tiny little slip. I'm, 6 inches, maybe taller than she is. I'm a lot bigger. We just had didn't quite line things up quite right with who is where. It was the cleanest uppercut I've ever landed in my life. It was Tyson-esque, this uppercut that I landed. I felt terrible. I still feel terrible. I didn't mean to. I mean, she knows. It's just, it happens. Things like that happen even if you're play boxing. But how many times can that happen? Enough to cut your tongue, braid your nose in multiple places, give you an eye, an eye injury, hurt your hands potentially. We never heard any explanation for those bruises on John's hand. Isn't it his left hand? I can't remember now. Anyway. Yeah, I would say it may read actual boxing gone wrong, but I don't know. Could be. It could be something like this. As simple as just play boxing, the dog got involved maybe. I don't know. From the defense standpoint, all that matters is that we can imagine these hypothetical scenarios, because if we can't rule them out, they're reasonable doubt. We can imagine play boxing gone wrong. We can imagine real boxing gone wrong. Doesn't matter. We don't have to prove either one of these. Just the possibility that it happened. Stacy LeBruno, who had ham sandwich on their bingo card for today? I certainly didn't. Hank seems to be circling the drain. No rebuttal. I'm thinking the jury must be tired of his shenanigans too. Well, the jury said, Bev said what, 3 days ago, jury's done. Jury's ready to get this case. So maybe they are. Maybe they have heard enough. I don't know. I did notice from Sue's notes about the jurors, when they take notes, when they don't, and stuff like that. Far more jurors take notes when the defense is asking questions and presenting the evidence. When we're on cross-examination, far fewer jurors. We have like jurors starting to play with their hair and things like that. Jurors are low energy but attentive. Like the cross, it does not seem to be showing the same level of engagement as on the direct. But of course, it's very hard to say. You can't mind read. But just objectively speaking, looking at their conduct, yeah, if we take Sue's word for it, kind of looks like maybe they're losing interest when Brennan is doing his thing. I did not have ham sandwich on my bingo card. In wings, no rebuttal, no rebuttal, no rebuttal. Nope, we saw that coming. We saw. You've been snookered. You've been snookered. You got nowhere. There's no win. There's no winning situation for you putting Welcher back on the stand. The only question is, how badly do you lose? That was such a brilliant setup by the defense to jump on that. Sandra, is there a rat in the Karen Reed camp that snitched on Dr. R? If it was on video about what they were laughing about, denying the S&P, wouldn't Hank Brennan play it? Well, that's what I said. We already know that he, I don't think there's a rat in the camp. This is from the documentary. And, because they had the cameras following them around during the trial. And, gave him access to the defense team and the war room and all that stuff. So this is the documentary cameras. I would, be willing to bet. And Hank got the access to all of that original footage, the uncut footage. So they would have footage of the documentary crew filming inside the restaurant if that happened. But we never did get the receipts, did we? Of substantiating anything that he's implying that's on that video. We never saw it. So no, we don't know. Possibly the reason why it doesn't get played is because Rentschler didn't come out and deny anything. Yeah, if somebody said something funny, I probably did laugh. But if they had them on evidence talking about his specific testimony, it's just the physics or something like that. Physics is physics. I can't remember, the exact thing that was supposedly such a funny answer that they all laughed about. If you have that on video, yeah, you could play that. but he didn't, did he? Bev sitting on the scales. So Brennan didn't give the jury the facts, science, and data he promised in his opening. No, he did not. Can defense say the Commonwealth promised science, but all you got was blue grease paint and dress up? They absolutely can, and I love it. And you say it like that, and I hope they do. Commonwealth proved nothing. Yeah, they did. They did. The defense can go very hard with this. That the Commonwealth told you they have the facts, science, and data on their side, and it was a lie, and it's always been a lie, and we've all known it's been a lie. And the whole prosecution is based on that lie, because they don't. Even their own expert revealed that this is a lie. They don't, in fact, have enough information to be able to say anything at all. Our experts can look at this and say, there's enough here to say a vehicle collision didn't happen. Commonwealth doesn't want that. So that's why you didn't hear that from the Commonwealth. They can lean in hard on the commitments that were made in opening. It does go both ways. You know, you run a little bit of a risk. It does go both ways. Commonwealth can feed that back. Well, they said you were going to hear all this stuff from these other people. You didn't hear that. Does it matter? I don't know. I don't know at that point, but it was an important theme that they brought. He tried to organize his whole opening around this idea. We've got the facts, science, and data on our side, and Karen's statements are just a sideshow, just a little add-on, just a bonus. But as it turns out, as we knew from day one, no, it's a head fake. All you've got is I hit him. And that's why you started with Nuttall. That's why you opened your case with Timothy Nuttall, because that's what your case is really about. Don Huffman. Hi again. My concern is the defense didn't get to address the speed the Commonwealth is accusing Karen of going 24 miles an hour in reverse. How important is this or not? I don't know that it is. We can just adopt the Rentschler perspective of if there is no collision, it doesn't matter at all how fast she was going. But we can also point out that, you can make whatever arguments you want based on what's already in evidence, based on the data. We can already point out it was cold that night. There was starting to be some snow on the ground. Cars in reverse. You would expect the wheels to spin. You would expect that, and that, you wouldn't necessarily mean that you're going anywhere, but the wheels are spinning and that could register speed. They can make all those arguments that's the significance of the vehicle data. But I think bottom line that they're going to lean into is if there's no collision, it doesn't matter how fast she went. She could have reversed at 50 miles an hour in front of 34 Fairview. If she didn't hit John, none of it matters. We didn't get the key cycle. Nothing about the key cycle stuff either. At the end of the day, if she didn't hit John, it doesn't matter what key cycle she was outside of 34 Fairview on. Lucy Fair, Andrea, if you're the lawyer on a case, do you get a feeling about what the verdict will be at this point? Not a reliable one. Nope, you're not any better of a mind reader of the jury as a lawyer than you are just anybody else. You have your hopes and you have your wants, but as far as being able to reliably predict, you don't know what the jury's going to do. P.S. I'm working on a Dr. L clapback vid. Share it with me. Tag me when you do it. I can't wait to see it. That's going to be awesome. G-Force Lexus in the Sky. Thank you for recognizing Hank is valuable to shady clients. There are many in Boston. Betterow says he will behave well to protect his reputation. Betterow says Betterow will behave well, or Betterow says Hank will behave well to protect his reputation. I'm not sure. But yeah, this is what shady clients want, guys. And this is, I don't want to shit on the private defense bar unnecessarily. But this is the reason I went into public defense. It's the whole dynamic is very different, because we also have shady clients in public defense, but they don't have power over me. They don't have the power to direct, to influence, to try to undermine my integrity by putting me in a position where I have a personal interest in violating the rules, in lying, in doing shady stuff. The private clients do. You're dependent on that client. Much, much stronger incentive to keep them happy so they keep paying you. And that does not by any stretch of the imagination mean that any, private criminal defense attorney is shady. No, of course not. It doesn't mean that every private criminal defense client expects or wants the attorney to be shady. It doesn't mean any of those things. It's just a different dynamic that comes up. And so when you have somebody that's shady like Hank, yeah, you can expect there is going to be a certain market for whom that's attractive. They want that. That's exactly what they're looking for. They don't want the lawyer that's going to follow the rules and not lie. That's why they're hiring somebody instead of getting the public defender who has no incentive to sacrifice their integrity for this particular case. Occiput boner. She allowed no dog DNA as it was meant to be rebuttal. I know, and it's not in. So what, are we going to maybe talk tomorrow about striking that from the jury's consideration? Disregard that because it's not in evidence. It could come up in the instructions charge. But let's be real. Can they unring the bell? No. At this point, it might even just be better to roll with it. We know it's pig DNA. We know it's pig DNA. Pig DNA like you get in dog treats. Mm-hmm. Yeah. Mark Lyon, if the jury comes back with a 2-word verdict, how many times will Bev send them back to reconsider? I don't believe she can. That's once they come back with the verdict, we're done. We're done. She doesn't get to pressure them to try to change it. That would be profoundly and obviously unconstitutional. So they come back with 2 words on a piece of paper. Guys, we're all going home. And we are never watching this trial again. And that will not be a day too soon. Tammy Martin, the jury has to notice. Not one doctor said John O'Keefe was hit by a vehicle. How can there be a guilty verdict? We're making that point in closing. Find the defense lawyer. We are absolutely making that point in closing that not a single medical professional has been willing to put their reputation, their credibility as a professional on the opinion that anything about John is consistent with being hit by a car. Not a single one of them, even the Commonwealth's own witness wasn't prepared to say that. The Commonwealth can't produce a single medical expert to say this is consistent with a car accident. You better believe we're leaning on that in closing because that's a great fact. It's a great fact for the defense. Wonderful, wonderful set of affairs. So rare. Usually you have battles of the experts. You might have some expert that's just preposterous and ridiculous and full of pseudoscience or whatever. And you want to think you can just discount it, but it's risky to do that. So you got to call your own, disagree with it. They couldn't even come up with that in this case. Not a single medical doctor willing to look at those injuries and say, yeah, sure, that looks like a car collision. Only Yuri Buchanan. We had to see the body and then knew right away. Michael Proctor in his text, he'd been waffled. I don't know if I've ever seen a waffle. I mean, I've seen my dog eat a waffle, but don't think he just left. A few abrasions on the arm like that. Amanda Lang, extra sus because denied cross of Welcher on medical examination report. It was inevitable. They had to. Or are you saying the initial cross when they were trying to ask him about the basis of his opinion and they weren't allowed to get into that with Dr. Scortibello? I realize that's I guess what you're talking about. Yeah, good point. That is sus, huh? They weren't able to talk about. So they couldn't have crossed him on this if they wanted to. They couldn't have crossed him about the x-rays and Scorty Bellows file in her examination if they wanted to, because they didn't get to ask him about his reliance on Scorty Bello. He said, I didn't consider it, and so we're done. No questions. I totally forgot about that. That's a good point. I can't think that was deliberate, honestly. I can't think that was deliberate. Because if they know the defense knows, then they know this is coming in. I really think they thought the defense didn't know. And why would they think that? They might think that if they hadn't given them to the defense. And then the defense didn't give them to Dr. Laposata. But they got them from Rentschler. How did they find that out? Oh, I want to know. I want to know. I hope we get statement from Karen, interview, something like that. Desperately want to know. James Casatelli. Oh boy, can't wait to be glued to the TV for the Brian Kohberger trial now that this one is almost over. We have a motion hearing coming up in Brian Kohberger, don't we? I don't have my calendar in front of me, so I don't remember. I hardly remember what day it is right now anyway, let alone what day it is. I think it's the 16th. I think it's Monday. We're set for a hearing in the Kohberger case because the defense has moved to continue. They want the trial date pushed out. Possible some indication. We don't have an objection from the state. We don't have a written objection from the state. And there are some little hints in recent developments that suggest that the state might not push back on that. And the big one, there's been a lot of conversation about that we've heard in the recent court hearings. Brian is asserting that he has autism. He has some other conditions. Those affect his behavior. The defense wants to be able to bring this up, certainly in the mitigation case, but also potentially, if relevant, during the guilt phase. The state has contested that, but has also argued if they're going to raise mental health, then we have the right to have our own independent examination. And he's right, they do under the statute. But then you look at how the statute sets it up, and basically it says that if the defendant wants to present evidence of a medical or a mental health condition, then there's the court will appoint an independent person to come in and do a review. So it's kind of like you can do it, but we're going to have this second pair of eyes, I guess, on the analysis. There were just orders entered over the last couple days that are sealed, and we don't know what they are, but they sure do look like they could be that. They could be the order for an independent medical examination, basically. Independent psychiatrist or psychologist is what the statute requires. So it looks a lot like that is still going on. Prosecution could want to wait till that's done. Make sure that they have all that. They know the significance of it. They know what to make of it. They've incorporated it into their strategy. They've considered all of the implications before we are getting into trial, and time is getting very short. So I'm not 100% sure we're going to be going forward with the Kohberger trial. January 30th is when it's supposed to start. Jury selection is supposed to start. These are part of the issue. Defense is arguing ineffective assistance of counsel, can't prepare. You're making a record now. It's kind of a gimme then if we go through trial and he gets convicted and he gets, a death sentence. Just hard for me to imagine in this particular case getting a conviction, not getting the death sentence. It's just one of these cases where it's like if it's not here, then when? Then when would you do it? But I guess not impossible. But it's like a gimme. This record, it's a gimme to have a do-over because all the stuff that you aren't able to do, that you weren't prepared to do. So the conservative and cautious and careful thing would be to grant the continuance. Go ahead and yell at the defense as much as you want about it. It doesn't matter. It's not important. The defense attorney is used to being the scapegoat for everything that goes wrong. That's the job. That's part of the role. We already know, my client gets screwed at trial. The way for him to fix that is to win an ineffective assistance argument. We all know that. Not many people take it personally because that's just how the game is set up. Nobody's ever going to say, well, they do sometimes, but it's just a lot easier, a lot more willingness to point at the defense attorney, say that person messed it up and that's why it got wrong, as opposed to the judge made the wrong ruling, the prosecutor engaged in misconduct, and so forth. We will remain, wait to see what happens in Koberger so far. But that is the next big one on the horizon, certainly for me. Sandra, I think ARCCA gave Karen Reed the FUHB discount. Maybe. I don't know. Honestly, you typically charge a little extra for the asshole premium. Okay. We got to upcharge this one because of the wear and tear on my emotional regulation system. Having to deal with an asshole like that. Transient man. Part of me wonders if Hank was too dumb to understand why ARCCA was right until they spelled it out for him. He probably knew, but he seemed defeated. Well, he did seem defeated. I think he knew. I just think maybe he didn't think they'd have the balls to say it or something. I don't know. Dr. Laposata did. Sure did take the wind out of his sails, didn't he? Just took the wind right out of his sails. And now Dr. Rentschler repeating it over and over and over again. No collision. The medical doctor, the forensic pathologist says so. You got the other forensic pathologist saying, I've seen thousands of dog bites and these are dog bites. You got Dr. Rentschler saying, no collision here. Nothing consistent with the collision. You got Dr. Wolf saying taillight damage. Even at like the highest speed testing and stuff that we did beyond what's shown in the vehicle data, we still didn't get that degree of damage to the taillight. With the whole broken diffuser, we like smashed in the whole back of the SUV and the lift gate and all that. Still didn't get the damage to the taillight that shows up in the sallyport. So a lot of reasons for Hank to be defeated. I think he knew the whole time. He just thought he was going to be able to, come in and out-lawyer it and get the win. Zach Smith, if Karen Reed found not guilty, will anyone continue to investigate who did this, or will this all come to an end with no justice? Another $1 million question. Pardon the slurp. I might pause real quick to go refill my tea. This is $1 million question because if she's acquitted, the case is still open. The case isn't closed. We haven't held anybody accountable. But very common reaction in the situation, especially when they've doubled down like this. They've gone all in on this theory of what happened. Is they just, the story they tell themselves, well, the jury got it wrong. Jury got it wrong. We know she really did do it, so no point in going and doing more investigation. It wouldn't lead us anywhere because we already know. We've decided. Jury just got it wrong. I wouldn't be surprised at all if that's what we see. In fact, I would kind of expect that. It's just that's consistent with the approach that they've taken to this all along. They've never been willing to consider alternatives. So why would they consider alternatives now just because they got their ass handed to them at trial? No, I think they just say the jury got it wrong, which is sad, but that's just how it goes. All right, guys, I am going to pause real quick. We got just enough in the queue still that I want to go and refill my tea. I'm starting to lose my voice a little bit, so make sure I can get my hydration back up. I will be back momentarily, guys. Thanks for hanging tight. All right, guys. Thanks for hanging tight. Oh, I feel so much better. The energy, the life just comes flooding back with just a little bit of silver needle white tea. Just what the doctor ordered. I'm telling you, the stuff is fantastic. I'm on like my third brew of these leaves, and you still get just a little hint of, I describe it as roasted honey. It's like roasted honey. It's what I imagine roasted honey would taste like. Someday, maybe I'll try roasting some honey and see if you get that. Maybe smoke the honey. Maybe we could smoke some honeycomb. I bet that would be phenomenal. Sounds really good. Let's get back to you guys. Enough about me and my tea. Daniel Boone, Lucky, Barrows, Crash Daddies, Dr. L, and Dr. Russell. They all dismantled the Commonwealth. I'm confident the jury gets it. I think they get it. It's just, do they want to? Do they want to get it? That's always the question. If you don't want to get it, you can be amazingly acrobatic at avoiding getting it, finding ways to not get it. But they really did, huh? The only one that really got, I think, dinged by Hank at all was Barrows. Barrows with the memory. Don't know how significant that was, but even with that, still the whole rest of them, no John on the yard. Taillight is not how it was in the sallyport. Taillight wouldn't have been broken by this type of collision. John would have received far worse injuries from this type of collision. John's injuries are not consistent with being hit by a car. John does have injuries consistent with being hit by a dog. It's hard not to see that as game over. It's just you never know what a jury will do. Catalina, I'm not being funny when I say I have no idea what the Commonwealth's case is. How did he get hit? You said paint time didn't matter, so what did you prove? This is Hank. Just again, he's trying to have it. He's trying to have it every which way, that if we can't prove an accident happened, we can still just kind of assume that it did. But you can't. That's the whole point. If you don't know why his phone stopped moving, there's lots of explanations for why his phone stopped moving, including but not limited to he put it down. Pretty common reason for your phone to not register movement. You put it down. One possibility. I mean, no, of course you're not alone in not knowing what the Commonwealth's case is. They made that the point that we don't know, but that's a defense case. That's not a prosecution case. We don't know is not a prosecution case. You don't always have to show how. You really don't always have to show how. I mean, I'm thinking of cases where, missing body murder cases. Great example. You don't have a body. You don't necessarily know how stuff happened. You can't necessarily, present a mechanism, but it doesn't necessarily prevent you from still getting a conviction. But you got to have a lot of other evidence. So the missing body case I had, guy is hanging out with drug dealers at a drug dealer house. He goes missing, and the drug dealer house has a big garage on it, and the landlord, I think it is, goes into the garage at one point, within a couple days or something like that, and there's blood, a massive amount of blood all over this garage. People, the drug dealer people tell him that they'd gone deer hunting, got a deer. It was a deer. But then there's other people had heard, really disturbing noises that night. Somebody ends up with the missing guy's dog. There's a lot of circumstantial stuff. Oh, and you know, of course, it's the last place he went. Somebody dropped him off here at the drug dealer's house, and he's never seen again. So, you know, you have enough little pieces like that. You don't necessarily have to prove how it happened, but you got to have a lot of other stuff like that. If they had a tighter chain of custody, better documentation, better evidence of the taillight, the debris field, that might be enough. It might. It's always, you know, keep saying it from my perspective, weakest point, you know, it's the hardest thing for the defense to have to counter the taillight, because you really got to kind of buy into it was planted. At least consider the possibility it was planted to, you know, neutralize that particular piece of evidence, because the circumstantial implication, if we knew for certain these pieces, this lawn here, not here before, we've got all that locked down. The inference is strong. If it all fit back into Karen's taillights, the inference is strong. So you got to be willing to entertain so it was planted to get around that. Much easier to entertain that when we just have a, you know, zero chain of custody and a bunch of stuff that ends up in Proctor's hands. If we had it locked down more, maybe that would be enough. They wouldn't have to show how. People would just be satisfied. I don't know how, but it did. Because here's all the taillight came from Karen's taillight. No other explanation for how that would happen. But because they didn't lock it down, there's a lot of other explanations for how that happened. So I know I don't think anybody knows what the Commonwealth's theory is here, because they're trying to, on the one hand, say, we'll never know. There's just too many variables. We couldn't possibly know how this happened. But at the same time, we're just going to assure you that it does. And it's just like Rentschler pointed out, those things don't align. You got to have a lot stronger information than that to try to tell us, you know, there was an accident, if you can't tell us how it happened. Scooter 54, the defense buried the Commonwealth, in my opinion. Well, definitely in my opinion. If only I were on the jury. I agree with you there. Melissa Garcia, Welcher wakes up in a rush to get to court in the AM. We could hope he's sprinting over. He's already on the plane from Los Angeles. That's not a fun flight, that cross-country flight. It's actually worse going home. Going west takes longer than going east. Wouldn't that be too bad? So sad. John Beattybot, can defense mention A, pig DNA? It's in evidence. B, hoodie 9-hole versus 36 abrasion. It's in evidence. Hoodie cutting. It's in evidence. X-ray mystery. They can point out the conflict. The whole like chain of custody issue. Where did the things go? That's not in evidence, so they can't bring up. But the fact that Laposata had them and they are the X-rays, but Welcher didn't have them and said they didn't exist, they can definitely bring up that discrepancy. Bumper glass, yes, etc., all as intentional deception. They can argue that it is. Absolutely. May not be the strongest thing for them to do, because they don't have to prove it, but they can definitely point out, you can't rule out intentional deception. Very much a possible interpretation of what you're seeing here. It's not the only one. It's not a necessary one, but it's a possible one. And that should give you real pause, because a credible investigation shouldn't leave you with any questions like that. Shouldn't even be on the table. Heather S., as a lawyer, how do you handle doing so much work and then most of it goes unused? Witnesses not called, motions dropped, evidence excluded, etc. It's just part of the job. You just got to roll with it. I'm telling you, this is nothing compared to the gazillions of times as a defense lawyer, you have prepared your case for trial and you show up the day of, and the prosecutor has finally seen the light and decided to dismiss your case or, get it down to the misdemeanor that you've been negotiating for the last 10 months, stuff like that. That's routine. That happens all the time. Put in all your time. You've litigated, you filed your motions to suppress, you filed your motions in limine, you've done all this preparation, you've got your subpoenas out, you've conferred with your witnesses, you've hired your experts, and you show up for the first day of trial and you use none of it. That's common. It's just part of the process. It's part of the process. A big piece of it, I think, mindset wise for the defense lawyer is your success isn't gauged by the outcome that you get. It can't be. You're set up to lose. If everything in the system is working correctly, you should lose because they've got the evidence, they've got the right person, they filed the right charge. So what do you have to work with? If the system is working right, all of those things are happening. So you would lose every time. So you can't get too attached to the outcome, especially in public defense, because just so much of that is beyond your control. It's not your choice whether to go to trial or not. It's not your choice what the evidence is. So all you can really focus on is your own effort and your own contribution, and you gotta gauge your performance by how well did I perform compared to my own expectations of what's good, what's professional, what's ethical, what's well prepared, all that kind of stuff. And so none of that changes just because you don't end up going forward to trial. You still did the work. And that's really what your job is the defense attorney, to do the work. What happens after that? It's nice to win, but some cases aren't winnable, and some cases you shouldn't win. And that's just part of the deal. So pretty normal, honestly. Do all the work and then it goes to nothing. It's honestly pretty normal. Darlene D., is it possible Welcher told Hank Brennan he wouldn't come back because he would be made to be a liar? Well, of course, we know there's been no violation of the sequestration order. So, of course, Welcher has no idea that these x-rays even exist, let alone that they are in evidence and waiting to impeach him. So, no, it couldn't be that. Of course, it couldn't be that. Certainly, there's no violation of the sequestration order where he would find those things out. I don't know. Maybe this is part of Hank's judgment call. Like I was saying the other day, I wanted the defense to call Yuri so much to read those Proctor texts because I wanted to see his little brain struggle with how to handle both pretending to see these texts for the same time, but also, the texts don't change his opinion whatsoever about the integrity of Proctor and the investigation. How is he going to be able to navigate that? Could be a very similar situation with Welcher. How are we going to pretend he's never seen the x-rays before while also simultaneously indicating that the x-rays have no bearing at all on his opinion about whether John was hit in the arm by the taillight? It's a hard little ledge to straddle there. Highland boy. Does no longer calling rebuttal witnesses have bearing on first motion to dismiss, given it no longer comes in, but it is in from Hank's BS re-dog DNA? The dog DNA is a messy loose end. It shouldn't have come in. It was going to be cured with rebuttal, but the dog DNA or lack of dog DNA in and of itself is not going to be the reason why the initial motion was denied. The initial motion is denied because the standard is so permissive. It's basically, has anybody shown up and said, I think this happened? Yeah, well then it's going to probably be enough, to go to the jury. So even if Welcher is completely lacking in credibility, even if he is wrong, it doesn't really matter because the jury is going to look at all of it under the standard, the motion to dismiss standard. You look at all of it as though the jury is going to decide all those issues in Hank's favor. So if there's a dispute about dog DNA, pig DNA, what the significance of that is, it doesn't matter. You just infer that it goes in Hank's favor. So no dog DNA. Is that like the turning issue of the case? Not really. Not really. It would be helpful for the defense if there was dog DNA there. But the absence of dog DNA really doesn't prove anything one way or another. Certainly doesn't prove he was not bit by a dog. So no, I don't think this goes back and affects the first motion to dismiss. But we'll see what Mr. Yannetti says tomorrow when they renew the motion. It's not going to be extensive. It'll be pretty fast. But we'll see if this comes up, if that's part of the defense thought process anyway. A Sparky 2, will you sing Happy Birthday to Kai? Happy birthday to you. Happy birthday to you. Happy birthday, dear Kai. Happy 10th, Kai. Happy birthday to you. There you go. Happy birthday, Kai. We got a couple new members here. Susie Q is a new member. Gwynn's Teddy is a new member. Guys, welcome to the channel. Thanks for joining us. Lula Bella, I hate to be a note-passing conspiracy theorist, but when Alessi and Jackson were discussing the evidence, the gal to Lally's left passed a note. I saw that. She handed a note up to, looked like Clerk Jim. Indeed, I saw that also. Didn't call it out, didn't say anything about it. Don't know what it is. Don't know if it's significant at all. But yes, I saw it. I saw it handed up. McLaughlin handed what looked like the clerk a pink sticky note. Good eyes on you, Lulabella. I also saw it. Josh H. Question that has been bothering me. If Lucky saw a Ford Edge by the flagpole around 3:30, wouldn't the people who parked it there have seen John's body if it was there? Yeah, of course. Of course. The Ford Edge should be, really critical evidence to law enforcement. They should be extremely interested in interviewing whoever that Ford Edge belonged to, because it wasn't there and then it was. So it appeared at a time when John should have been out there. You would want to talk to those people. And yet, we saw what reluctance there was to even talk to Lucky. Because we didn't call Michael Proctor as a witness here, we didn't get to admit that part where he lied about, had it wrong last time. I remember last time, I think I mentioned this. I was thinking it was Louis Jutras that was a DPW guy, but he's not. He was the city video guy. Michael Trotta. Michael Trotta was the name of the head of the Department of Public Works. Michael Proctor wrote a report. Forget when, but not long after February 2022. Says he went and talked to Michael Trotta and was told that they didn't plow 34 Fairview that night. Wrote it in a report. And Michael Trotta testified at the last trial. No, in fact, they did, and sent out the call and everything you've heard as far as Lucky being assigned to Frankentruck and going out and plowing 34 Fairview and all that. So another lie by Proctor about all of these circumstances around the early morning hours and Lucky and the plow and the Ford Edge. They didn't even want to, they preferred to lie about the plowing then talk to Lucky at all. And then once they finally, like a year and a half later, get around to talking about Lucky and he tells them about the Ford Edge, they don't do anything with that. So it really does tell you everything you need to know about the purpose, the objectives of this investigation. It was never to find out the answers. Kelly, rescue Randy's personal injury advisor. You and Nick need to team up. Nick needs to advise him on his rights as an employee here of ARCCA. Hank isn't doing rebuttal because defense doctors have made it impossible that Cross isn't going to be more negative for him than his direct was positive. I mean, it's just hard to know. He's not finished on a strong point, has he? Both of these last two witnesses. It would be better if he had never gotten up on Cross. If he had never gotten up on Cross with Dr. Rentschler, we never have Dr. Rentschler saying, I don't think there was even a collision. Same with Dr. Laposata. It's only because you got up on Cross that stuff got elicited at all. You were better off just not even getting up. So it seems like he's maybe seen the light and recognized if I'm not going to get more out of calling Dr. Welcher than I stand to lose by calling him, I should just not call him. Yeah, that's right. That's a sound strategic decision. Even if it's self-interested because you know he's going to throw you under the bus. Well, I wasn't given those by the Commonwealth. Oh, no kidding. No kidding. How intriguing. Wonder if that would cause any grave concerns. He's smart enough to figure out that's a big downside. If Welcher gets on the stand and says, oh, that was Hank's fault. He didn't provide me with that information. He told me it didn't exist. Hank lied about it. Very hard to have enough positive to make up for that. Josh H., do you think jury will want to come back Monday? They will. Well, I mean, chances are pretty good they will. You know, I'd love, of course, like anybody, I would love a fast verdict. I would love the jury to get the case by lunchtime on Friday, go back into the deliberation room and, you know, fill out the form and turn around and walk right back out. Give us the verdict, go home and go back to your normal lives. I would love that, but it's just not likely. It's just not likely. If you're Vegas setting odds on the time of a verdict, it's unlikely to be fast. Not impossible. Definitely not impossible. Just happened with that ASAP Rocky case. It can happen. But it's just, you know, you can't really predict that that's going to be the case. This has been long, 31 days, a lot of evidence, a lot to go through. Not sure everybody is going to be walking back into that deliberation room with the same general inclination to start with, you know. So I don't think they'll necessarily want to, but they may just kind of have to. It's deliberation. Takes as long as it takes. The Mad Mystic, how likely is Bev to set aside jury decision? It's a fear I can't get out of my mind. Sorry if it's already been asked. It is okay. It's a common worry I know that people have. She has no legal basis, no authority whatsoever to throw out an acquittal. She can't. She can't do that. The worst that she can do would have to be before anything like that happened, you know, the whole like removing friendly jurors and stuff like that before they get to a point of an acquittal. Stuff like that happens. We'll be watching it very closely to understand it and what, if anything, it signifies. But in terms of jury comes back with a not guilty and she says, I don't accept that. No, you really can put that fear out of your mind. I know that law in general and rules in general don't govern Bev and what she does. This one is just far too fundamental and too basic. She would get, you know, writted in a second if she did something like that. So no, it's not going to happen. You can be comforted. It's not going to happen. Nordic Phoenix. If Hank Brennan's law career tanks after today, he has a promising career in digging ditches. He's really good at digging holes. He can come dig some post holes. He dug himself some huge holes in the past 2 days. Put him on a road crew. I'd pay to see that. Rolling floor laughing my ass off. Yeah. Really good at digging holes. You know, he could also potentially be like a chef of some kind, because I think he's getting a really good taste of his foot. Starting to really pick up some nuance of that flavor. He did. He dug himself massive holes. So much of the damage was it's self-inflicted. If you didn't have anything to bring out on this cross, you shouldn't have got up in the first place, and you definitely shouldn't have gotten up and been assholes to these people and inspired them to then go ahead and hand your ass to you. If you had been nice, they probably would have been polite and nice back, but you weren't. So karma, man. Karma. Patty Garner. Doctors Rentschler, Laposata, Russell, and Wolf were the stars of the defense. Yeah, I mean, the experts really did, the defense experts. I sure do love me some Lucky, though. I really did. I love Lucky. He's just so endearing. You know, he just comes across as so sincere. He answers straight, answers fast. He's not thinking about it. He's not waffling. He's not, you know, critiquing your question in his mind. Just there to tell you what he knows. I really liked me some Lucky. Josh Finnis. I lost faith in jurors after the Zachariah Anderson trial. It's very easy to lose faith in jurors. Delphi, another good reason to lose faith in jurors. I get this. That's why I say may look like a slam dunk, may look like they've buried the Commonwealth, but you never know what the jury's going to do. You just never know. You really don't. You know, we tend to want to assume good faith, average intelligence, all of those types of things, willingness to be unbiased, all of that stuff. Those may not be fair assumptions. They may not be fair assumptions. James Cassatelli. Yeah, but Hank will have lost the 2 biggest cases in Massachusetts history. That seems like a bigger career killer than anything. Should have been done after Whitey Bulger. I have to be fair to Hank. There was no winning Whitey Bulger's case. You know, there was no winning that case. They had him, you know, 10 ways from Sunday. The only win to be got from litigating that case was to, you know, try to rehabilitate his reputation, since now he's outed as a snitch. That's all you're fighting. That's all you're fighting. You can't get him off of the murders and stuff when you got, you know, Flemmy talking about 50 of them or whatever. I mean, it's just not going to happen. But the snitch, that's what he was worried about. And as it turned out, probably for good cause. As it turns out. So I do want to be fair to Hank. Probably no winning the Whitey Bulger case. That's just not a realistic standard. But this one, he took it on purpose. You're the prosecutor. Everything, you know, institutionally tips in your favor. You really thought that you could take this shit fabricated case and polish it up, and that you could get a win out of it. You'd be the one to do it. I'm definitely going to hold not winning as a prosecutor against you a lot harder than I'm going to hold not winning as a defense attorney against you, particularly in a case like Whitey's. Melissa Garcia, I bet Dr. S secretly sent them after hearing Welcher say that she didn't do her job. Oh, Scorty Bello. What has been your favorite moment so far? Mine is your mom, Hank. Oh man. I mean, I think it was, I've had 2 favorite moments. One was Jen McCabe cross-examination. Do you deny it? Ah, angels from heaven, angels from heaven. They sang, the clouds parted, the sunbeam came down. I just was waiting for that. I was waiting for that. It was what that cross needed. We got it and it worked. Oh, it was wonderful. I loved that. And then I think Dr. Laposata, there wasn't an accident. I don't think there was an accident. The very first time she got that out, just hamstrung him. It was just like drawing a sword right across the back of his hamstrings. He just collapsed. He never recovered. Really didn't recover after that. I think those are probably my two favorite moments. But I'm glad you enjoyed little little fun with Hank's mom. Probably too many people have had their fun with Hank's mom. Sal, why does forensic integrity seem to have no place? Deep policy question. It makes it harder to convict people if you require forensic integrity. If that were like the bar that had to be cleared, it would be harder to convict people. That might be the cynical answer, but it's really the only one I can give you. Can somebody give me a reason why we shouldn't require stringently high quality science in criminal courtrooms? Anybody got a reason why that shouldn't be the standard? If it's not the standard, then it's because they don't want that. They don't want that. And if that's not what they want, there's a reason for it. Obvious reason. Doesn't give you the outcome you want. You want to convict people. Sal, like for disgust of solo cups. Yeah. I mean, honestly, the solo cups are they're not good. Of course they're not good. But again, they're like one of the lower level offenses that I take in all of this. It's just hilarious. It's hilarious. Like that's what you thought was a good idea. But as far as like what's actually offensive, it's really the lack of the chain of custody. I'm just going to have all this stuff and not secure it. And you have to take my word for it. Coming from these cops, that's what I find most offensive. And of course, garbage in, garbage out. The reliability of the forensic process is all downstream from what you did with that evidence. That's why Dr. Rentschler was saying, well, how much credit I give it, how much I consider it depends a lot on, what it is, but also how was it collected? How was it handled? Is it reliable? So all your conclusions flow downstream. Hasn't been proven to me that Proctor couldn't have just, taken that T-shirt of John's down to the sallyport with them, and after he busted out a few pieces of those taillight, and you got a few little shards on the floor, just go ahead and use the T-shirt to wipe it up. If the T-shirt had been booked into evidence and secured, and a chain of custody is to have established, I could rule that out. But I can't because they didn't. I'm supposed to just take Michael Proctor's word for it. That's what I find offensive. Michelle, I assume John was mortally wounded in the house. What could the people in the house be charged with if he died there, did not call for help, and move his body? It's a lot of it depends in the situation. It just depends on the circumstances. Not providing the criminal assistance, not providing the medical assistance, knowing that he's mortally wounded is very likely a manslaughter charge. It's not a murder. It's not you're not doing something intending that he die, but you're willfully disregarding the risk that he will die if you don't act. So we're probably talking about a manslaughter type of a situation, moving the body. Obstruction of justice, desecrating a corpse, stuff like that, potentially on the table. A lot of it depends. Criminal charges always really depend on the details, but just generally speaking, those are the types of things I would be looking at. Just Jim, we know not much can or will be done to Hank and Bev. If Karen is acquitted, do you think Morrissey or others will bring Hank before the bar? Is he the patsy? Interesting theory, interesting idea here. Is Hank the patsy? That would require Morrissey to bring him before the bar. I don't know. I don't know. Is that risky for Morrissey? You know, bars will investigate. They'll do their own investigation, but you have a prisoner's dilemma problem. Okay, you go and try to make Brennan your patsy, throw him under the bus. What's his incentive now to not out all of your secrets? Same as the risk of calling Michael Proctor. He's got nothing left to lose at this point. You call him. Why is he going to save you? How's that in his interest? So I'm inclined to say no. No, there would not be something like this happen because it's too risky for Morrissey. If you turn on Hank, Hank will turn back on you. He's the patsy in the sense that he will be the public face of the failure. We'll be able to point to him. Heats off Lally. Lally's come out of all of this probably the best at the end of the day. Ironic. Not necessarily deserved either. But I think that's really it. He'll just be the public face of the inability to convict Karen Reed. It's on him. You know, if she gets acquitted, he came in, he was arrogant, he thought he could win, he couldn't win. So in that sense, I think he's the patsy, but any like material sense, I don't think so. There's too much risk for everybody else. Old twat on the bench. Has Karen Reed filed suit against Proctor? Not to my knowledge. Not to my knowledge. Should she? I'd love to see it. Sure would. Sure would. We didn't get into the ins and outs of qualified immunity and, you know, all that, how difficult that is to prove. Cops get qualified immunity. But, you know, even over here in the state of Massachusetts in the First Circuit, it's probably well-established federal law that planting evidence, fabricating stuff, lying in police reports, these are all well-established constitutional violations. So just the lying in the reports alone. I'd like to see it. I haven't seen that it's happened, but we'll continue to watch. That would be a fun sequel, wouldn't it? Fun sequel to all of this. Karen Reed, the civil case. Van Helsing. Hello. Regarding the FBI, this is a state case. They only have the power to investigate civil rights violations in this case. Any delay is likely due to waiting for an outcome in this trial. You're absolutely correct that the FBI does not have any sort of independent jurisdiction to investigate murder as murder. It's not John O'Keefe's murder in and of itself that they're interested in. They are investigating something else. We don't know what it is. Public corruption is probably the best guess. Probably the best guess. And yes, abstention doctrine, very strong policy to not interfere with state prosecutions by the federal government. Wait for it to be done. Very possible. Can't say that's not what's happening. Can't rule it out. Bev sitting on the scales. Do you think after every cross when Hank sits down, Lally mutters to him, "Great cross if you were on the defense team"? Hot shot. Oh, he should, but no, that's way too clever. That's way too clever for Mr. Lally. He's just sitting there like a lump. He's sitting there like a lump. I'm just here so I don't get fined. He's getting paid either way. What does he care? He just gets to strut a little bit more when he actually has a role to play in this particular trial, because he gets to boost his confidence. Confidence might have been a little shaken after he couldn't get Karen Reed convicted, but boy, watching this guy flail even harder than he did? This guy who's supposedly so smart and so good. Look how hard he's flailing. Yeah, that'll put wind into old Lowly's sails. But this particular comment, I think, is probably too clever. Deborah Gelsey, do you think Hank's contract pay depends on the outcome? No. No, I don't. He would never do that. Now, there could possibly be like an anticipation of, I don't know, a bonus or something. Might not be ethical to put that in a contract. Not really sure how that would work with the prosecutor. Because the problem is, as soon as you tie incentives to the outcome, or as soon as you tie benefits to the outcome, you create incentives to getting that outcome. So even with things like contingency, pay depends on the outcome in a contingency case. Very few cases where you're allowed to do that. There's a lot of, a lot of states, you can't do it in criminal cases. You can't do it in other types of cases. It creates very bad incentives. But not only that, it's just it would be a terrible structure for Hank. It would be an awful deal to strike. Absolutely not. You're getting paid by the hour. Regardless of the outcome, you're just getting paid by the hour. And then the rate is where you make up that room for I'm better, so I'm more likely to get a good outcome. So you pay me more per hour. Almost certainly an hourly contract. I can't wait to see the contract. Is it out there? I don't think it's out there. Not all of them anyway. Yeah. I'm very interested in seeing that. So jury instructions tomorrow, guys. I know it's not going to be the most thrilling thing, but I am intrigued to see, are we coming back to this cautionary instruction about the sweatshirt? And are we going to have to do anything about the fact that Terry Kuhn did not testify? So this absence of dog DNA isn't actually in evidence. Is there going to need to be something relating to that? Very interested in seeing the arguments about missing witnesses, etc., missing evidence, anything like that. What's the defense's basis? What's their argument? Is she going to consider it or not? Boo Crew, I've heard Higgins has signed a proffer. So this is a piece of information that has been, it's speculative, but it has been out there since before the first trial. And I'll tell you where it came from because I saw this. There was a pretrial hearing with the 2E right after the 2E materials were provided to the parties in the case. So before the first trial. And David Yannetti is addressing the court. He's talking about some of what is in these 2E materials, and he's making reference to a proffer involving Mr. Higgins. And nobody knows exactly what that means. Okay, he didn't spell it out. He didn't get real specific. It's just that when you're talking about a federal investigation, the word proffer has a very specific meaning. It's a very specific meaning. It basically means you cut a deal and you've provided information to them as part of the deal, and you're getting some benefit in exchange. I mean, that's like the 10,000-foot version of it. Proffer is typically, I'm going to tell you whatever you want to know. I'm going to get a limited type of immunity for it. You can't use my proffer against me. But, maybe you can use it for other purposes. Maybe you can compel me to testify consistent with my proffer, stuff like that. So it has a very specific meaning in this context where it seemed to come up. And David Yannetti is a longtime criminal defense attorney. It just seems very hard to believe that he would use a term like that and not know the significance or just use it very cavalierly. So that's where this idea of Higgins signing a proffer comes from, is from that choice of language that Mr. Yannetti had when he was describing the 2E materials to the judge, and he used the term proffer. Because we're talking about a federal investigation, it seems to mean something, but we don't actually know. And we don't know anything else, about it. We don't know circumstances. We don't know if there was a deal. We don't know if Higgins was being investigated for something. We do know that Higgins testified in the first trial. and didn't say anything about it and didn't plead the fifth or anything like that. So it just didn't come up or get explored in the first trial. We didn't learn anything about it. Really don't know what all that means, but that is a piece of information that's out there. Well, we get an extra hour tomorrow. Always nice. Always nice. Of all the things to complain about with Judge Bev, I'm never going to hold her desire to sleep in and take long weekends and stuff against her. I'm going to hold it against her when she, is blaming the defense for running out of time after you've had lots of late days and long weekends and early finishes and so forth. I'll hold that against you. But in and of itself, giving us all a break, not necessarily having the strongest work ethic, I'm not going to hold that against her. I kind of appreciate Bev's holiday schedule. I didn't mind at all having 5 days over Memorial Day. That was kind of awesome. So I'm not going to complain about a little bit of a late start tomorrow. Extra day for the jury. They don't have to show up at all. Charge conference, very unlikely to go all day. Tends to be pretty routine. They'll have these other issues that they need to sort out, but otherwise tend to be pretty quick and dirty, and there's just a few points of disagreement that have to be fleshed out. So we'll see how all that goes. I do always enjoy the charge conference. It's probably a lawyer thing, a very nerdy type of thing. See what they're going to be told, but it's a part of the process for sure, and it's an important one because it is going to guide the jury in what they get to do once they are finally free to go back into the jury room, look at all the evidence, talk about it, and start coming to a consensus about what they think. So I'll be back tomorrow, slightly less bright and early, 6:45 Pacific. Love it. Not breaking my heart at all with that. Hopefully plenty of you guys will join me as well. Rush to judgment. Hank forgot the first rule of prosecution opening: under promise, over deliver. Where are the facts, science, and data? Seems like the defense has it all. Yeah, managing expectations is a really important part of being a lawyer, especially a criminal defense lawyer. It's one of the things you learn very early on. You got to manage your client expectations because they get real pissed if they start to feel disappointed. And so you learn things like very simple things. People hear what they want to hear. So be very, very careful what you have to say. If the defendant asks you, what's a possible sentence that I'm looking at? And you say, well, if you don't have any priors and, there's no aggravating circumstances that are found, the standard range is going to be 3 to 10 months. But you could get an exceptional, up to 5 years. Or if, that could change if you've got other priors and stuff like that. Have that conversation. What the client has heard, 3 months. That's what the client's heard, 3 months. They've heard the best part of that answer. So you have to be very, very careful with your communications because you got to manage the expectations and you cannot overpromise. You learn that real quick. So very good advice here. Under promise, over deliver. Don't commit to giving them something that you can't follow through on. Let them be pleasantly surprised that you have an even stronger case than you represented to them. Should have learned that in defense too. This isn't just a prosecution opening. This is anybody's opening. Manage the expectations because they're hearing what they want to hear from you, and that's the standard they're going to hold you to. So be very, very careful about what kind of expectations you set. All right, guys. 10:15, not our longest day by a long shot, but hey, it's momentous. It's momentous. We wrapped up the defense case. They haven't formally said the defense rests, but they'll do that Friday morning, very first thing Friday morning when the jury is in. Defense will rest. Hank will get up and say no rebuttal. And the court will say, it's now time for me to instruct you, and we will move on to that. Actually, it's closings. I forget. In Massachusetts, they do closings before they do the instruction. It doesn't always go in that order, but in Massachusetts, it does. They close and then they instruct. So Friday, if you don't feel like joining us for the jury instructions tomorrow, because it's not going to be that dramatic, I do encourage you to, because it will be interesting, and it actually might be dramatic. We'll have to wait and see. The jury's not in, so, lawyers have a little more liberty to say what they really think. Some of the reactions they've had, some of the perspectives they have on what needs to be done to even the playing field, level the scale, so forth, that might get aired out tomorrow. So just a little different drama potential than you have with witnesses on the stand. But even if you can't make it tomorrow, Friday arguments, cannot miss that. That's going to be fantastic. So guys, appreciate you all being here. I appreciate having gone through this journey with all of you. This second trip through the Karen Reed trial. Lo and behold, the case has not improved with time. Case has not improved with time. Case has not improved with the new prosecutor. Case has not improved with new accident reconstructionists. 500,000 plus down the drain. It's probably a couple million they'll pay on this when all is said and done. 500,000 just to Aperture. $250,000 to Hank, maybe more. All the personnel cost, all that stuff. Hasn't improved the case at all. So having all of you on this journey has really been wonderful. It's been fun. It's been enlightening. It's been a great resource. I don't remember everything. I love that when I just, I can't remember something, somebody in the chat knows it. I completely lose the word, and here's the chat to let me know. Lividity, Andrea, you're looking for the word lividity. Yes, I am. Thank you, chat. Here to laugh at my stupid mom jokes, guys. I know it's juvenile humor. Of course it is. It's funny. Some things are always funny. But it's just it's just a good time. It's been a really good experience, and we are getting close to the end now, so just important to stop and appreciate how you guys have cared. You've seen what's happening. It matters to you. Matters to you that this thing that we've been watching here, this circus, it's not fair. It shouldn't be this way. It just really is music to my ears to know that there are so many people who look at this, see it, realize it, and care about it. Care about it. If we care about it, we can change it, guys. First step is seeing it. Second step is caring about it. And then we can change it. So very, very heartening to see the attention and interest that so many of you have had, and just the wealth of knowledge that you've brought to your perspective. Really, really a fun thing. Thank you to the mods. Appreciate all of you so much, helping me out, keeping things running smoothly. You got the good information. You got the links. Keep us on track. Really couldn't do any of this without the mods. Jeff, appreciate you, Jeff. Thank you for being here, sharing all this time in different rooms together on the internet. It's it's a good experience too. Tribal Girl wants to know what's the next case you're going to cover, FKR. The next case that's been on my docket, my radar is Koberger. So that's the next one up for me. The question is just, when is that going to happen? We've got a motion to continue that is pending, should be heard Monday. I hey, might even be able to watch it depending on where things are at with Karen Reed at that point in time. It's been a while since I've been able to live watch a Koberger hearing. That's the next one on the horizon for me. After that, not sure, guys. Not sure. Not sure. Had some thoughts about some different things. I'll just tell you right now. One of the things I've been thinking about is potentially taking a little bit of a break from the high profile case coverage. There's a few reasons for that. It takes a lot of energy. It does take a lot of time. It takes a lot out of me. I need to take a break after I've, dedicated 2 months to a trial, a lot of hours, a few hundred hours. Need to go back and do those life activities that feed you and refuel you, So I definitely need to make some time for that. But besides just my kind of self-interested reason, you guys, the high profile cases are such a small part of what happens in criminal justice, and they aren't necessarily representative of the rest of the system as a whole. And so the high profile cases bring so much attention to these kinds of injustices, and dirty cops were not invented by Karen Reed's case. These guys that are pulling these shenanigans in these cases, it's not their first rodeo. It's not their first rodeo. And the vast majority of when that's happening and who it's affecting, it's just slides under the radar because it's cases people aren't paying attention to. And so I want to find a way to get back and focus on that day-to-day justice a little bit. I've been thinking about that. So, no ideas. I'm not retiring, guys. Don't worry. Not like making an announcement. Just talking about out loud about some of the things I've been thinking about doing. So, Brian Koberger next on the docket. After that, we'll see. We'll see. So, with that, guys, I'm going to call it a day. We're going to go ahead and wrap it up. Thank you again, all of you, for being here. Look forward to being back tomorrow. We're at the end once again, and it's been quite a journey. So thanks all of you for being here with me. Really adds to the experience, and that whole feeling of not being alone. Very important. Very important that we're all seeing this. We are not alone, guys. You're not crazy. You're not wrong. You're not alone. 6:45 Pacific tomorrow. Jury conference. I will be here, guys. Hope to see you there. Have a wonderful evening, and I will see y'all soon.